for you that I'm not in this. It's lucky for you that I'm not in the same room as you, because I've got a bad cold. At least you won't catch anything off me this morning. But I hope you will catch some very useful information from our speakers. We've got a very full and interesting program, I think. And just a couple of remarks about how we're going to proceed. Now, each speaker has got a slot, which you can see in your program. And if you have any questions for the speaker that arise during the talk, you can put them in the chat box, and the speaker will endeavor to answer that question either in the course of the talk or at the end. We may be a bit short of time at the end of each of the talks, so there may be limited opportunity to answer all the questions. But for those speakers who will be on the panel this afternoon, that's the one at 3:20. You can ask that question then, if it hasn't already been answered. Now, unfortunately, our first speaker, Kezia Tobin, won't be able to stay for the panel talk this afternoon. And if she can't answer your questions this morning, she'll try and answer them later. So hopefully you will get the reply in due course. Well, that's probably enough from me. We've got 2 speakers on before our first morning break at 11:10. And as I say, we're starting with Kezia Tobin, who's speaking on something very topical, EU law and Brexit, and what's happening to the EU settlement scheme. So, Kezia, over to you.
Thanks, Richard, and good morning, everyone. Thanks very much for logging in bright and early on a Monday morning and joining us for some exciting updates to immigration law. Is it ever boring, hey? I'm just going to try and share my screen with you now. Hopefully this works. Now, what I've realized is that unfortunately the slides that you've got are a slightly incorrect version of my webinar slide. So what I should have done is sent you the version that I'm going to be presenting now. What I'll do is I'll send them over to Hasan so that the correct ones can be circulated. There's only a few minor differences. I'm here today, this morning, in 2 capacities. I've got 2 different hats on. I'm a barrister at Goldsmiths Chambers, part of the immigration team there, alongside Sarah and Samina, who are our joint team heads, who are presenting later on today. But as of last week, I'm also here. I've also taken on the role of head of policy and advocacy at the organisation called the 3 Million, which works to advocate and lobby for the better protection of EU citizens' rights in the UK post-Brexit, taking its name, the 3 million, from the estimated 3 million European nationals that live here in the UK. So this is sort of my first public announcement of my new role, but I would like to emphasise that I'm still very much a member of the Goldsmith team as well, and I'm still taking instructions for court hearings. It's just that my diary is now a little bit more varied and split between the work that I'll be doing at the bar and the sort of policy work that I'll be doing at the 3 Million. So today, in this 50-minute session that we've got, I will just take you through a little bit of an overview of the EU settlement scheme so far. I know it's something that most of you, if not all of you, will have come into fairly frequent contact with, but I don't think it ever hurts to step back and do a bit of a recap. I'm then going to go through some of the case law that relates to settlement scheme applications. Some of them you'll be very familiar with, at least in terms of the name, and some others possibly less so. After we've looked at a few pieces of recent case law, we'll go on to look at some practical considerations for you when you're going about making EUSS applications or challenging refusals of them. And then I'll go and look into some other issues that you might want to be on the lookout for, and that your clients or future clients might come to you having encountered problems with. And then at the very end, I'll talk to you a little bit more about what the 3 million does, and how it might be that, that your work could feed into the broader policy work that the 3 million does. So in terms of an overview of the EU settlement scheme, now the EU settlement scheme opened for applications initially in August 2018, and that was just to a limited cohort at that time of NHS workers. And then it was rolled out across the board in March 2019. And since that point, since August 2018, there have been over 7 million applications. And that doesn't, of course, mean that there are 7 million Europeans in the UK, as the name of the 3 million suggests. Those 7 million applications also include repeat applications, and of course they also include applications for the third country national family members of EU citizens. And to date, roughly 50% of applicants under the scheme have been granted settled status, 39% have been granted pre-settled status, and 11% have received other outcomes, which generally means they've either been void applications, or they've been withdrawn, or they've been refused. And there's a spike in decisions in that latter category that is increasing as time goes on. As at the end of last year, there were 181,000 applications still outstanding, roughly. And what we've found is that the length of time that applications are taking to be decided is on the rise, and as are refusals. So at the moment, refusal rates are roughly 60%. And that probably is because a lot of the applications that are pending now relate to late applications after the cut-off period of the 30th of June, the grace period, 2021. And it might also be that other applications that were made prior to that haven't yet been decided are more complicated cases, possibly where there's a history of criminality, things like that. Now, in terms of the cut-off date for residence rights for EU nationals in the UK, I'm sure most of you know this, possibly all of you know this, the cut-off date was the 31st of December 2020. So in order to secure rights under the settlement scheme, EU nationals had to be resident in the UK by the 31st of December 2020. And so did their extended family members seeking to rely on their rights. But of course, the deadline for making applications under the settlement scheme was not that date. There was a grace period introduced, which meant that applications could be made any time up until the 30th of June 2021. The scheme, as I'm sure you're aware, didn't entirely end then either, though, because late applications are still being accepted. And again, those late applications have to be for people who were resident in the UK still by the cut-off date of the 31st of December 2020, unless they're joining family members. There's separate provisions that apply to those sorts of applicants. The guidance that's in the settlement scheme guidance on the Home Office website that's dated the 9th of November 2020 is quite helpful in that it has a fairly extensive section on what the Home Office considered to be reasonable grounds for having made a late application. It starts on page 33, but it's fairly extensive, and it's relatively comprehensive because, of course, the Home Office's approach to these applications, as set out under the withdrawal agreement, is to take a fairly open-minded approach, and the Secretary of State is supposed to be looking to grant applications rather than to refuse. And to that end, it's perhaps worth recalling that the team within the Home Office that's dealing with settlement scheme applications is a distinct unit of about 1,500 members of staff, and they were all recruited purely to deal with EU settlement scheme cases. And yet, despite the fact that the emphasis has been on making the process a smooth one, a relatively straightforward one to apply under, and one that has sought to grant leave rather than to refuse it, we are seeing an increasing number of people who've had issues in making their applications and demonstrating their ability to claim rights under the withdrawal agreement, and also a higher number of refusals facing people at the moment. So those bits of the guidance that relate to reasonable grounds for late applications might also be relevant for family members who have come in post the end of the grace period, but who might still be able to make applications. So if you've got a case like that, I'd urge you to turn to the guidance and to look into what constitutes reasonable grounds for making a late application, because you can use that then to formulate your cover letter when setting out your client's reasons for not having applied before the end of June 2021. Of course, there is no such deadline for people applying from abroad. When I say people, I mean family members, immediate family members, as long as the relationship with the EU sponsor predated the end of December 2020, and that EU sponsor was in the UK themselves before the 31st of December 2020. In those circumstances, their immediate family members are still able, even at this point, to make an application for family permits to come in from abroad. It's worth noting that there are issues for people travelling. We'll come on to this a bit later as well. And it's no longer really possible for people from European states to come into the UK just using their national ID cards, unless they have pre-settled status or settled status, or an outstanding application that's been acknowledged, to which they've received a certificate of application, or if they're a frontier worker visa, which means they're frequently in the UK for work, but they're not technically resident in the UK. But in terms of the ease with which people are able to travel in and out of the UK without their passports now, things have become a lot more complicated, and I would urge you to encourage your clients to be very cautious about doing that, because they may find that they have issues at the border. Right, so turning to some of the case law updates. The first two cases are ones that you'll be very familiar with, at least by name, but I'm going to talk you through them anyway. And the first one is Batul. And Batul is an upper tribunal case that related to other family members, also known as extended family members, applying to enter the UK and claim rights under the EU settlement scheme. Now, it might help just to have a quick reminder of what the definition of extended family members is, as compared to the definition of family members. A family member is essentially a spouse or civil partner, or any child of the sponsor under the age of 21, or a dependent child who's over the age of 21, or dependent parents. And dependent parents can also include parents-in-law if they're the parents of the spouse of the EU national sponsor. And so extended family members basically means everyone else. All other extended relatives, aunts, uncles, cousins, and so on, who were dependent on the EU national sponsor or their spouse, or who were a member of the EU national's household. So in this case, the appellants in Batul there were four of them, four appellants, and they were the nieces and nephews, minors, of an EU national sponsor who was their aunt through marriage. She was married to their uncle by blood. And the children made an application for entry into the UK alongside the application for their grandparents, and their grandparents were granted family permits and were able to travel into the UK, because of course they were not extended family members, they were the immediate family members of the EU national sponsor. They were the parents-in-law. So the grandparents were granted entry clearance, and the four appellants in Batul were not. And what they argued was that even though they hadn't applied for a residence permit under the EEA regulations, their application should have been treated as though they had. And they argued that even though the application hadn't been one under the regulations, the fact that they'd applied under the EU settlement scheme ought to have been interpreted as they're making an application under the regulations. And the court roundly rejected that argument. The court found that, in fact, the only people who were able to rely on the withdrawal agreement and obtain rights under the withdrawal agreement were people who had applied, whose entry into the UK and whose residence in the UK had been facilitated by the 31st of December 2020. And when they use the word facilitated, what that means is that they have to have made applications under EU free movement law, which basically means under the EEA regulations 2016 or previous versions of it, the 2006 regulations as well. The court found that applying under Appendix EU, which is the settlement scheme, didn't equate. And the appellants tried to argue that they had rights that needed to be considered also by the applicability of the EU Charter, were rejected. Those arguments were rejected as well. The court found that the EU Charter had no bearing on their ability to benefit from the withdrawal agreement, and so the appeal failed. Now, unfortunately, we've found out that last month, permission to appeal by the Court of Appeal was refused, or to the Court of Appeal. Anyway, the permission's been refused, and so sadly it seems as though that might at this point be the end of the line for people who are extended family members who failed to make an in-time application under the EEA regulations. But of course, there's a small category of extended family members who are viewed in a different light, and it's those particular sorts of applicants who tried to argue their case through CHELIC. CHELIC. We've all had a lot of engagement with cases where this is an issue, I think. CHELIC was an appeal in which similar arguments were mounted, but from a very specific perspective of durable partners who were unable to marry and become direct family members, spouses, by the 31st of December 2020, purely because of the COVID lockdown restrictions, which meant that wedding ceremonies weren't taking place in the run-up to that 31st of December 2020 deadline. Now, the courts, the first tier and the upper tribunal, have been very busy with cases on a CHELIC footing in the last few months. But I think it's also helpful to bear in mind that in reality, this is a small cohort of people in the grand scheme of the population. It's just people, the case just relates to people who were unable to marry, essentially in December 2020 when the lockdown kicked in. So it's, in relative terms, it's a fairly small cohort of people. Now, the appellant in CHELIC, Mr. CHELIC, he was a Turkish national, or he is a Turkish national, and he had a Romanian partner. And he was in the UK before the 31st of December 2020. And he intended to marry and tried to book a wedding prior to the 31st of December 2020 and wasn't able to because of the lockdown restrictions. They tried to argue that proportionality arguments could be exercised to find in his favour. But the court found that unmarried partners were entirely outside the personal scope of the withdrawal agreement. And for that reason, they found that the proportionality requirement set out in Article 18(1)(r) of the withdrawal agreement didn't relate or couldn't be of benefit to someone who was entirely without personal scope in any event. So it was argued that the withdrawal agreement had direct applicability, and it was in that way that the appellant was trying to argue that he could benefit from it. But the court wasn't satisfied with those arguments. Another argument that was run, and that I know has been run repeatedly following Çelik by those seeking to argue Çelik-esque ways of trying to get their clients' cases through, was to argue that in fact refusing these sorts of applications has a direct impact not only on the appellants themselves, but of course on their sponsors, their partners, in many cases after the lockdowns were lifted, who became spouses, and that in fact the proportionality of the impact of this refusal on those EU nationals who are within personal scope of the withdrawal agreement ought to be considered as well. And that's something that is going to be looked at, because thankfully, in relation to this case, permission has been granted by the Court of Appeal. That was granted, a decision came out in January, and it's anticipated that the Court of Appeal will hear the appeal in Çelik fairly soon. It's going to be relatively fastly processed, and it's anticipated that it'll be just after Easter that the court hears the matter. Now, what does that mean in terms of what you should do with your cases that are pending and that come before the courts in the meantime? Well, until permission was granted, for the most part, possibly entirely, the First Tribunal and Upper Tribunal were really reluctant to adjourn. So applications to adjourn pending the decision in Çelik were routinely kicked out, and judges were intent on proceeding on the basis that until permission had been decided, Çelik remained good law and was straightforward enough to apply. But the position that the tribunals have taken in the aftermath of the grant of permission has been quite different. So I've seen in my own cases and anecdotally from other practitioners that the courts are much more inclined to adjourn cases both in the first tier and in the upper tier until the appeal in Çelik is heard. And so if you have cases coming up, what I would urge is that you apply to adjourn on that basis, and preferably before the hearing comes to court. For those of your clients who are privately paying, of course, that would save them significant fees in having to send representation to court. And it seems that the tribunal's attitude is fairly uniform on this, so it might be a fairly straightforward adjournment application that you're able to make. So turning now to another case, the case of Siddiqa. This is a very recent case. It just came out, I'm not quite sure when it was now, but in the last couple of weeks, I think. This was a case that sought to revisit some of the issues that the appellants in Batul raised, which related to someone who had made a mistaken application under the EUSS when in fact the correct application for her was one under the EEA regulations. So Miss Siddiqa is a Pakistani national. She was applying from Pakistan to join her brother in the UK, who's a Portuguese national and who was in the UK with pre-settled status, I think it was. Certainly he had leave under the EU settlement scheme. And she made the online application, and it's a drop-down tick box. She ticked to make the application under the EU settlement scheme. Her argument was that in fact what she had meant to do was to tick the box that said it was an application under the EEA regulations 2016. The court found that there was no evidence before them that that was the case. There was no evidence before them to suggest that in fact what had been intended was an EEA regs application, and they said she therefore couldn't benefit from any of the rights under the withdrawal agreement, and that was the end of the matter for her. It's quite a harsh decision, particularly when you consider the unreported case that I've quoted there of Ahmed and others. That's not a reported decision, but it's one that was referenced in this reported decision of Siddiqa. And in the Ahmed case, the court had found, on the contrary, that someone had made an EU settlement scheme application when in fact what they ought to have done is made an EEA regs application. But the tribunal in that case was satisfied that the entry clearance officer ought to have considered the application under the EEA regulations instead, because in the cover letter for the Ahmed appellant, the applicant had made reference to the intention that it be considered under the EEA regulations. So the tribunal, the upper tribunal in Siddiqa, looked at that and found that that was a different sort of circumstance to Miss Siddiqa's case, because it was clear to the entry clearance officer that there had been an intention to make an application under the regs, even though in fact the one that had been made was under the settlement scheme. And so it's a subtle difference. Now what the tribunal in Siddiqa did that went further than the tribunal had gone on this point in the decision in Ratul was they had looked at the wording of Article 18.10 of the withdrawal agreement, and that's the clause that says that the Secretary of State should give an applicant an opportunity to correct errors and to furnish further evidence if there have been omissions. In Siddiqa, the court looked at that and they considered that in fact that Article 18.10 ought to be construed narrowly, so as to only mean that the Secretary of State needs to invite amendments to errors that relate specifically to the application that's been made. So it doesn't include references to an error as substantial as having made the wrong application in the first place. Now, this case could be quite helpful, particularly because we've got the unreported case of Ahmed that's been referred to in it. So if you're dealing with an applicant or a client who's facing an appeal where they've made an application for settlement, for leave under the EU settlement scheme, when in fact the right one was the EEA regulations, what's really important is that you go through the application with a fine-tooth comb and see if there's any reference in the submissions that have been made to the application being under the EEA regulations, because if there is, then you might be able to try and distinguish Siddiqa and say, in fact, our case, your case is more closely aligned to the situation in Ahmed. So in these sorts of cases, it's really important to be able to go back through all of the paperwork and the paper trail and see if there's any way in which the entry clearance officer was alerted to the fact that the EEA regulations was what your client was hoping to rely on. And to that end, this is a case that might also be of help. It's another unreported one. I'm sure you might have seen it being tweeted about or commented about in immigration law circles, because it created a bit of a giggle. It's a case in which the appellant, who's actually the respondent in this appeal, was represented by another one of our colleagues from Goldsmith Chambers, Jamila Hasan, who was supposed to be here this morning, but unfortunately is no longer able to present her session, but who many of you might have encountered in AstenJ's trainings in the past. And in this case, the upper tribunal essentially threw their hands up and said, we can't make head nor tail of what is intended by the Appendix EU. And essentially, it was a case in which the Secretary of State was alleging that the first tier tribunal judge had misinterpreted the wording and the meaning of the application under Appendix EU. But the Secretary of State in their written submissions and in court was not able to explain clearly to the upper tribunal panel exactly why it was that they were saying the judge's interpretation was wrong. And the judge, the panel in the upper tribunal concluded on that basis that if the Home Office, if the Secretary of State themselves, if the Secretary of State's officials themselves are not able to set out why it is that the wording isn't sufficiently clear, then it cannot be said that the first tribunal judge was wrong in the way they interpreted the rules. So the reason that I flag this up here is because it might be quite helpful, particularly when you're looking at applications where there's a fine balance to be struck between whether or not, particularly a lay applicant applying without legal advice, should have been expected to do something differently in their application. It might be helpful to just quote the upper tribunal from this unreported determination as a way of highlighting how completely impenetrable Appendix EU is. I mean, it's fairly impenetrable for Home Office officials and for us as immigration lawyers, so even more so for those who are trying to grapple with these things without legal representation. Okay, how are we doing for time? All right. Another case that might be relevant to your European clients, it doesn't relate specifically to the settlement scheme, but it's a case called Rurig from the High Court from earlier this year. And it's a case in which the High Court found that an individual who was born in the UK prior to the 2nd of October 2000 to EU citizens exercising treaty rights here may in fact not have obtained British nationality when they thought they had. So the impact of this case is potentially fairly vast. The appellant in the case was born in late October, actually after the 2nd of October. He was born in late October 2000 in the UK, and his mother was French, and she'd been living and working in the UK since 1995. So you do the maths, 1995 to 2000. Essentially, she'd been in the UK exercising treaty rights for more than 5 years. What she hadn't done is she hadn't applied for indefinite leave to remain. And that was where the court found there to be some difficulty. So from 2006 until 2020, the EU Citizens Directive was in force. And that meant that EU nationals who were exercising their treaty rights automatically acquired settlement, indefinite leave to remain, after having done so for 5 years. But prior to 2006, the Citizens Directive wasn't in place, and in fact there were different provisions. And specifically in this case, the court found that until the initial introduction of immigration EEA regulations in 2000, which set aside the direct effect of EU law, the provision in place was the Immigration European EEA Order of 1994. And the judge in this case found that under those provisions, the Home Office's interpretation of European law during this period, by the way, has been inconsistent. But the judge found that this domestic secondary legislation that we had in the UK at that point didn't have any provision that ensured that citizens' rights were protected to such an extent that an EU citizen exercising treaty rights had an unrestricted right to remain in the UK, effectively settlement. So effectively, the judge ignored the fact that EU law had direct effect during that period and just focused on the domestic legislation. So he went on to find that, in fact, residence as an EU citizen in the UK prior to the 2nd of October 2000 was conditional, and it was conditional on that person exercising their treaty rights. And as a result, it didn't equate to being settled, and therefore any children that were born to those EU citizens during that period didn't automatically acquire British citizenship. Now, this decision doesn't affect those born in the UK prior to January 1983, when the British Nationality Act came into force, because prior to 1983, if someone was born in the UK, they automatically acquired British nationality at birth. So it's for those born after January 1983 and up until the 2nd of October 2000. And then it's likely that there will be lots of European nationals or children of European nationals born in the UK during that time that have obtained British nationality, have obtained British passports. And so query whether the Home Office are now going to try and seek to withdraw citizenship from those people, cancel their passports, that seems highly unlikely. But the impact is quite clearly vast, and it creates a potential potentially sort of Windrush-esque impact for a lot of people. So there's no word yet, as far as I know, about whether or not the decision is going to be appealed, but I would expect that it will be, and it's one to watch, because it could be that you've encountered clients that are quite severely affected by it. So a bit, sorry if that was a little bit convoluted. It's not an easy area. It's looking at EU law and nationality law, two notoriously straightforward issues. Hey. Just before I come on actually to practical considerations, there's one other case that I just wanted to flag that I haven't included in the slides, and that's because it relates actually to appeals under the regulations themselves rather than Appendix EU, and that's the case of Elias, E-L-A-I-S, in the upper tribunal. I've realised I've not written the citation down for it, so my apologies for that, but the name is E-L-A-I-S, Elias. The appellant in that case was also represented by another couple of colleagues of ours in Goldsmith Chambers. It was Paul Richardson in the upper tier, and it had been the appellant had been represented at first instance by Sanaz Saifullah. In that case, the appellant had made an application under the EEA regulations before the relevant cut-off date of the 31st of December 2020, unlike the appellant in Chelik, on the basis of his being in a durable relationship with his EEA national partner. But that application was refused after the 31st of December 2020 because the Home Office didn't accept that he was in a durable relationship. As with many of the Chelik style appellants, the couple had gone on to marry after the lockdown restrictions had ended, and indeed before his appeal came before the first tier tribunal. And so what the court looked at in Elias was whether or not the marriage between the couple constituted a new matter. And the court found that it didn't, because it couldn't relate to a new ground of appeal. But what it was useful for was, what the marriage was useful for was to demonstrate the durability of the relationship. So it's a good one to have in mind, because if you've got an EEA regs appeal outstanding where that's an issue and they've gone on to marry, you can safely rely on the marriage as evidence of what was previously a durable relationship, and the appellant went on to win his appeal. Okay. So looking at practical considerations, which actually relates to what I've just said about Elias as well. Something to consider is what appeal rights your client has in EUSS appeals. There are lots of different regulations that have been drafted, and you'll have to be very careful to look at which ones apply, and that will depend often on when your client lodged their application. And unfortunately, there's a lot of cross-referencing that needs to be done between the different regulations that were introduced at different points. But as a general rule, applications that were lodged after Brexit, which is after the 31st of January 2020, attract a statutory right of appeal. That's applications under the EUSS. Whereas those that were made before the actual Brexit date didn't. They only attracted a right of administrative review. Now, it's unlikely that you'll have many cases which were made before the Brexit date itself that haven't already been decided. But what's important to bear in mind is that even for more recent applications, your clients will have access to both an appeal right and the right to seek administrative review. Applying for administrative review costs £80 and is appropriate if you're looking not at arguing that the decision is in breach of the withdrawal agreement, but if you're simply challenging the decision as it was sort of on the facts. So if, for example, your client was not asked to provide further information or to evidence a relationship, let's say they forgot to include a copy of their marriage certificate, you can apply for administrative review and include the marriage certificate at that point. And what's helpful is, of course, that you can still exercise the right to appeal after having sought administrative review. You can actually do both in parallel as well. But if your client wants to seek administrative review first, it doesn't preclude them from then exercising their right of appeal further down the line. So it's a helpful thing to bear in mind. Also, in terms of appeal issues, something that has been considered, actually looked at in Chelik or in Batul. I mix them up a little bit sometimes. I think it was considered in Chelik, is whether or not human rights arguments can be argued in the context of these EUSS applications. Because the rights of appeal in EUSS cases, on the face of it, appear to be fairly narrow. You can argue either, firstly, a ground of appeal that the decision is in breach of the withdrawal agreement, or secondly, that the decision is in breach of the rules which relate to the application under which it was made, which basically means in breach of Appendix EU and its associated guidance. But Regulation 9 of the regulations under which the appeal would be lodged also confirms that if other issues are raised through a Section 120 notice, they can be considered. So it's important that you look out for whether a Section 120 notice is given, but what you need to bear in mind is that even though that might be a route into considering human rights arguments, they will still constitute a new matter, and that means that the Home Office will have to consent to the tribunal considering them. And to my knowledge, that's not something they ever do. So in these sorts of cases, although technically speaking, you might be able to raise other arguments about human rights, or indeed the application of other immigration rules, in practice, it's unlikely that the tribunal will be able to go on and consider them substantively, because the Home Office is unlikely to give their consent to them being considered. Of course, there might be exceptions to that. This is just a kind of general law, general way that things have been progressing. So some issues that you might want to look out for. When somebody makes an application under the EU settlement scheme, what they should receive is a certificate of application that's issued immediately. Article 18(1)(b) of the withdrawal agreement stipulates that it ought to be immediate. And what we found is that, in fact, the Secretary of State routinely does not issue certificates of application immediately, because they go and conduct background checks prior to issuing those certificates. Now, the Secretary of State maintains that that's done on the process, on the basis of trying to sift out fraudulent applications or spurious ones, but the failure to issue certificates immediately actually puts the Secretary of State in breach of her obligations under the withdrawal agreement. And the implications of that for your clients can be quite severe, because without a certificate of application, they're not able to evidence that they have a right to work in the UK. They're not able to access housing or benefits, and significantly also it means that they might be prevented from accessing NHS treatment without charge. So they're entitled to all of those things. Their rights, an applicant's rights under the withdrawal agreement, are protected while the application is being decided, once they've got that certificate of application, but not before. The 3 Million has done a lot of engaging with the Home Office on this, and there's a whole paper train of correspondence back and forth on it at the hyperlink that I've included there. So I'd urge that you go and consider having a look through that. I'll just say as an aside now, I can say this without claiming any credit for it, because I've only just joined the organisation, but the 3 Million is actually a really useful website. It's got a vast number of resources, and a lot of all its correspondence with the Home Office on various issues affecting EU citizens' rights is all put there and published transparently, and it's a very helpful resource, particularly when you're looking at fairly complex issues and cases that sort of seem to fall through the cracks. And on this issue, the delays to the issuing of certificates of application, the Independent Monitoring Authority has actually launched an inquiry That was last year in 2022, but the results of it haven't been published yet. It's maybe worth just highlighting what the IMA actually is. The Independent Monitoring Authority was set up as part of the withdrawal agreement. It's sort of the baby of the withdrawal agreement, and it's a sort of a government body that's been set up to have oversight of the Home Office's implementation of the withdrawal agreement, with a focus specifically on the protection of citizens' rights. So it's there as a kind of as a monitoring body, obviously monitoring authority, it's in the name, to hold the government to account. Now there might be some questions about its independence because it is still a government body, but you'll have seen them in the news fairly recently, I think, because of the JR in which they took the Home Office to court over the legality of the settlement scheme as a whole, and I'm going to touch on that in the last couple of minutes before we end. Some other issues that you might want to look out for, again, delays. I mean, we've touched on that already. It also is relevant in terms of your client's abilities to travel. So in general, if somebody has made an application and it was an in-time one before the end of the grace period, 30th of June 2021, and that person was resident before the date of the 31st of December 2020, and they've already received their certificate of application confirming that their application is being considered, then technically they are able to travel with just that certificate of application as proof. But I would really urge that you advise your clients to be cautious about this, because airline carriers and immigration officials in other states may be unfamiliar with that, and it's possible that people would be refused boarding onto aeroplanes without clearer evidence of their entitlement to reside in the UK. With travel generally, I would urge huge caution, and again, the 3 million's got some very useful, helpful guidance on that. Another issue that we're seeing at the moment a lot of is that the Home Office is not seemingly doing what it's set out that it ought to do under Article 1810 of the withdrawal agreement, which we've already talked about with in the case of Sadiqa. That was what the tribunal looked at, that the Home Office rather is supposed to give opportunities to applicants to prove to provide evidence to fill the gaps in their applications. But in fact, what we're seeing and seeing increasingly is that doesn't happen. And the Home Office sometimes say that they've been trying to make contact and were unsuccessful, when in fact the evidence that the 3 million has received is that often there's no indication that contact attempts have been made at all. So that's something you might want to look out for, and it goes to the importance of making sure that the applications are prepared thoroughly without any missing documentation from the very outset. There's also now a truncated process in the Home Office has set out in their guidance that allows for fewer opportunities to contact applicants if there is a suspicion that there's been some fraudulent element to the application. So there's going to be even fewer attempts to clarify matters, and that's no doubt one of the issues that's leading to the rise in refusals that we're seeing. We also consider at the 3 million that there are real problems with the fact that the status that people have been granted under the EUSS is digital only. Now, for most people, once the initial teething issues were dealt with in 2019, the use of the app is fairly straightforward and streamlined compared to other immigration applications. But of course, there are people for whom it has been really quite problematic, and that includes the elderly who are IT illiterate, homeless people, others who don't have immediate access to smartphones, or who live in areas where there's poor internet connection even. This has caused real difficulties for people working, particularly in the gig economy, who might be there with other potential job applicants who have to prove their right to work. And of course, the View and Prove system requires that they log on to the website, they receive a share code, they provide the share code to the prospective employer or prospective landlord, who then also has to go into the Home Office website and enter the share code in order to see confirmation that the person has the right to work in the UK. And what we've seen is that many European citizens have been bypassed in favour of applicants for whom that process is more simple. So either British citizens or indeed other third country nationals who simply have the vignette or BRP to show that they have the right to work in the UK. And so that's something that the 3 million is looking to, is lobbying the government on at the moment. I've put in there another issue with BRPs that actually doesn't relate just to EU clients, but to others across the board. Because the UK and in fact many countries across the world are moving to an increasingly digitalized immigration system, BRPs are going to be phased out by the end of 2024. So you might have clients who've got leave beyond that, but whose BRP cards expire at the end of December 2024, and they might need reassuring that doesn't mean that that's when their leave expires. And there'll be guidance published later on, either this year or next, about what happens after the end of December 2024. I'm conscious that we're more or less running out of time. I'll just rush through the last couple of bits. It's always a rush at the end, no matter how well you think you've timed these presentations. That's true for me anyway. So the other thing that I wanted to flag was that you might find you have contact in 2024, so looking kind of in the longer view now, from European clients when they're abroad, because the UK is moving towards this electronic travel authorization, ETA scheme, which is similar to a scheme that's being rolled out across Europe at the moment, across the EU as well, and which is similar to the US's ESTA system. Those of you who've been to the US might have had to apply for an ESTA. And it's an authorization certificate for non-visa nationals that you go on and you apply, and you can't travel without one, even though it's not a visa. And the Home Office is rolling it out on the basis, or the reason that's being given is that it adds tighter security, that it's a security measure. But what we anticipate is that your European citizens who are in a different position to other non-visa nationals, in that they won't be required to obtain an ETA, and yet we anticipate that at the point of check-in at an airline counter, often those airline officials will be unaware of the fact that EU citizens with leave under the settlement scheme are not required to have an ETA. And again, this issue of having to require those individuals to then go on and log into the gov.uk website with a share code is, I suspect, asking too much. Many airlines or many airports probably have restrictions on their staff that would prevent them from accessing external websites at that point. And we just anticipate that a lot of European citizen clients of ours might find themselves facing difficulties on re-entry to the UK once the ETA has been rolled out. Again, that's the subject of one of the 3 Million's reports to the IMA last year. So please take a look at it there, along with the other reports. There are 5 of them in total that the 3 Million has made to the IMA. And I just, as a final thing on there, just wanted to point out that difficulties that your clients facing in deportation, but especially extradition, might face. Because of course, if somebody's being extradited to face trial abroad and they only have pre-settled status, if they're absent from the UK for more than 6 months in any 12-month period, they stand to lose their right to remain with pre-settled status and under the withdrawal agreement. And the implications for them, of course, can be fairly drastic, therefore, and not only for them, but also for their family members. And it's important, I would urge, to think about the impact of somebody's removal on the family members, particularly their partners and children, where those family members' right to remain in the UK is actually dependent on that sponsor's own residence in the UK. Those are issues that I'm sure many of you are already having to grapple with. Okay, very last thing, 3 minutes to go. Extending from pre-settled status to settled status was the issue that was the focus of the IMA-JR against the Home Office, in which the European Commission and the 3 Million acted as interveners. It's the case that was in the news recently. Last week, the Home Office confirmed they weren't going to seek to appeal the decision. And in the decision, the court found that the EU settlement scheme was unlawful in that it breaches the withdrawal agreement by failing to properly protect citizens' rights. And it fails to properly protect citizens' rights by requiring that applicants with pre-settled status make a subsequent application for settled status on completion of their 5 years residency with pre-settled. And they said it was important that those with pre-settled status don't lose their entitlements under the withdrawal agreement and don't become overstayers simply because they haven't made an application under settled status. So it remains to be seen how the Home Office is going to implement this judgment. But what I would just urge is that in the meantime, you continue to advise your clients to apply for settled status when they've completed 5 years, regardless of the outcome of this JR, because it's not clear yet how effective the implementation of it will be. And we want to minimize potential issues for clients as much as possible. So despite this judgment, which is of course hugely welcome and to be celebrated, I would urge that your clients continue to apply for settled status when they reach the end of 5 years. So the first ones with pre-settled status will be eligible for extensions into settled status will be August 2023, that NHS cohort that were the initial trial rollout of the settlement scheme back in August 2018. Okay, I think I'm more or less done. I've got 1 minute to go. I just want to highlight the work that the 3 Million does, because it's a very small organisation that packs a strong punch. It does a lot of research, thorough research-based lobbying and advocacy work in Westminster. It works closely with partners in the EU on an institutional level and beyond. It's been involved in some key strategic litigation, not least the IMA judgment that I've just referred to. They also were involved in the Court of Appeal decision from 2021 regarding the immigration exemption in data protection law. The court found that the interpretation was too broad and that it was therefore unlawful. They've also been instrumental in advocating for the removal of the fee for EUSS applications quite a while ago. So they do quite a lot of lobbying and litigation, and also work with community groups around the UK to ensure that citizens are aware of their rights, and also that their experiences feed into the strategic work, which is where you come in. I would really urge that you contact us or get your clients to contact us if you are facing repeated issues, systemic issues and problems that your clients are facing. We really would like to hear from you, because it's information like that gives the 3 Million its direction. So there's a tool there, a report it tool, that your clients can use directly to contact us, or that you can use to contact us on their behalf. But I've also got my email address at the end of these slides, and I'd really encourage you to get in touch with me directly as well if you've got issues that you think are worth us taking forward as an organisation. Yeah, there we go. So yeah, with all those sorts of things, policy and kind of broader approach issues, please go and you contact me at the 3 Million. If you've got a specific case question and you'd like legal advice, then please contact me through Goldsmith Chambers. I've taken my clerk Neil Dinsdale's email address off there in error, but I know that his details are at the ends of the slides that Sarah and Samina have prepared. So please do continue to contact him if you're looking for instruction. I think on the copy of the slides you've got, there is a full list of useful resources. That's still valid, but I realised that what I thought were hyperlinks actually haven't worked. So it's, I'm afraid, just a list of resources, and you'll have to go through and look for them yourselves, which is why I took them out of this one, because I didn't have time to go and put all the hyperlinks in. But anyway, I'm conscious of the fact that there are some questions in the chat box. I think, as I've indicated earlier, I won't be able to answer those now, unfortunately, because I'm out of time. But what I will do is make a note of them, and I will seek to come back to you on that. It's possible also that my colleagues and the other presenters today might be able to help you with those questions in the kind of panel discussion at the end of today. But otherwise, I'll try and come back to you with any comments that I might have or answers that I might have on the questions in the chat. Thank you. Well, thanks very much for sticking with me. Thanks.
Well, Kezia, thank you very much for that very interesting talk. There was an awful lot to pack in. Yes. And we are now running over time, but we always do. So our next speaker is our regular speaker, Samina Iqbal, and she's going to be talking about JR applications in immigration cases. Another very useful talk, I'm sure. Now, if we end her talk on time, which is 10 past 11, I'm sure she won't be able to finish by 10 past 11. So if you'll bear with us, we will go on for longer with Samina's talk. And do you think you could manage it by 20 past 11, Samina?
I am marking that on my clock now, so hopefully.
All right, thank you very much. So without any further ado, I'll hand over to, as I say, one of our favorite regular speakers at these webinars, Samina Iqbal.
Thank you. I'm just trying to check if I'm sharing my screen okay. I always have this problem, so I'm just going to stop share and try again.
You were.
Okay, great. I'll try again. And I think it's that one. There we go. I just need to go to the top of the slide, so bear with me. And that starts me there. Okay, I'm going to try and move along as well with the slides. There we go. Just sorry, everyone, do bear with me a second. Okay, so I do want to just get back to my slides there. I may not be able to move them, but I will try my best. I'm having some technical glitch, as we normally do. But this is a talk or a webinar essentially about the JR applications in immigration cases. Now, I know that we're all very familiar, or we should all be very familiar with judicial review applications and taking them specifically in the upper tribunal in immigration cases. But I thought it's useful for us to have almost a toolkit, something that we can all refer back to when we're looking at complicated cases, complicated decisions that we want to go back and challenge. And so it's useful to look at these issues essentially from the start. So just my overview here is, and can someone tell me if I've moved the slide okay, if you can all see the next slide?
Yep, that's great.
Okay, good, thank you. So that's the overview there. That's what I want to look at, procedural matters, decisions being challenged that we see on a regular basis, grounds of challenge. I think we almost forget, we're so used to taking challenges automatically, but we forget what we want to look at in terms of specific issues or the specific way in which that decision can be challenged. Also want to look at common immigration challenges at present time, and then some case law which is useful for us to put in our, as I say, toolkit, looking also at other issues at the end of our judicial review hearings, which include consent orders and claiming costs back. You'll all be familiar with judicial review being a remedy of last resort. I've just added this here because it's important to check it's actually the last resort in the decision that you are challenging. And I say this because I've been caught short, or nearly been caught short by this. when the rules suddenly changed, with specifically the short-term student. I'm zeroing in on short-term students because that particular rule changed to include an admin review challenge. There was no admin review challenge against such a decision, but I think it was sometime last year, early last year when the rules changed to allow an admin review. So we had to challenge by way of an admin review before we could go to judicial review. So it's worth always checking your decision, looking back at the rules, looking at the admin review Appendix AR as well, to see specifically with reference to a decision that you might want to challenge, whether it's the last, whether there's any other remedy available to you. And then where to challenge, as I said, I'm going to look specifically at the upper tribunal because we're looking at immigration cases. We have many cases since 2013 which go directly to the upper tribunal, but there are some exceptions, and those exceptions are set out here within this slide. I think if you're going to be looking at any of these exceptions, you need specific specialist advice in relation to these, but it's always worth checking your decision and then checking which court it's going to go or going to be challenged within. Now, I flagged this particular guidance here. It's the statutory guidance practice note, judicial review, case management, because I think it's an important addition to judicial review powers, or I say jurisdiction, for us as practitioners. It's specifically with reference to any OISC advisors who are at level 3. This was introduced in 2017, and it extends, or it adds, particularly for them, allowing them to take further judicial review action beyond the pre-action stages. But to do this work, it's going to be very important to refer back to that statutory guidance, because you need to, as an OIC advisor, to take additional steps to have the remit to be able to take judicial review cases. And the two main points that you can take from this particular guidance is that you have to be authorized by the OISC, but also be permitted by the Bar Standards Board to instruct a barrister to undertake the litigation and advocacy element of a JR through their licensed access scheme. So you have to see if the barrister themselves is also able to conduct litigation. So it's a twofold and slightly difficult but useful way to move forward if you're an OIC advisor who is engaged or wants to be engaged in further litigation within judicial review. I have also highlighted for you art JRs here, and I think again we were caught out slightly by this last year, and you can see I've put that's purposely done, not a mistake, but I've cancelled here, drawn a line through challenges to decisions of the upper tribunal, and I do this because late last year, or mid last year, I think it's July 2022, the Judicial Review, I'm going to give you the full act, it's the Judicial Review and Courts Act 2022 came into force, and it removed the CART jurisdiction by inserting a new provision into the act in relation to judicial reviews. So I think that's a TCEA 2007 Act, if I'm not mistaken. But yes, it removed challenges to the upper tribunal. So that's when permission's been refused by the first tier. If you're challenging a determination refused by the first tier tribunal, it's then refused by the upper tier, and then you take that challenge or the refusal of permission by way of judicial review to the admin court, but that has been removed essentially. There is exceptions, as there always is with guidance that comes out or new rules that come through. There are exceptions to this, and the exceptions include a decision where the upper tribunal has acted in bad faith, or if the decision's procedurally defective in some way, so that it amounts to a fundamental breach of the principles of natural justice. But I would advise you, if if there is a decision where you feel it must go further, seek some advice, look at the specific act and the exceptions, so to see whether or not it's something which can be taken further by way of judicial review, CART JR essentially. Procedure-wise, I think we are looking at the very familiar pre-action protocol. You have a decision you want to challenge, no other remedy, so you seek to do that by way of pre-action. Now there is here, this should be hyperlinked, the specific Home Office, the pre-action protocol that's generally now in use, but it doesn't harm for us to put in more detailed grounds in addition to filling out the very specific form that we now have in place for pre-actions, and front load your client's case. You want to essentially put as much information there as possible, direct them to what they haven't looked at or what needs to be looked at, or where the errors are within their decision. So front load it as much as possible. They will normally respond, and you usually have the time frame of 14 days. Everyone, again, is, I'm sure, very familiar. If their response is a negative one, you'd then prepare your claim and issue and serve with any draft orders or directions that you might be seeking. I've put there the relevant forms, the T485 and the T480, I think it is, which you would look at with reference to the upper tribunal. Sorry, I've jumped a slide there. Now, the Home Office would usually, once you've issued and served your claim, would file an acknowledgement of service alongside summary grounds of resistance, usually within 21 days. It's worth keeping your eye out on this to see whether they are complying with time limits. So if you make sure you have your own timetabling procedures set out so that you can tick box them, but to ensure that they do this, because if they don't, it does have cost sanctions, and I will take you through that when I address you in relation to costs right at the end. But it's worth keeping this in mind in relation to any missed deadlines, and of course that applies to us as well. If we were to miss any deadlines, then that does have essentially some impact on us in relation to costs. So it's worth, again, as I say, just having this in mind. Now, if permission's granted, you have 35 days, or the Home Office, sorry, normally have 35 days to file and serve detailed grounds of resistance. So that's there. If it's reviewed on the papers, which is more of what we do tend to see, then you can renew it orally. You can ask for an oral renewal, again, everyone is more familiar with that process, because I think a lot of the judicial reviews that we see are generally refused on the papers. But I think what we do forget to do is that we have 9 days within which to ask for the renewal. But what you also must do is look at whether or not, when refusing permission, the judge has made an award of costs against the client, so in favour of the Home Office. It's always worth making representations at that stage when you're renewing in relation to those costs, if they're too onerous, or if the AOS is simply a generic AOS, then it's worth putting in something about those costs and flagging at that stage that you challenge those costs when you're renewing. Because if you get to the next stage and you're in court, or you've instructed someone to be in court, and they are at the oral renewal hearing, but the costs haven't been challenged and permissions again refused at an oral renewal hearing, then they won't be able to say much about the cost award at that stage, because you never challenged it in the initial paper stages. So I would advise it's definitely worth marking that in your diaries insofar as later challenges to costs are concerned, even if you're not granted permission. So looking at then the time limits, again, this is something just to flag for yourself. Whilst we all know that 3 months time limit within which we must bring a judicial review, there is always the option to seek an extension of time. Now, this does happen, and it can happen, especially if a decision comes to the notice of an individual much later than expected. That is, it wasn't served to the right place, or it wasn't served in time. There could be a variety of reasons why you might have to seek an extension of time. And just to flag, that's something you need to do at the initial stages when you're serving or you're lodging your judicial review. And as I say, it's always something we need to look out for, because it can impact on costs against us as well. Now, or even bar us from participating, bar us in the first instance in relation to pursuing judicial review, even if merits are good. So, I mean, that has happened on occasion when you are in court and there's no explanation for the delays in bringing the judicial review, or it's not brought promptly. Some of the harsher tribunals may well bar or strike out the judicial review on the issue of time. So keeping that in mind as well. Even if you're within the 3 months time limit, I would, and it's at the very end, it's always worth to put in a line, whilst you're not seeking an extension because it's brought within the 3 months, it's worth putting in a line about why it's brought so late so close to the 3 month time limit. I've again flagged the acknowledgement of service and summary grounds of defence, and I have done that because, as I've already highlighted, that if the respondent or the Home Office have 21 days to serve or to serve this, but if they haven't done this within the 21 days, or they seek an extension, it can affect the costs against them and making costs awards against them, or even barring them from participating in the proceedings at that stage because they were so late in responding, so without any explanation. So it's worth, again, something that you keep an eye on with reference to whether they're actually in time on their time limits as well. I find it useful to mark these things in a calendar. I'm sure we all have our different ways in which we ensure that we're complying with some of the very tight time limits that we see in immigration proceedings. Grounds of challenge. Now, again, it may well sound very basic that we all know what the three main grounds of challenge are, but you receive a PAP and sometimes you receive a decision, and sometimes we look at it and we know that it's wrong, but what we don't do sometimes is identify it by way of the legal terms as to what the actual defects in that decision are. So this is just essentially a reminder of the three main grounds and what comes within those three main grounds of challenge, what to look out for, the terminology, how to actually grapple with the issues in the decision that you are looking at and the pre-action protocol that you're preparing. And as I say, the more that you can put in the pre-action, the better. So in the first ground, we're looking at unlawful, the decision being unlawful, or the illegality of the decision. You're looking at a decision being ultra vires, and the reason for this would be, for example, the DFT, the detained fast track rules. They were seen, there was a challenge brought against those, and they were seen as not fit for purpose. So they were found to be ultra vires, and there was a whole spate of other litigation that followed that. So it's worth looking out for the rules themselves, and to see whether or not there are issues with those rules. But again, that would be if you've identified something, then going on to do the research or getting specialist advice if you're instructing counsel in relation to those issues. And then you have the very basic or the very familiar or regular issues that arise, which are there's been an error of law, a fact or fact. There's been a failure of the decision maker to give adequate reasons, a very basic decision. And they've not considered any of the evidence put in. So you put in a whole load of evidence about exceptional circumstances, but there's nothing to demonstrate that the decision has taken into account any of the factors that you've put forward. The authority, the leading authority for that was the Court of Appeal in Iran. And so that's worth going back to just to check for yourself or recheck those challenges or the relevant issue or how to frame the particular challenge that you want to take. You also have the evidential flexibility or discretion, I should say. There is a use of discretion by public authorities, and if they've not properly applied that discretion, then that's certainly a ground for challenge as well, because that would be them acting unlawfully. And then one of the more popular, I should say, challenges at present, and I think this comes about as a result of the pandemic, but even pre-pandemic, we've seen a whole spate of delays at the outset in decision-making process, delays in issuing what documentation related to a particular successful challenge. And I want to look at that in a much more detail, because that's we've seen an increased trend in relation to delays by the Home Office, the Secretary of State in a vast number of areas within the immigration field. But coming to the second ground here, irrationality, Wednesbury, and reasonableness, everyone is very familiar with the quote here: the decision has to be so outrageous in its defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at that decision. So self-explanatory, and I think we see that on a daily basis with reference to some of the decisions that we do see. But as I say, it's right to focus on or to consider some of the other aspects of the decision if those apply. Which brings me to the issue of procedural impropriety. I have here flagged procedural fairness. Now, this one's been very interesting, and there's been a lot of litigation connected to procedural fairness with reference to applications. And I flagged some of the cases from which we have some very useful nuggets, which I know that I constantly rely on, not only for the purposes of judicial review, but also during the course of normal statutory appeals. But these all relate to, and I just want to just flag the kinds of decisions that were being made here. So Mushtaq was an application of a student, genuineness of his application or him as an applicant was being questioned. The case of Mia was a marriage of convenience, so under the EA regulations. Anjum was a tier 1 case, as was the case of Taj. And the case of Balajigari, I think we're all very familiar with the tax discrepancy cases and the procedures that were followed with reference to the decision making in those kinds of cases. And then Karagul is a case to do with the Ankara agreement. Now, all of these have in common, the issue that they have in common is the genuineness, as I say, of the application or the applicant himself. and they relate to the procedures. So whether someone was being interviewed, whether someone was being asked to fill out certain forms, whether they were being given the opportunity to respond to that. What was the relevant procedure taken to make that decision in their case? And as I say, all of these cases collectively provide very useful guidance in looking at procedural fairness itself, and are worth referring back to when you're looking at a case where you feel the process has not been fairly followed. I've also flagged there the other grounds of bias, where the decision made may have elements of bias, but you've also got a decision where there's a legitimate expectation or a breach of human rights. So those also fall within procedural impropriety. Now, just going into a bit more detail on common immigration challenges, we're all going to be familiar with the decision on an application where it's certified. You'd look towards the guidance in relation to the reasons for the certification and whether or not the correct reasons have been given for certification. You'd also look towards the case law. I haven't set out that here. I think these are just to give us reminders and flags what we need to do when we're looking at these kinds of cases. You've also got a refusal of the Secretary of State to consider a fresh claim. Now, this is in the context of, again, the immigration rules. We need to look at the rules and why the Secretary of State, look at the background behind previous cases or the previous application made, the previous decisions made, and again, looking at the new materials that have been produced. The rules provide quite clearly, as does case law, for challenges that we might, how we might challenge those decisions. You also have trafficking and modern day trafficking decisions by the NRM and refusal of reasonable grounds. And we're going to cover the trafficking and modern slavery a little bit later, but that's just to flag that those are common challenges as well that we regularly see in the courts. And then the most, as I say, increased challenges that we've seen as practitioners is in relation to delay in decision making, and that's decision making in every single layer with the Home Office or with the Secretary of State, and that's what I do want to look at in more detail by way of case law and the different challenges that we've, or the different trends that we've noticed by way of challenge to these decisions. So as I say, what kind of decisions are we looking at? Well, there is the first one, which is a failure to make a decision on an asylum claim or fresh claim. We've seen both. We've seen failures on both. So asylum claims, fresh claims, and different length of delays in those decision makings. What would you look at? The first instance, you would look at the rules, as I say, the immigration rules themselves, particularly at paragraph 3.3a, provide a specific timeline within which a decision should be taken, and that timeline is 6 months. If you go to the gov.uk website, again, 6 months is provided for. There is much case law on this, and I'm going to deal with that in the next slide, which provides further guidance on when you might look at either of these decisions with reference when the delay of over 6 months might be unreasonable. You then got failure to implement successful appeal decisions. I had a case quite recently which was under the regulations, and there was a continued delay of the applicant receiving, or the appellant receiving, any documentation to confirm his rights under the regulations, which would in turn delayed his rights with reference to the EU settlement scheme. And he sought to challenge those delays. And again, there's a very specific guidance known as the implementation guidance, the Home Office guidance, which is quite helpful to look at with reference to when and how a successful appeal decision must be implemented. And the guidance given there is that it should be implemented promptly. And so it's quite wide. It allows for challenges to be taken even if it's a short space of time. So it's not time limited, essentially. If for whatever reason an individual feels it's not being taken promptly, they may bring a challenge to that. And we did take pre-action with reference to a decision within a month of waiting for that challenge. It was conceded within time, but yeah, it's worth looking at that and exploring if there is something untoward as to why they won't implement that decision. And as I say, that guidance will help you or guide you through that. Now, I'm just going to skip the BRP because I'll come to that, but we'll look at a failure to issue a passport. Again, that is something within that the gov.uk website provides us specific time limits within. They say we should allow up to 10 weeks to receive your passport, and there are different turnaround times if you're applying from another country. So it's worth again looking at that to see what the issue might be if it's from another country. But we've seen specific delays given refusal with reference to issuing passports as well, and no specific reason as to what has led to those delays. It may well be, I know we're all going to be very familiar with the deprivation cases, and we know a lot about what's been said with reference to the Begum case. So it's at the forefront, but there may well be some investigations if a passport's being withheld. But that's something that they have to, that's something that they ought to provide information about. And again, I will deal with that in my next slide and the case law, but something to tell you how long they might be and what the delays are about. And of course, we've all seen many delays through the pandemic in relation to decision making, but overall, when you're looking at a case, you've got to see whether or not that overall delay, in spite of the pandemic delays, is reasonable, and it may well be that it's not. And so coming back to this issue of the failure to issue a BRP after a successful claim, now there was a case, Hasan, in 2020, and it certainly missed me by for a while. I hadn't seen the case for a while, but this was a case where Mr. Hasan brought judicial review action, given a delay of 25 months waiting for a biometric residence permit, which would confirm his right to live and work in the United Kingdom. Excuse me. He argued that not only all the unreasonable delay issues, but he additionally argued that there was a breach of his private life as protected by an Article 8 of the ECHR, and therefore he was claiming that he was entitled to compensation because the delay in turn had denied him from the benefit of working. So the BRP, which would have given him the benefits or would have secured his status essentially, and by not having that, he was not allowed to work, or he was being denied permission to work and other benefits. So in the alternative, he also argued that the Home Office had breached duty of care which was owed to him, and he was entitled to compensation as a result of negligence. It's definitely worth having a read of this case if you are contemplating any form of damages as a result of a delay in decision making. This is quite a specific issue with reference to the BRP, because, as I say, he was denied the opportunity to work, and he could show that, I think, by way of, if I'm not mistaken, he had applied, or he'd been denied the opportunity to go back to work. So the damages claim on the breach of his private life was expressly linked to a declaration that the delay in issuing the BRP was had caused him those damages. So you have to look very carefully at how you frame the issue of damages. But this is a remedy worth considering or pursuing. And as I say, I put it in the context of delays, but there may be other areas where you might seek damages, or you want to, we generally do include damages, but it's as a remedy, but it's worth ensuring, if you do, that it specifically highlights how you're going to be looking, or how you seek to claim those damages, or where an individual has why he's entitled to the compensation, where the real issue arises with reference to him not being able to act because of the failure of the Secretary of State or the Home Office. And on that note, I promise to just flag some of the case law for you with reference to delays. These are, and I think MK and FH Iran are the essentially leading cases in relation to the obligations of the Secretary of State to decide an application within a reasonable time. In FH, Justice Collins, he said that it could be a range from between 1 to 5 years, which is not so excessive. So you have to look out for the specific fact of your case and the reasons for the reasons for the delay, which is why I flagged out all the more common cases that we're seeing and where to look for the timelines or the timeframes within which the Secretary of State promises to carry out certain actions, and whether or not then you relying on some of the principles in relation to delay can bring your challenge against the Secretary of State. So coming back to the case of FH and others, that was in relation to in relation to failure to decide an asylum claim. They differentiated very clearly here in this particular case the difference between deciding a fresh claim, which has already been in the system once before, and the delay in deciding an asylum claim, a first-time asylum claim. So there is a difference between that. The priority, of course, is someone who's applied for the very first time for asylum, and whether or not and how long there is with reference to delay in the decision being made. And the things to look out for is when there is a delay and you've chased that delay, let's say even with reference to a fresh claim, whether or not they've provided any information about how long it's likely to be, whether there are any reasons for their delay. And what FH flags is that they should at the very least do that, because if they don't, then that would call as an aggravating factor, which strengthens any claim that you might have, which may not fall within the traditional 1 to 5 years, which is not seen as excessive. The other things to look out for with reference to the facts of your specific case is whether or not there are mental health issues. So again, if you're looking at a fresh claim and the delay in making such a decision, or any claim, whether the delay of the respondent is causing or aggravating any pre-existing mental health conditions, whether or not there's a Section 55 issue. So fact-specific matters combined with delay, and it could be a 1-year delay, could be seen as excessive for the specific facts of your case. So it's worth putting together all the facts of your case against the case law, against the various guidance, depending on which element of the decision making or the layers that you're looking at in the decision making when you seek to challenge a delay in a case. But as I say, these are all worth having as in your toolkit for judicial review delay cases. Essentially, these cases and referring back to them and the principles of them is going to be useful when trying to kind of work out what you want your challenge to be. Other matters, and I'm just checking time, I do have enough time, so other matters to look at is supplementary decisions and rolling reviews. So supplementary decisions, you've started your judicial review proceedings, you're halfway through and the Secretary of State issue another decision. They say, oh, it's just a decision to give you further reasons, or it's just a decision on the evidence that you've provided, which we hadn't looked at. So it could be for a variety of reasons. But if you have halfway through or at some point during the start of your proceedings been served with a supplementary decision, I would advise you to go back to this authority, Karpoon, Karupen and Myri. There was a lot of guidance given in this case, very useful guidance, and I flagged out the paragraphs for you to look at. There's 4 different types of decisions that can be made. So look at the kind of decision that the Secretary of State have made. Are they trying to defect the cure in their decision, the initial decision? So you might have said that the decision didn't look at evidence A, B, and C. So they issue this and say, so we've now looked at it, but our decision is the same. What would you do in those circumstances? And essentially, after analysing each type of decision that the Secretary of State might issue, and I think it was Lord Justice Underhill at the time, he stated that in practice the lines are blurred, so it may well be open to us to challenge it in a certain way. And the most common way of a supplementary decision which cures the defect in our original decision is going to be a fresh challenge, because more often than not we're going to see the court saying that the challenge is now academic. But it's worth, again, looking specifically at what they've done, looking specifically at how you fit your case within the types of supplementary decisions, and that's by going back to the case of Karupen. You've then got the rolling reviews of the, and again, this is a Court of Appeal decision which held that an applicant for judicial review could amend his statement of facts and grounds. So if you've been served this before permission, before the statement has been served on the Secretary of State, they may well have, in response to your pre-action, issued a decision. You can, at that point, amend your grounds at any point without permission. However, once you have issued and served, you're going to require permission, and that's essentially SPAHU in a nutshell. So it's worth, and the reason why we need to look at what kind of decision it is, whether we continue the challenge, whether we go on to issue a fresh challenge to it, or do we amend our grounds, and at which stage do we amend our grounds. The reason we need to look at that is because there's always going to be implications of costs associated with any actions that we do take, and the costs for the appellant as well, or the claimant who's taking out judicial review action. If we continue and we know that it essentially is rendered academic by what the Secretary of State's done, then it may well lead to a refusal of permission if we're at that stage, and the claimant costs being awarded against the claimant. So it's worth tactically looking at these decisions if you've had a new decision or there's new information that's come to light and you need to look at that. I just flagged for the sake of completeness here remedies. What I would do is just highlight the quashing order, and the reason I highlight that is because the new act, the 2022 Act, which has taken away CART JRs, has also introduced a new form of quashing order, and that's connected to the points that I've just been making about rolling reviews and so on. The quashing order may not take effect straight away. It may allow a decision maker, so the Secretary of State, to make good their error. I don't know how it's going to work in practice. I haven't yet used it or come across it in practice. So it's worth just having that in your background and just knowing that that's it may be an issue in your case. Then the last couple of slides that I would flag here is, and I'm not going to go into any detail in relation to this particular slide, but again, it's something for you to keep in your armory when you're conducting judicial reviews, and it's especially for those who are undertaking injunction work, last minute removal challenges in judicial review. Look at your duty of disclosure. What is your duty of disclosure? I mean, it applies to both the defendant and ourselves, but just making sure that we're complying with that. If we don't know something, then ensuring that we flag that there is missing. We are missing this, we're doing it in a vacuum, but the places to look in relation to what our duties are is the administrative court guidance, as well as the rules, the upper tribunal rules. But the specific parts that I flagged here, and as I say, all these links are live, so you can go to any of these cases when you need. But this particular guidance is going to be invaluable when you need to look at whether or not you ought to have what you ought to be disclosing, or if the Secretary of State is saying you haven't disclosed something and you should have, then whether that falls within that remit. But likewise, when you're seeking disclosure from the Secretary of State as well. More importantly, moving on to consent orders. So we're getting to the end of the challenge that we've made. The Secretary of State in the AOS has issued a consent order. So look out for that, because they sometimes do that. They say, well, you're asking for them to reconsider the evidence or the decision based on a specific matter that you've raised that they haven't looked at. And they say, well, we'll look at it within 3 months and so on. So keep an eye out for that. Negotiate in a timely manner, because if you don't, the upper tribunals provide at least 3 weeks is good enough for you to be able to negotiate that time limit. Then they may they may question why there's been what the good and sustainable reasons are for not having resolved this within those 3 weeks. So it's worth keeping an eye on that. Now, if you've signed a consent order and you then find that your 3 months are up, or they've, in my case in particular, the BRP case that I had, they said they would issue it within 3 weeks, I think it was, because we had waited a very long time. They didn't come back, they didn't comply with the consent order, and you would think that you can just go back to the court and say, well, we signed this consent order and it's not been complied with, but you can't. You have to take you have to initiate fresh judicial review action. So unless you've made a specific clause, or you've put a specific clause in the consent order itself, which you can do, then you'd have to take fresh judicial review proceedings out against that failure. So a little circular and not cost effective at all. The case of AMs, just a reminder here that the upper tribunal has the same powers as the High Court. So it's just worth, if issues arise with reference to their jurisdiction, keeping that in mind. And then this last slide, which is all about costs and where to look for when you've been awarded your cost, or when you should be awarded your cost, because sometimes the Secretary of State, once you've signed a consent order, let's say, they will say, you know, each party bears their own cost, but that if you've had a successful claim, and this leading case of Croydon, which followed Bahta, if you succeeded in your case, even though it didn't go to court because you they've essentially decided to look at your case again, well, you should be awarded your costs. So if they send you a consent order which says no cost, you can redraft that and send it back to them and ask for your costs in the case. So keep an eye out for that. In the case of Kimondo, I thought it's just worth highlighting. I talked about the acknowledgement of service, and in this case, I think it was in this case, or the case of Kumar, which is also flagged, you had the failure of the respondent to, so these are delays by the Home Office, respondent not serving the AOS in time for the purposes of the oral renewal, even at the oral renewal stages. So they were barred from participating, and you know, just saying administrative burdens is not enough for them to have an extension, especially where they've not engaged with the tribunal to say, I'm sorry, we're late. So it's worth, again, looking at these cases and your timetable of whether and when you should have received a response and whether you should be challenging that. One of the other really good cases, which I should have flagged up in my consent slide, but I'm flagging here, is the case of Mwangi. So it's worth looking at that and the principles there in relation to consent orders and how they should, what should happen with reference to consent orders. And then this latest case of Butt, where the tribunal used its discretion to award costs against the Home Office after it breached a consent order, promising to return a passport here in 7 days. So again, worth keeping that in mind. And then the last two things, just flagging there, that it's worth keeping, again, the Administrative Court Judicial Review Guide to hand, even though we're looking at the Upper Tribunal Procedure Rules, as I flagged at the top of the slide, but always go back to the Admin Court rules as well. Sorry, I just want to flag one last thing with reference to the cases that I've mentioned here, which are Kimondo and Kumar. The tribunal awarded costs to the appellant, even though they were midway proceedings, because they were wasted costs for a hearing. So the halfway, I think the Secretary of State sought an adjournment through the proceedings, and because the applicant had attended, but they were wasted costs because the Home Office were in breach of what they ought to have been doing, then they were awarded costs for that particular hearing. So it's worth keeping in mind all of these things when timelines are not adhered to by the Home Office, also by ourselves as well, what the cost implications are going to be. And that does bring me to the end of my talk, and I think I'm slightly over, Richard, so my apologies, but I just thought it's important for us to go through all of those issues and ensure that we're familiar, or just to refamiliarize ourselves with those issues.
Well, thank you very much indeed, Samina. You're only just over your time limit. Well done. And there was an awful lot of information which you've imparted to us succinctly, but we'll certainly be reading through those slides again at our leisure, I'm sure. Now, talking about leisure, we now have our morning break, and after that you'll be hearing from yours truly, and our speaker for the talk after that on modern slavery was to be Jamila Hasan. Unfortunately, she isn't able to attend today, but her slot will be shared between Samina and her colleague Sarah Pinder. So you will be looked after. And how long are we going to have? Well, it's coming up for 11:30. So if we can reassemble no later than 20 to 12, you'll be hearing from me with my winter update. So Samina, will be hearing from you later as well. And see you all at 20 to 12. Thank you. Welcome back, everybody. I hope you're back, because it's time for me to fire off on my winter update, which today is going to focus particularly upon two aspects of the Nationality and Borders Act 2022, namely certification and inadmissibility. Now, starting with certification, we're looking at, in particular, certification of asylum and now human rights claims, which have been rather in the background in the past in terms of certification. We're looking at asylum and human rights claims, which have been certified as clearly unfounded. Now, there used to be a right of appeal against a decision to certify a claim as clearly unfounded, but it could only be exercised from abroad. Now, there still is a right of appeal for asylum seekers who are sent to a safe third country. They can appeal from there. Of course, if it really is safe, their appeal isn't going to be successful. But anyway, looking just at certification on the basis that the claim is clearly unfounded, there have been changes to sections 92 and 94 of the 2002 Act, brought in by the 2022 Act. And section 94, section 3A, makes it clear that if a claim has been certified, there's no appeal under section 82 of the 2002 Act. Oh, by the way, I should apologize for lack of slides on my part, but hopefully you can follow what I'm saying in the brochure, which hopefully you've all got. Now, what does clearly unfounded mean? Well, it turns out, according to Home Office guidance, to mean manifestly unfounded. And that was the old name, which was changed, I suppose, because a lot of people wouldn't understand what manifestly means. Rather like permission has given way to, rather leave has given way to permission, because some people might not understand what leave means. Anyway, the House of Lords, in an old case in 2002, said that a manifestly unfounded claim is a claim which is so clearly without substance that it is bound to fail. Now, some elaboration of this is given in the guidance to caseworkers, and you'll see at the bottom of the first page of my talk. A claim will be clearly unfounded where the caseworker assumes, for the purposes of certification, that the claimant is a credible witness. Well, clearly this is focusing on asylum, where credibility is so often an issue. And the claim is still bound to fail for other reasons, such as the country situation. For example, you accept a person has been threatened by a criminal gang, but there is unequivocal evidence that the gang has since been arrested and sentenced to a long period of imprisonment. Well, I doubt that a person who's threatened by a criminal gang would actually be eligible for asylum anyway, because that's not a convention reason. And there was a case from Colombia years ago where there was a chap who was being threatened by a criminal gang. He didn't have a convention reason, but his family members who were also being threatened did. they were members of a particular social group. And there's another example of that in K and Fauna, which appears below. Now, in the Home Office guidance, there are plenty of examples to do with asylum claims that can be certified, but eventually we get to human rights as well. And the guidance tells us, near the top of the second page, the fact that the Article 8 claim falls to be refused and there are no exceptional circumstances, or in deportation cases, very compelling circumstances, does not mean that the claim should be certified. A human rights claim must only be certified where it is so clearly without substance that it is bound to fail. So that's the House of Lords definition. And we get some examples of claims that are in fact clearly unfounded. So in a partner application, there's no evidence that the relationship is genuine or subsisting. Fair enough. A partner application again, but this time focusing on a dependent child. Well, there's no evidence of a genuine and subsisting parental relationship between parent and child, and no evidence that the parent even sees the child or has any involvement in the child's life. So that would scupper any EX.1a argument for the 10-year route. And then for a parent application, no evidence that there even is a child at all. Well, that's clearly unfounded. But another example seems to me more problematic. There is a partner application, but the claim does not raise any circumstances which suggest that family life with the partner could not continue overseas. And there is no evidence of any exceptional circumstances. Now, lots of applications in Appendix FM by overstayers who have got hitched up with a British or settled partner, but there are no children, are routinely refused because there are no insurmountable obstacles to family life for the couple continuing abroad. And this seems to me to be something that could very well describe a common or garden no insurmountable obstacles case. And we now are getting real life decisions on what look like routine EX.1b claims, where the Home Office say that the applicant or appellant and partner would not face insurmountable obstacles if they were to move abroad. Now, this looks to be in contrast to the guidance which we see above in the top paragraph on this second page. The fact that the Article 8 claim falls to be refused and there are no exceptional circumstances does not mean that the claim should be certified. So the fact that there may be insurmountable obstacles, or sorry, there may not be insurmountable obstacles and there may not be exceptional circumstances, but that doesn't mean that the claim has to be certified as clearly unfounded. Right, well, let me just finish this bit on certification with looking briefly at the history. So if we go back to the 2014 Act, from October in that year, both asylum and human rights claims could be certified as clearly unfounded, but they could be appealed from outside the UK. Also, in 2014, deportees who raised human rights claims were also told that they could only appeal from abroad if it was certified that they would not face a real risk of serious irreversible harm. And then in 2016, that was extended beyond deportation claims to any human rights claims. But at first there was a policy that the Home Office would not certify a claim under Section 94B if the claimant had leave to remain when he made his human rights claim, and also if he was not relying, if he was relying on his relationship with a British family member. So if he had leave, or if he had family life with a British partner or child, then the claim would not be certified. Now, some remains of this policy still apply in the new guidance. So, for instance, if there is a British child involved, or a child who's lived here for 7 years, then the claim would not normally be certified. Now, there are two examples given in the guidance which struck me as perhaps causing some puzzlement to Home Office caseworkers. And the first of these says that there are obstacles to the applicant continuing family life outside the UK, but these obstacles are not insurmountable, as per EX.1A, 1B for family life with a partner. The other example is there is evidence of circumstances that may amount to exceptional circumstances, though the caseworker does not consider that the circumstances are exceptional, and therefore the claim falls to be refused. So it strikes me that there is a grey area between an obstacle and an insurmountable obstacle, and between an exceptional circumstance and a common or garden circumstance. And which way a particular caseworker goes could be challengeable. So this, I think, leaves some room for judicial review challenges to certification. And of course, as we've just been hearing from Samina, judicial review challenges are indeed brought against certification. Well, I'll turn now to inadmissibility. And this can be found in a new Part 4A inserted into the 2002 Act by the 2022 Act. And it comprises sections 80A, B, and C. So the Secretary of State, under these sections, must declare inadmissible an asylum claim made by an EU citizen. Now, the Secretary of State may, so this is discretionary, declare inadmissible any asylum claim where the claimant has a connection to a third safe state, or a safe third state, I should say, get it the right way around. And what is the definition of a safe third state? Well, it's one where 3 conditions have to be satisfied. The claimant's life and liberty are not threatened for a convention reason. The claimant will not be sent to another state otherwise than in accordance with the Refugee Convention or with the Article 3 of the European Convention. And thirdly, a state where applications can be made for asylum. So all of those 3 have to be present for the state to be a safe one. There is no right of appeal against a declaration of inadmissibility. So the last resort, well, first resort in this case, would be judicial review. Now, further up, we see that a safe third state is one to which the claimant has a connection. So what is a connection to a safe third state? Well, 4 things have to apply. Or one of these 4 things should apply. That the person has been recognized as a refugee in that state. Well, that's definitely safe, isn't it? Or they have made a protection claim there, which has not yet been determined. okay, they've got a pending asylum claim. It may be granted, so they should go back to the safe third state. But the state is also safe if there has been an asylum claim which has been refused. So I wonder, what would the situation be if the applicant is sent from this country back to that state where his asylum claim has already been refused? Now, if the state is safe, then they won't refool him to a country where his life or liberty would be threatened for a convention reason. So what's going to be the situation? Will the safe third state entertain further submissions or a fresh application? What's going to happen to him? Well, the third situation is that the claimant in the UK was previously in that safe third state and could have claimed there. It would have been reasonable to expect him to do so, but he didn't. And then the fourth alternative says the same thing. It would have been reasonable to expect that chap, when he was in the safe state, to claim asylum there. So I don't see why the fourth has been added to the third when they both seem to mean exactly the same thing. But drafting skills seem to have declined somewhat in recent years when it comes to primary legislation, not just the immigration rules. Now, here we have at section 80B, subsection 6 of part 4 of the 2002 Act, the killer. An applicant whose claim has been declared inadmissible because of his connection with a particular safe third state can be removed to any other safe third state. Well, yes, because what other safe states would accept an asylum seeker from this country? When Britain was part of the Dublin Convention, or Dublin Regulation as it became, we could ask other member states of the European Union to take back asylum claimants who had been on their territory. And quite a few were indeed received in other member states. But nowadays, after we've left the European Union, unless we have an individual agreement with a particular country to admit asylum seekers who've passed through that country, there's no obligation on any other country to accept asylum seekers from the UK. And in fact, the only country with which we do have a treaty is, yes, Rwanda. So section 80B6 makes provision for Rwanda. But subsection 7 is also very important, because it says an asylum claim that has been declared inadmissible may nevertheless be considered if there are exceptional circumstances. Now, what might those exceptional circumstances be? Well, we'll see an example of one such below. And I'm going to take you to an example of a standard letter headed Notice of Intent, which is being issued to recently arrived asylum seekers, the ones who've come in since the 2002 Act came into force, as far as asylum is concerned, on the 28th of June last year. So this is a standard letter, and it tells the claimant, well, in this case, you've been through Italy and France, so this has consequences. Now, we're going to consider whether it is reasonable to have expected you to have claimed protection in Italy or France. Or, and if it was, we will declare your claim as inadmissible. And we won't ask you for your reasons for claiming protection, or make a decision on your protection claim. But then it says, a bit further down, it is important that we conclude these inquiries promptly. If, within a reasonable period, we have not finalized and obtained agreement for your admission to a safe third country, we will admit your claim for substantive consideration in our asylum system. Well, there you have exceptional circumstances. The Home Office can't get any other country to agree to take the asylum seeker back. Therefore, he will be admitted into our own asylum consideration system. So, as has been pointed out by people like Colin Yeo in the Free Movement blog, the effect of declaring lots of asylum seekers inadmissible will simply be to keep them in limbo, or indeed in a hotel, for several months, kicking their heels, before their asylum claim is actually considered, which it's going to be, because there's no way that anybody's going to be sent back to, they're going to be sent to Rwanda anytime soon, probably not this year at all. And so several months will elapse, and the Home Office will have to start considering these asylum applications. Now, if you go on to the next page, we look at a document which comes with the notice of intent to declare the claim inadmissible. And this sets out frequently asked questions and gives the answers, such as, why am I being considered for relocation to Rwanda? And the asylum seeker is told that he must disclose the details of his stay in any safe country while on his way here. And if he could have claimed asylum in that country, his application here will be declared inadmissible. Now, it strikes me this doesn't give asylum seekers a great incentive to come clean about their route to the UK and how they got here, because if they end up with their claim being declared inadmissible and they get sent to Rwanda, well, yeah, they're not going to be very forthcoming. Okay, well, so much for inadmissibility. I have a brief technical note here, which is to do with a tweak made by the 2022 Act to actually the definition of one of the convention reasons, namely membership of a particular social group. Now, in the House of Lords case of Kay and Forna, Forna was female genital mutilation, Kay was family member, and that was another case where the head of the household did not have a convention reason, but the rest of the family did, namely membership of a particular social group. So they defined a social group as one in which the members must share an innate characteristic, a common background that cannot be changed, or something so fundamental to their identity or conscience that they should not be expected to change it. But Section 3 of the Nationality and Borders Act has added a second condition, namely that the group has a distinct identity in the relevant country because it is perceived as being different by the surrounding society. Now, that's probably not something brought to the attention of the Prime Minister before he made his speech to the House of Commons on the 13th of December last year. He had a plan, a 5-point plan, which he imparted to the Commons. And here it is in a nutshell. Number one, a new permanent, unified small boats operational command, to use all available technology, including drones, to pick people up and identify and then prosecute more gang-led boat pilots. Boat pilots beware, and more than 700 new staff will be drafted in. Now, these extra resources will be will free up immigration enforcement officers to carry out 50% more raids on premises where illegal working may be going on. And one hears anecdotally that there do seem to be more raids now. But here's something which has caused alarm among the very large number of people who are here with irregular immigration status, but who have bank accounts. Now, if you want to open a bank account, sure thing, you have to provide not only photo ID like a passport, but also proof that you have regular immigration status in the UK. So if you don't have leave to remain or something similar, you're not going to get a bank account opened now. But it was easier in days gone by to open a bank account without having to do that. And quite a lot of irregular migrants do have bank accounts, or they may have got them in somebody else's name, but they have access anyway. But what Rishi Sunak wants to do is to bring back an aspect of the hostile environment which was actually suspended by Sajid Javid when he was Home Secretary. And that is providing banks with sets of data from the Home Office, which list the very large numbers of people who are here unlawfully, and the Home Office thinks are still here unlawfully, and get the Home Office to get the banks to trawl through their list of customers and pick out any names that appear on the Home Office list. So by sharing this data, the Home Office hopes that the banks will weed out lots of illegal immigrants, freeze their bank accounts, and help to force them back to their own countries. So that is something which is causing much alarm among irregular migrants. There had been hopes among them, as I'm sure many of you know, that there would be an amnesty for people who'd been here for 10 or 12 or even 15 years. And they were really pleased when Boris Johnson became Prime Minister, because he'd mentioned several times when he was Mayor of London that he was in favour of an amnesty. Alas, those hopes proved baseless, and there's certainly no way that Rishi Sunak is going to grant an amnesty. Well, moving on to the other points, to avoid spending £5.5 million a day on hotel accommodation, asylum seekers are promised disused holiday parks, former student halls, and surplus military sites. Great. Now, in order to process claims more quickly, the number of asylum caseworkers, which had already doubled from 600 to 1,200, will be doubled again. And that way, all of the backlog of asylum claims, or what they're now calling legacy claims, claims lodged before the 28th of June last year, will be cleared by the end of this year. Now, that's a tall order, because at the end of last September, there was a backlog of some 143,000 asylum claims. So we'll see. Now, one way of doing it will be to have shorter guidance, fewer interviews, less paperwork, and specialist caseworkers by nationality. What about modern slavery? Well, of course, a lot of asylum seekers also claim to have been trafficked, and probably the majority of the 13,000 Albanians who've arrived on small boats during the past year have claimed to be victims of human trafficking. But according to Rishi, the shine will be taken off Theresa May's Modern Slavery Act by such means as removing its gold plating. And that can be done, for example, by reducing the cooling off period from 45 to 30 days. Well, we'll hear more about human trafficking and gold plating in the next talk. And then finally, the Prime Minister turns to Rwanda, which, to Albania, which, like Rwanda, when described by Priti Patel, is also a safe and prosperous country. And it will be a new approach to Albanian asylum seekers. So again, it's a 5-point plan. First, immigration officers, or rather border force officers, as they're called these days, will be embedded in Tirana airport. Why? To stop asylum seekers getting here. Yes, lots and lots of asylum seekers come by air in preference to coming by small boat. Guidance for caseworkers will make it crystal clear that Albania is a safe country. And as far as modern slavery is concerned, a caseworker will need objective evidence rather than just a suspicion. Although I think for a reasonable grounds decision to be made, more than just a suspicion is needed. Now, in fact, I mean, this is really over-egging the pudding. The vast majority of claims from Albanians can simply be declared clearly unfounded, because formal assurances have been received from Albania that they will protect genuine victims of trafficking and people who say that they're at risk of re-trafficking on return. And there will be a new dedicated unit expediting cases within weeks, staffed by 400 new specialists. And the weekly flights to Albania will keep on going. And of course, they have been going. But what about flights to Rwanda? Well, the Prime Minister assured the House that we will restart the first flights to Rwanda as soon as the current legal proceedings have been concluded. Well, it's a bit pedantic, but flights haven't started at all yet, have they? So how can you restart them? But perhaps the most disturbing thing in that December statement to the House of Commons is something that hasn't happened yet, but may do, because as you can see at the bottom of the page, there will be new legislation to make abundantly clear that if you enter the UK illegally, you should not be able to remain here. And once removed, you should have no right to re-entry, settlement, or citizenship. Now, would that apply to people who don't come to the UK and claim asylum, but let's say they overstay a visit visa or a student visa, get hitched up to a British or settled person and then make a human rights claim? Will they be told, well, they haven't entered the UK illegally, so I suppose the fact that they entered with a visa would leave them outside that cohort. But if they were an illegal entrant who came in on the back of a lorry, never claimed asylum, but just hung around and got hitched up to a British citizen, would they be caught by this? We'll see. And then the Prime Minister finishes, the only way to come to the UK for asylum will be through safe and legal routes. Now, fair enough, the safe and legal routes for Ukrainians have indeed worked for large numbers of Ukrainians, but not so for Afghanis. There are two schemes: the Arab scheme for Afghans who've worked with the British in Afghanistan, usually as interpreters, and then there's the Afghan citizens resettlement scheme for other Afghans who would be at risk from the Taliban because of their being women who speak out against the Taliban, or other people who are who have been supporting human rights there, that sort of thing. Well, not that many Afghans have come at all under the Arab scheme. Many who could have come are still there and haven't been able to make it to the UK. And in fact, nobody has yet been admitted on this Afghan citizens resettlement scheme. It simply hasn't got going. So it doesn't really look very good for safe and legal routes. Now, I'm just going to finish with a little more about the Prime Minister's 5-point plan. And this comes in a letter from two directors of the Home Office to stakeholders, including ILPA, and ILPA has sent it round to members. And this letter carries on from the Prime Minister's 5-point plan, which include his desire to re-engineer the end-to-end process. Yes, they love to use rather florid language, don't they? And we will do this by simplifying policy guidance, removing the requirement for substantive interviews, and appointing specialists in particular nationalities. Now, this actually may be a good thing, because the streamlined asylum process will apply to manifestly well-founded claims. So high grant nationalities, and 5 have been singled out: Afghanistan, Eritrea, Libya, Syria, and Yemen. Asylum seekers from those countries will not need to be interviewed at all, and they will be issued instead with a questionnaire, and they will be given at least 20 working days to complete the questionnaire, which will provide information which could lead to a positive decision being taken without a substantive interview. And please note, asylum claims will not be refused without a personal interview, unless one of the exceptions in paragraph 339NA of the immigration rules applies. Now, if you look up paragraph 339, and most of the letters of the alphabet now come after it, the first subparagraph of NA is for just this situation. It's not necessary to interview you because we're going to grant you asylum anyway. Now, if the questionnaire is not returned within 20 days, the caseworker has got to remind the applicant that it should be returned. And some more about that is contained in specific guidance to caseworkers. This was just a letter I was quoting from, but there is published guidance for streamlined asylum processing available to caseworkers and, of course, members of the public. And when it talks about the asylum questionnaire, it says you've got a minimum of 20 working days to return it, with a further 10 working days if you get sent a reminder that you haven't yet sent it. And you can still make a request for a further extension, but it will normally be appropriate to accept such requests only if the request is reasonable and proportionate. And extension requests for another 20 days or more, on top of the 30 that have already been given for returning the questionnaire are unlikely to be reasonable and proportionate. And a claim where there's been no questionnaire returned is likely to be treated as withdrawn under paragraph 3C of the immigration rules. And right enough, if you look up paragraph 333C, one of the reasons for treating a claim as withdrawn is that a questionnaire has been sent out and not returned. And there's also an asylum policy giving an instruction on withdrawing asylum claims. The questionnaire should be returned to the following address: Asylum Customer Communications Hub, all one word. So asylum seekers are customers, at homeoffice.gov.uk. Now, you'll be relieved to hear that I'm not going to inflict upon you the last bit of my update, which is grounds for refusal. Now, I say this with great personal sorrow because nothing interests me more than nitpicking details of the immigration rules. And that's what I was going to agree, that this is what I was going to inflict upon you. In particular, the new rule, which can mean that if you go back from this country having been here unlawfully and make a claim to come back, maybe family reunion with a spouse, you can be refused because of your previous breach of the immigration rules. But you can read it at your leisure, and I hope it's reasonably clear. So thank you very much for your patience so far. And it's after 12:20, so we're still running a bit late, though I've tried to catch up a bit with the timing. But it's not lunchtime yet, folks, because Samina and Sarah are waiting in the wings to tell us about modern slavery cases, gold-plated or not. So we'll be having lunch then after they've finished, but in the meantime, I'd better let the ladies get cracking. Thank you.
Thank you, Richard. And yeah, as ever, so much to cover, isn't there?
Indeed.
We'll try and make up time as well, I think.
Yeah.
I can definitely cut my bit short. I'm happy to do that. But let's see how we get on. Before I head over to Samina, I'm just going to share my screen because I'll do the slides. And let's just make sure that that is happening. Is that good?
Just enter the full screen and then we're...
Full screen on Zoom. Can you see other stuff then?
Yeah, we can see everything.
Oh, sorry. Okay.
That's fine. That's better.
Is that good? Yeah.
Yeah.
Okay, great. Sorry. I hope I didn't have anything incriminating on there.
No.
But yeah, apologies again from Jamila. You heard from Richard earlier and Kezia. Unfortunately, some issues came up for her, so she wasn't able to present in the end today. So bear with us because we're covering. So that's the overall disclaimer. We've kind of last minute, tried to get our heads around this as well. So hopefully you can bear with us. And without further ado, I'll hand over to Samina, who will start.
Thank you. And sorry, you've got to hear from me again. So just wanting to look at modern slavery and trafficking cases, but also in the context of the new act, because a lot's changing. You've heard from Richard already. And so it's worth, as a topic and as a webinar topic, to be able to just be able to place everything in that context. So what we want to go through and what we want to look at today is identifying victims. We all come across individuals in a variety of different applications that are being made or that we're dealing with, including asylum. So it's not just asylum, but looking at identifying other individuals essentially who might be victims of trafficking or modern slavery. We also want to look at, of course, the interplay with the Refugee Convention, because that's where we see most of our victims of trafficking or modern slavery when they've claimed asylum, and then through the investigations and interviews, that's where we see those individuals. I want to look at also the EU Trafficking Directive and the new Act, and what might change with the introduction of the new Act, and then going to be handing over to Sarah to look at the national referral mechanism itself, how it all works, what's changing, and in that context, what's changing with reference to the new Act, which you've already heard some bits of from Richard. And then, of course, looking at this new guidance, which turns things slightly on its head. And of course, the new case of Shamima Begum, which touches on the issues of trafficking, and will be interesting to see how that all plays out and which way where it goes to. But for now, Sarah will be exploring that how it touched upon the issues of trafficking and the matters that arose there. Just going to the next slide again, just looking at an overview itself with reference to who is a victim of trafficking. There seems to be a uniform definition of a victim of human trafficking for identification and components of the offence. But where do we get this? And that takes me to the next slide, next couple of slides, where I'll go through some of the sources, but also talk about the various components that we look at when we're looking at trafficking and modern slavery. So here you have the modern slavery and trafficking defined in the Modern Slavery Act 2015, sections 1 and 2. These create criminal offences, but the definitions are used in provisions pertaining to victims generally. So there's an overlap between criminal law, immigration and asylum, as well as family context. And the distinctions that are made are less likely to matter in practice to us as immigration lawyers than to the criminal lawyers who might be prosecuting or defending and have to look specifically at the wording of the Act. But just if I look at section 1 of the Act, it refers to holding a person in slavery or servitude, or requiring a person to perform forced or compulsory labour, are to be construed in accordance with Article 4 of the Human Rights Convention. So we'll look at Article 4 of the ECHR, but more importantly, you'll see several references to different parts of the or different components or sources of who victims of trafficking are. And this is the first in this particular slide. The Council of Europe Convention on Action Against Trafficking, commonly known as ECAT. You will have seen it referred to in some case law, but generally we don't, as immigration practitioners, use it in our daily dealings with either the cases that we're looking at under the Refugee Convention, but also when you're looking at victims of trafficking. So it's nice to be able to familiarize ourselves with the definitions under Article 4 of ECAT, which provides us with the definitions used by the UK. Now, the source of ECAT is from Palermo. I'm going to be referring to it as ECAT because it's just easier than using its full title. It comes from the Palermo Protocol on Trafficking on the to the UN Convention on Transnational and Organized Crime. So there's a theme of attempting to streamline the definitions, and it's the definition that the UK government has derived from Article 4A. And what the most important things that come out of ECAT are that the definition that, it doesn't require there to be trafficking across international borders. So British citizens or foreign nationals moved from one part of the UK to another for exploitation can be considered as individuals who fall within the definition of trafficking. So that's important to keep in mind. You know, we often associate trafficking or modern slavery with someone who's come from another country, but that is not, or may not is not the only way to consider an individual's circumstances where there's a suspicion of trafficking. And looking at some of the, oops, I think I've lost the slides there. I don't know if anyone else has, it's just gone blank. If I can just go back to the last one. But I just wanted to look at these two cases that have been highlighted here. So it's Atemawan and EOG, both, one was from 2013, but it was upheld in EOG, which is a 2022 case in the Court of Appeal, both quite important cases. They considered the ECAT, they considered it and held that whilst ECAT doesn't have direct effect in the United Kingdom, there is Home Office guidance which gives effect to it. And if you don't consider that Home Office guidance, then there's an error of law. So these were all challenges to failure to consider ECAT and the definitions used there with reference to cases involving victims of trafficking. So it's useful to just keep that in mind. So this is not something that has direct effect in the UK, but it's still an error of law not to be take account of it. We've also heard from Richard in relation to some of the new provisions under the Nationality and Borders Act, and it introduces regulations associated with the Act, which seeks to now, and it's enforced from last year, but it seeks to now define the victim of slavery and victim of human trafficking. What has been noted by several practitioners in the area is that the definition under the regulations is much narrower than that of that's within the definition of provided for by ECAT. So that's worth keeping an eye on. It's a worry because it narrows or restricts what's already become quite a well litigated area, and where we're exploring different elements of victims of trafficking and the definitions within victims, or who forms a victim of trafficking, or who is a victim of trafficking, sorry. But looking at the three components then on the next slide, excuse me, the definition itself, a little bit difficult sometimes to get your head around, but you want to look at three different components. One is the act, one is the means, and then one is what is the purpose of what's happening to the individual, but it's got to be for the purposes of exploitation. So looking firstly at the act, you're looking at an individual. What's the act that we say has occurred for them to be considered as being trafficked? So in a sense, it's either you're looking out for recruitment. Have they been recruited? Have they been transported somewhere? Have they been transferred from one place to another? Harboring or receptions of persons, including the transfer of control over those persons. All very interesting elements and self-explanatory and things that we have come across in our day-to-day practice as asylum representatives, where individuals we know that have been recruited perhaps into, or there's been a criminal raid where individuals which involve cannabis growing, individuals are found on cannabis farms. I think there's been several cases, and they have been recruited, essentially. They've been found to be victims of trafficking. So you're looking at a variety of different acts in relation to individuals. If you're dealing with these individuals, you must look at the situation itself. As I say, I've just given you one particular example, but there are so many different ways in considering what the information that someone's giving you, and we'll look at that a little bit more in terms of disclosure of an individual who you might be representing in a different context. But be aware of the situation that they're in. So it's situational awareness. When you are looking at the terms, always ensure that there's a broad interpretation of these terms. So take that as read, that it's going to be a broader interpretation, and each of these elements are disjunctive. So there doesn't have to be a combination of any of them. It could be one single act that is relevant to your client's situation. And of course, always be aware of any misconceptions associated with a single situation, and whether your client would fit within that particular act. So that's looking at the act, but let's look at how that act is achieved. Again, self-explanatory there is the threat or use of force or other forms of coercion, of abduction, of fraud or deception, the abuse of power or a position of vulnerability, or the giving or receiving of payments or benefits to achieve the consent of a person having control over another person. We've seen that with reference to many different cases. Again, I could go back to the cannabis farms and those individuals who might be recruited there, maybe trying to pay a debt back home if they are from another country. You have those who have been trafficked for the purposes of prostitution and being detained and against their will. But those are the more well-known cases. So just look at that in the sense of, and the lesser ones that we would see are the ones where someone's receiving a payment or benefit. So it's worth keeping in mind this particular element, and keeping it and ensuring that we explore it as thoroughly as possible. And then the last part is to look at the purpose of the act being carried out, and the purpose ought to be for exploitation. I've already covered the issue of prostitution, for other forms of sexual exploitation, forced labor or services, including begging, slavery or practices to slavery, servitude, or the exploitation of criminal activities, and even the removal of organs, which is something not so common that we see, but it's something to consider in the wider context. That explains the definition of the who would be considered as a victim of trafficking. Now, there is an exception within all of this, and that's with reference to children. Children, if the victim is a child, it's enough to show that the trafficker has done something that is an action for the purposes of exploiting the child, without showing that there's a particular means of doing it, that there was any threat or anything involved. So the means part can be taken out of the consideration of a child being trafficked. So it's much more flexible when you're considering the circumstances of a child. And I think that we all have or would have come across individuals who have a long immigration history and have come here as children, and will often give us a history of having had to have worked in the family home or family restaurant and so on. So it's worth bearing the circumstances of a child in mind when you're putting forward the case or looking at the history of someone in that circumstance. So I do want to look at the interplay with the Refugee Convention. I think I've already touched upon the individuals that we tend to see are those who often, who are victims of trafficking, are often also claiming asylum. It's worth looking back at the UNHCR guidelines here on international protection relating to victims of trafficking, persons at risk of being trafficked, and whether or not they also have a well-founded fear of persecution, whether they fall to be considered as someone who's a victim of trafficking, but also whether or not they are a refugee. There have been two cases, I haven't put them here and I can put them in the chat box later, which are relevant to someone who has been or who can be considered a victim of trafficking and considered with reference to ECAT and leave to be granted with reference to being found a victim of trafficking. And these cases, the first one is KTT. It's a well-known case in which the upper tribunal, they confirmed that even if you're recognized, where you are recognized as a victim of trafficking, but you're also an asylum seeker with maybe a fear of being re-trafficked as well as political persecution or other issues, you should still be granted leave to remain with reference to ECAT if you've been found to be a victim of trafficking with reference to the NRM and all other elements of trafficking. So you should be granted, even if you're awaiting your status as a refugee or consideration, your claims consideration as a refugee. And the tribunal also clarified in another case, this is a case of SSA Ethiopia, that the claim does not need to be based entirely on a fear of re-trafficking to get leave under ECAT, so long as the issues put forward as one of the reasons the individual fears returning to the country of origin, then that they should be granted leave with reference to ECAT. And just looking at the kinds of leave that I think Sarah is going to address that, because there are later slides which talk about the new changes or the changes in the new guidance with reference to what kind of leave might be granted to individuals who are found to be victims of trafficking. So I'll leave that to Sarah for the slides which come later. But looking at the Trafficking Directive and the new Act, the Trafficking Directive is something which, as it says on the tin, it was on preventing and combating trafficking in human beings and protecting its victims. And it was something that the UK, strangely enough, had opted into. It survived Brexit, and it's one of those few EU instruments on immigration where the UK has exercised the opt-in after they initially refused to do so. The focus is on criminal aspects, preventing trafficking, pursuing and protecting protection from criminal prosecution, as well as protection in criminal proceedings and assistance and support. So it's more of an impact there. But when, and I think section 68 has now, is now in force, and I think again Sarah will address that, but I believe it is in force now. It will disapply anything which is incompatible with the Act, the Nationality and Borders Act, with reference to this trafficking directive. So it will trump the directive, even though we've opted into the directive. Direct effect will be given to anything within the Nationality and Borders Act 2002. But again, the impact for the EU trafficking directive is going to be more relevant to those involved in criminal prosecutions of this, using the directive as a source document. And that takes me to my last slide. When you're dealing with clients, what are useful resources? What should you be looking out for? As I said right at the start of the talk, we have clients approach us all the time, and they may well, it's not only with reference to asylum claims, they may well be seeking leave as a spouse, long residence or other elements. And it's important for us to have in mind what, if there is something that triggers a factor which looks like trafficking, to keep in mind things to look out for and how to look out for them. So one of the important, or the more important sources, is going to be this guidance. It's hyperlinked, so you can go straight to it if you need to. It reminds the staff, the Home Office staff, even if at first instance someone looks like a willing participant, their relationship with the trafficker, it may well be one that is of, the relationship may well be one of control and coercion. Now, if you look at the table of indicators at page 37, that's going to be a really useful source just to cast our mind over, or to even just keep in mind if something triggers within your the remit of your consideration that you want to go back and refer to with reference to the client's circumstances. And then as a practitioner, when you're dealing with clients who are coming to you with an account of being someone who's a victim of trafficking, or there is some sort of trauma that you're being faced with, it's always important to go back to adopting a trauma-based informed method of working with your client. And that comes from, or a useful source of doing that is to look at the trauma-informed code of conduct. Again, that's produced by the Helen Bamber Foundation, but it's really useful guidance. It helps you understand that you must build a relationship, remind your clients of your policies on confidentiality, and that anything they say, how the issues of confidentiality will work, allow them the opportunity to express themselves, check who's with them, check the individuals around them who are guiding them, interpreters with them. So it's empowering them, empowering your client, that if they are trafficked, they can, and if they've experienced control and manipulation, that they can disclose information to you, which may assist their case and assist you in pursuing their case if they are a victim of trafficking. So it's just things to look out for to facilitate disclosure and to just remind ourselves of how we must act. And sometimes we forget, even as I say, if it's a case where they haven't come forward as a victim of trafficking, and they may be in another category, but it's sometimes good to remind ourselves of this criteria to ensure that you can take the relevant action, and that if you are faced with an individual who you suspect is a victim of trafficking, and on that note you have the Law Society practice note on the Modern Slavery Act there as well, which I think is quite a useful tool as well in relation to our own practices and the way how we might deal with certain situations we find ourselves in. That takes, well, I can hand over to Sarah. That takes me to the end of my part of the talk. I hope it's been useful, but Sarah's going to carry on with the national referral mechanism.
Thank you, Samina. Yeah, absolutely echo everything that Samina covered, particularly in terms of the awareness that we need to have as practitioners. The next slides will take you through the procedure a bit more, but it's still an overview. So do use that really to sort of lodge radars, if you like, in terms of your practice area. And if you want to delve into it into more detail, then obviously come to us or look at those resources in more detail. But basically, this is the procedure for the referral effectively for the identification of victims or potential victims. So it's NRM for short, for those who are less familiar. As Samina already highlighted, the first bullet point is just reiterating the positive obligation under ECAT and under the ECHR in terms of positive obligation on the authorities to identify a victim, potential victim, and that's an absolute obligation. It's not qualified in any way or can't sort of be swept aside for another good reason, so to speak. You've got a bit more detail in terms of the authorities that are responsible for it. I will just talk quite swiftly through that. Effectively, it's become as a shorthand in terms of the competent authority who will take that process over. But you do have two authorities, and they are detailed there. The single competent authority, part of the Home Office, so sort of under the remit of the Secretary of State, but it's separate to the immigration functions in terms of those that fall under UKVI. And the second is the Immigration Enforcement Competent Authority, which is more controversial, created more recently in 2021, and is really attached to what we've been seeing a bit more in the media, reported in the public domain, coming from government officials in terms of the concerns held seemingly by the government in terms of any abuse of the modern slavery sort of framework and the system. That is just, again, a quick pause. That is done, as far as we're concerned as practitioners, also voiced by the former modern slavery sort of rapporteur in the UK, without much evidence, if any. So it does seem to be anecdotal, it's very political, and so I think that's one space to look out for in terms of how that develops. And just the last bullet point is just making you aware, for anybody joining us from different devolved administrations, that there are different competent authorities for Scotland and Northern Ireland. So just bear that in mind if you have either clients based in that region, as we may also be moving around a bit more with remote working, but also if yourself as a practitioner are based in a different region. Sorry. So in terms of the stages of the NRM, this slide is very bare because there is quite a lot to fit in. So I'm just going to speak to you a bit more about that in terms of the different stages within the referral. Stage 1 is set out there. So it's the first responders. So effectively there needs to be a referral to one of those organisations so that effectively the referral can take place under the NRM. And I've listed those there for England and Wales. So apologies again for those in different governments, devolved governments. You have them all there. I've grouped the sort of similar ones in terms of the Home Office, local authority, police, NCA, sort of the public authorities, and then a list of more sort of non-for-profit organisation. You may be familiar with some of them, not all. Migrant Help, for example, I've certainly come across them in terms of Section 95 accommodation, so within the National Asylum Support framework. Kalayan is, from memory, I think specifically looking at domestic workers, domestic servants within certain communities and any abuses within that context. It may have a wider remit, but it's certainly a very active organisation. So I would encourage you to familiarise yourselves with their work. And then others like Bernardo, Salvation Army, NSPCC and so forth. So they've got the set procedures, they've got the knowledge to then take that on. As practitioners, again, speaking from memory, as practitioners, we can't ourselves make a formal referral for the NRM to be started, to be kick-started, but you can make that referral sideways to one of those first responders, for example. And then you reach stage 2. So once that referral has been started, and sort of responsibility has been seized, so to speak, you enter stage 2, which is called the reasonable grounds. And you had references in Richard's earlier talk in relation to that, because we'll see a bit later on in the slides how this sort of may be affected by the new provisions in the new Act. But basically, in terms of the reasonable grounds procedure, it's supposed to be a very swift process. So it's a target date of 5 working days for there to be a reasonable grounds decision. And that is concerning whether someone is a potential victim of modern slavery. So again, the emphasis on potential, the emphasis on suspicion, and that entails a lower threshold in terms of test. So effectively, it's sort of a prima facie test that you've got to show, or that you've got to establish, or that needs to be established. Sorry, I don't mean to say you, as the burden is not on the potential victim in any way, but effectively that's the level that the investigation needs to be taken at. So you have a suspicion that a person is a victim of modern slavery or trafficking, and really no more than that. So reasonable grounds to suspect that a person's been trafficked or subjected to slavery. And just pausing there at this stage, again, part of that lower threshold, it is really what's important to remember is that that really can kick in at any stage. So Samina's already mentioned earlier, when looking at the different acts, that the relationship with, for example, the trafficker can be a changing one. And I'll just give you an example of this that happened to me quite early on in my practice. I was quite junior, and it was an asylum case that I had in court, first appeal hearing, so substantive appeal hearing, hadn't had any involvement with the case before. And effectively, the person in their statement had set out that they had paid a substantial sum of money in order to an agent, in order to be brought to the UK, in order to claim asylum, effectively. So that was their means of arriving in the UK. So at first hand, that's nothing obviously unusual. But upon his arrival in the UK, the relationship had changed, and he was forced to, I think, if I recall correctly, it was to sell DVDs on the high street, in the black market, but effectively to do that until a very substantial debt had been repaid. And that hadn't been his understanding of what he would be doing on arrival as part of that sort of initial agreement. So there was very much a coercion from the point of arrival, and a different sort of context that had then established thereafter. And this was back in the days where I certainly wasn't very aware of the trafficking provisions and all of the components and the changing nature of those. And so it was only later in the hearing that picture emerged, and it was then adjourned for there to be a referral and for that to be looked at. So it's just, again, an important reminder that, like children, there can be complex aspects of it that are not necessarily straightforward at the start, or that are glaring, and the same with adults as well, that relationship can change, and the elements of modern slavery can come out at a later stage, and they often go undetected for a long period of time. So we still see failings within the criminal justice system, for example, and in other contexts as well. So it's just to remember that, and that really that lower threshold at the initial stage. Then once you have a reasonable grounds decision, so you would either have a positive or a negative reasonable grounds decision. If you have a positive reasonable grounds decision, you get on to stage 3, which is the conclusive grounds. If it goes without saying, if you have a negative reasonable grounds decision, then that would be the end in theory of that process, unless you are to look at that decision, if you'll cease of the matter at that stage, or you're digging into it at a later stage and looking at whether that should be a decision that should be challenged. So moving on to the conclusive grounds, that's effectively the sort of the meat on the bones, where you get to effectively the substantive decision that would recognise a person as a victim or not. So at this stage, we move up a scale in terms of the threshold, in terms of the test that is to be carried out, and it is on the balance of probabilities. So that is whether there is sufficient information to conclude that the individual has more likely than not been a victim of modern slavery / trafficking. So really, there's not much more to say in terms of that process, in terms of the test. That is what it is. But what I wanted to add in terms of practice, again, because of the way perhaps we come across these cases as practitioners, in a sort of roundabout way, you're not necessarily seized of the claim in terms of that person is claiming to be a victim of trafficking or modern slavery, but you've seen it perhaps as part of the asylum case, or you've seen it many years later in terms of an unlawful detention case, whatever the case may be. What I want to highlight is, very often you don't actually have sight of those decisions. So you very often don't have sight of the NRM reasonable grounds decision, or NRM conclusive grounds. So more often than not, certainly it's the case, I think, for both our practices, Samina and I, you see them as referred to in other decisions of the Home Office. So you see it in the immigration history that there was a negative reasonable grounds decision, for example, or positive, and you know, it's that the asylum claim has then taken its course, and you have the refusal of asylum, for example. So very often you don't have them necessarily you know, without asking for them. So you need to, if it's something to explore, you need to get hold of copies of those decisions, data protection requests, for example, for the copies of those, you know, contacting the authorities themselves, obviously seeking up previous files and so forth, because you may need to look at that source decision in order to see where you're going to take the case from. The other context where this happens also is when you have an asylum claim that has continued and you're at the appeal stage, for example, and there's been a negative reasonable grounds decision, but the part of the case is maintaining the trafficking element. Again, you wouldn't necessarily have that NRM decision in the Home Office bundle. So that's a very frustrating aspect of working on these cases. And you also often have queries from tribunal judges as to whether they can mess with that decision, whether they can actually, I shouldn't say mess, but whether they can review that decision at all and make findings of their own. And often the reactions that you do get is that they can't, is that the NRM's taken that decision, the jurisdiction that is before them is in relation to the protection claim, and they can't necessarily look into that. Well, in fact, they can, because ECAT, because the ECHR is there, they're looking at a protection claim, whether there's breaches of human rights, and they can, in fact, make a finding of their own motion, in the sense that you can invite them to make a finding as to whether a person is a victim of trafficking. And that may cause you to get the NRM decisions, of course, so that all of the relevant evidence is there. But it's just, don't be fooled by the lack of those decisions as perhaps an indicator that there's no case to pursue on that front, or an indicator that that's the end of the matter, because it isn't necessarily so. So moving on from the NRM, again, quite swiftly, I said I'd try and make up some of the time. Now we're looking at the National and Borders Act 2022 changes. Again, I'm just going to stick to quite a bare overview, and I apologise if that isn't sufficient for some of you. But there is, again, you could do a whole talk on really on NABA and its changes, and also how it affects the modern slavery framework. But the other reason is, I think we've yet to see really how a lot of this is panning out. So it may be too early to really sort of try and figure this all out. And if of interest, let the organisers know, let Vasanta know, and we can always do a repeat session on this topic in later this year. So you just have the explanatory note here in terms of the Act. I mean, it's just reiterating really the commitment to the protection of victims. And then I've listed here Part 5, modern slavery. So Part 5 is the part in the Act where this appears, and the sections, because as you know, the Act covers nationality first, and then other aspects of asylum and refugee convention claims, and then modern slavery. So you have the list just really as a go-to if you need to go back to it. Where I will speak on the next slide in a bit more detail is the late disclosure of evidence, sorry, the late disclosure / evidence sections, and the victim identification section. And then the rest, again, speaks for itself in terms of dealing with disqualification, if you've got character issues, for example, leave to remain, recovery periods, and so forth. So just looking at the two really that are useful for this talk, but also crossover in how NABA affects refugee protection claims as well. So looking at late disclosure and evidence sections, so effectively the summary of these sections in the Act are that in claims concerning both refugee convention claims and modern slavery, there's a power under the Act, which is a new power, to send a notice, to serve a notice for the person to lodge evidence in support of their claim. The rationale for that is to try and sort of keep to tighter timeframes of processing of claims, putting really sort of an emphasis on genuine claims that can be evidence and so forth. But a consequence of such a notice is if you don't lodge so if you don't respond by the time that you're given, then the next power that can kick in, there is a discretion, is that the Secretary of State can effectively apply less weight, or can kind of draw certain inferences on the fact that either you haven't lodged any evidence or that you were late in doing so. And again, this is the rationale for this is to avoid repeated claims, fresh claims, where the evidence could have been obtained initially in the first asylum claim. Why couldn't it be available then? And to sort of avoid repeated claims that lead to repeated rights of appeal and thwart the government's sort of policy objectives to ensure higher removals and so forth. So that's the context in terms of these provisions. Why they're problematic really in the context of modern slavery is, first, we come back to the positive obligation to identify victims not being on the individual. So it's sort of contrary to that principle. Then the second bullet point is just really highlighting difficulties that we're aware of in the asylum context already, where there are recognised barriers to disclosure and self-identification. So there may be a lot of shame attached to the fact that a person was trafficked and effectively exploited, for example, on a sexual level. There may be all sorts of issues of gender tied up in that. There may be all sorts of issues in terms of fear of authorities, in terms of reporting it, disclosing all these aspects. A person, again, may have been impacted so much by their experiences that it's affected their mental health, and therefore their ability to disclose all of that. There may be avoidance, there may be self-denial, what have you. So all of that is carried forward, perhaps even on a heightened level, in the context of modern slavery. You have a third bullet point in terms of phenomenon of late disclosure, recognition of that in this context, but that isn't often really grasped or applied by the Secretary of State in dealing with cases. And just the reference to the case of MN. So MN is one of the major sort of, not groundbreaking, but again, one of the major cases that you need to be familiar with in this context of modern slavery if you are working in this area. Court of Appeal decision. It also has wider impact in terms of the assessment of expert evidence. So it's useful in outside of trafficking and modern slavery cases as well. The main point, again, as far as I recall, that was being taken in that case was whether victims of modern slavery and trafficking should be entitled to a heightened level of support at an earlier stage than they are otherwise. So effectively, when they receive, it was argued, when they receive a positive reasonable grounds decision, you'll remember that's the second stage after the referral to the first responder, you get a decision that's positively assesses you as a potential victim, and effectively the appellants were arguing that the enhanced level of support should kick in at that stage. That I think failed in terms of showing that obligation, so it wasn't successful in that respect. But there's a lot of guidance in terms of credibility, how to approach expert evidence in the context of modern slavery, but that has wider application as well. So it's a very useful case to go to. And then the other two cases, I won't speak to TVN actually, but VCL, another sort of major case that had to go to the European Court of Human Rights. So I'll just speak to that, and effectively that concerned children who had gone through the criminal justice system. So they had been apprehended and prosecuted for working on a cannabis farm, and had gone through the criminal justice system, so had pled guilty as part of those criminal proceedings. And then it was only at a later stage that there was an NRM referral that then identified them as victims of trafficking. The Court of Appeal case in VCL had looked at whether before I get to that, there had been, once there'd been an identification of them being victims, it had gone back to the CPS in terms of them conducting a review as to whether the prosecution should go ahead or not, and it had decided that it should. And so again, as far as I understand the case, in the Court of Appeal, the court was being asked to consider whether the CPS's decision to prosecute was justified or not. And as far as I understand it, Court of Appeal said that it had been, and then it went higher into the European Court of Human Rights. And as part of that appeal, as part of that hearing, there were findings that effectively meant there had been failures on the part of the authorities. There had been breaches on Article 6, so in terms of fair trial right, because had those breaches, those failures not happened, the victims could have gathered further evidence and so forth in order to show a defense to the criminal prosecution. So it's sort of, again, we see how all these bits and pieces of the various systems that we have in the UK in terms of criminal justice system, the NRM, and how all of this is tied up can really go wrong and actually fail those victims. So it's a very good case to go to in terms of looking at all of those obligations and really how to support those victims. The last bullet point just under late disclosure and evidence that I wanted to mention is in terms of access to justice. Really, we all know within this field that it is difficult to get specialist legal advice. It's difficult to get special legal advice that persons can afford to secure, but also problems with the legal aid regime and legal aid sort of advisor deserts and so forth. But also going beyond that, the trust and the rapport that is needed to, again, identify and help and support and try and achieve the justice that those victims should be entitled to. So again, it brings all of these sections in terms of the late disclosure and evidence and what weight to attach to such evidence or inferences to draw are problematic against all of these principles. In terms of victim identification, I'm just going to draw your attention to it. It's section 60. And sorry, let me just check actually where I didn't check whether section 60 is in force. I think it is, because I think all of the provision of the modern slavery provisions were brought into force, but let me just double check so that I don't do a boo-boo. Yeah, so section 60 was brought in force not too long ago, 30th of January of this year. So it amends section 49, changes the wording of the test for identification from having reason to believe someone may be a victim to is a victim at the reasonable grounds stage. Okay, so there's a shifting in terms of that threshold from the 30th of January of this year. I would have to delve into the commencement provisions to gauge whether there's transitional arrangements. I would have thought so, because there were under the protection claims in terms of new asylum claims brought in after, started after June of last year. And the provisions only apply from claims started from June. So I would have thought the same applies to modern slavery. So for now and for a substantial period of time, we'll have different, in principle, in theory, we'll have different burdens of proof, different thresholds for the reasonable ground stage. You'll recall under the NRM set out that it's effectively a lower threshold, that it's a suspicion that a person is maybe a victim. Section 60 amends at the reasonable grounds stage that they are effectively a victim, so the balance of probabilities really shifts to the earlier stage as well. So we will have sort of two different systems running for a while yet. So again, it'll be important to gauge that procedural history to see where you are at. To try and gain some time over our overrunning this morning, I'll just speak very briefly to this policy. So again, very hot off the press, so to speak. It was published on the 30th of January 2023, temporary permission to stay considerations for victims of human trafficking or slavery. Now, this is sort of long awaited. You heard Samina talk in terms of the case that effectively said that victims that are identified as such should be granted leave. And there's been just massive delays since that body of case law was established and gave guidance, and persons have been in limbo since. So this policy was long awaited, was hoped to sort of resolve any uncertainty in terms of how that would take place. And to a certain extent it does, but sadly it does also sort of restrict the remit a bit as well. And so again, the worrying sort of developments that we've had since the 2022 Act have continued. So effectively it's highlighting that the policy objective is to grant leave to effectively categories of persons, and you have those listed in the second bullet point. So allowing those who are cooperating with public authorities and effectively in their investigation or in their prosecution. And third category is if they are receiving treatment. So if they have been recognised as such, have been as victims, but also have been recognised of having suffered physical or psychological harm arising from that exploitation, and they need to have that recovery. So they may be involved in therapy, they may be involved in specific treatment, and so it's to allow those to partake in that. And then, third category is seek compensation, so a person who may be seeking compensation in relation to those acts. So 3 is cooperating with public authorities for investigation, prosecution purposes. Second, recovery / treatment. Third, seeking compensation. So really just 2 things to mention about that, really just in terms of practice. The first, in terms of the recovery category, what you find often though is from a therapy point of view, from which obviously not an expert on, but from a psychotherapy, from a psychologist kind of point of view, often victims can't really start to engage in that process meaningfully until they have any sort of other worries taken away, and often those other worries can be in relation to their status. So we've gone one step in the right direction in that often those persons didn't have any status because they were awaiting a grant, and if they hadn't secured that through their protection claim, again there was sort of a limbo period. So this policy does take us one step in the right direction in recognizing that, but often therapists' view is that they can't really meaningfully engage until they have permanent residence. So there were cases in the past, some years ago, challenging the grants of discretionary leave as it was then, on the basis that really a person had such issues to grapple with mental health wise, well-being and so on, that they needed indefinite leave to remain in order to be able to start that process. So I think just a flag there to see where that goes in terms of any future litigation. And what was the second point I was going to say? Yeah, the second point was more generally that there is, in the policy itself, there's no mention really of the sort of fear of being re-trafficked as perhaps a reason to grant leave. Now, arguably that may come, again, we have the interplay with the Refugee Convention grounds, but that's just something to flag that there may be some criticism in terms of this policy, and we'll just have to see how that pans out. Very briefly, in terms of Begum, as Samina introduced earlier, it's not a trafficking case in terms of the decisions that she was seeking to challenge. As we know, it's deprivation of citizenship. But again, last week with the judgment, it has brought to the fore again how much interplay there is with these sorts of issues. And so just in this slide, you have really highlighted just some of the findings some of the concerns expressed by the tribunal in SIAC. And that is effectively, as you have in the second bullet point, that there's a credible suspicion that she was trafficked, possible violations of the state's protective duties in the months leading up to her departure from the UK in 2015, which were not and have never been properly investigated. Again, credible suspicion that she was recruited, transferred, harboured, etc. And those are the terms that you heard Samina touch on in terms of the components, the acts and the means. And again, a reminder, this is from the judgment, a reminder again, an international crime, form of modern slavery, trafficking in the context of her circumstances. And then a reminder again in terms of consent being irrelevant because she was 15 at the time of her arguably being trafficked. So we just wanted to highlight that really because it is the sort of latest case to sort of grapple with these issues. And another interesting aspect of the case that you may want to delve into in more detail is that quite usefully, there was a lot of comparison in her case as it was run in SIAC with other cases of young women, young girls being lured away from the UK by ISIL in the context of the Syrian conflict, but where the authorities intervened earlier. So for whatever reason, it's obviously detailed in those cases, they did not leave the UK. And those cases were dealt with within the family jurisdiction. And those cases were, led to findings that the persons were effectively exploited. And the contrast was drawn in Shamima Begum's case in SIAC with the latest judgment last week between her case and those cases where the persons didn't leave, and the difference in treatment. So that's again just highlighting that's an interesting aspect of it, and just to see how different jurisdictions deal with it. Again, it's different because of the context of the deprivation decision, but it's really, again, shows the interplay between the different systems and how important it is almost to sort of have an eye on each one, so that either issues can be identified when you're dealing with it, or you can see potentially the differences in it and take that forward. So that's all that we wanted to cover and were able to cover in this session, and apologies again for running late as part of these talks this morning, but we hope you found that useful and can take that forward in your own practice.
Well, time for me to rejoin the fray, and thank you very much, Sarah and Samina, for stepping in at short notice and taking us through very thoroughly but concisely just about all there is to know about human trafficking. Well, maybe not quite, but quite a bit anyway. So thank you very much indeed. Now, we always overrun our time at these webinars, so nothing unusual there. And it's getting on for, well, nearly 1:25. I'll be generous and say, let's reassemble at 2 o'clock. That'll give us a slightly longer lunch break. And don't forget, folks, there's a panel discussion after we've had our afternoon break, so do hang in there. And we'll see you back at 2 o'clock. Thank you.
Thank you, Richard. See you in a bit.
Bye.
Thanks all.
Welcome back, everybody, and hope you enjoyed the lunch break and you're refreshed for the next session. And we're going to start off with Sarah Pinder again, who's going to talk about global mobility, that new raft of routes in the business environment. And she's going to look also at acquiring sponsorship licenses for those global mobility routes. So Sarah, welcome back, and over to you.
Thank you, Richard. So let me just share my screen, and use the right slides. Yeah. And sorry, that's not the right slide. Just bear with me. No, sorry. I forgot to. Minimize the others. So that should be the right ones now. And let's just start in presentation mode. Okay, so unless someone tells me they can't see my slides and can't see the title, Global Business Mobility and Sponsorship Licenses, we are good to go. So as Richard mentioned, well done for keeping with us. And hope you're not feeling too frazzled and jumping from one topic to another. So we move from modern slavery into a completely different world, which is, I think, one of the best things in our job, in a way. But does require some brain space to be left at 2 o'clock after lunch. So hopefully you'll bear with me on that front too. So yeah, I kind of, to be honest, quite slightly regret the topic in the sense that I added sponsorship licenses to quite a kind of meaty topic. So there's a lot of slides that I don't think I'll speak to in very much detail, and the sponsorship license may be more there for you to go back to, but we'll see how we get on. I did think it was useful to add because the global business mobility route has sort of brought in a whole new level of sponsorship licenses, and I'll tell you why in a minute. But also we have that sort of heightened as well because of Brexit. So many employers who wouldn't have ordinarily employed foreign workers, and I use foreign workers as a term broadly in terms of non-EU, non-EEA workers. So if they, were primarily employing settled persons, British persons, and persons from the EU/EEA, then they wouldn't have needed a license. But post-Brexit, post-end of TP period, they do if they want to employ new EU workers, for example, which a lot of industry areas will be needing. So that's why I thought it'd be useful to add, but it may be, again, if you have a particular need for training in this area, that you feed back to the organisers, and we could do a specific talk on sponsorship licenses on its own. We could do specific right to work things, compliance stuff as well, rather than tagging it on to another topic. So I'll leave that to you, and we'll see how useful this talk is, I hope, of some use. So that's the sort of intro that I want to give. I think it is relevant now to be looking at these things a bit more if you had avoided it up until now or only touched on it, just a bit. The main focus will be global business mobility routes. And I have added, again, I think I was feeling overambitious at the time, high potential and youth mobility, just again to make you aware of those topics. But again, I probably will leave that for you to delve into. And then, as I said, sponsorship licenses. So global business mobility is probably a term that you have heard now for some time. I think it got announced maybe a few years back and then came in sort of in some way and then was changed again in more recent changes in the rules. So effectively, they are temporary categories, so we'll see that none of them lead to settlement in themselves, which is I think one step in the wrong direction, but certainly one step in a different direction policy-wise, because really for a long time now work categories tended to carry the right to settlement, or was with a view to settlement after 5 years. The only change to that was with the ICT route, when effectively they took that out of settlement and also took it out of the route for long residence under 10 years, lawful residence. So it's sort of the first change really in sort of policy direction that we've seen in a long while in the business kind of immigration world, working immigration world. But 5 routes, we'll go through these in turn. So you have the list there. I won't read out the list because we're going to look at them in turn. Where you go to, though, before we look at each of those routes is effectively the immigration rules. And you have an overarching appendix, which is called Appendix Global Business Mobility Route. So if you see my cursor highlighting here, it's this one in terms of Appendix Global Business Mobility Route. That is hyperlinked, it takes you to it. And then under that, within that appendix, you have effectively sub-appendices with the 5 different routes. So it's a bit confusing because then those sub-appendices are also called Appendix Global Business Mobility Senior Specialist Worker and so forth, as you have in that list. So, you know, to adding to our frustration in terms of what the rules look like, that's one of them. So they're each under this main appendix, but you can then minimize each different section, as you know, from perhaps other sections of the rules in order to look at each one. And the other frustration, of course, is that none of the appendix are in sort of alphabetical order or anything like that. So, but have them tabbed if you go to them a lot. All of the appendices are kind of cross applying or are cross subject to the other general criteria, common criteria, which we're not going to cover in this talk. You should be familiar with that perhaps in other areas, but if not, go to those. It always, as you advise in these areas. So those include Part 9 in terms of general grounds, which you have their appendix skilled occupation in terms of particular job occupation and codes, appendix ATAS for technology certificates and so forth, and appendix finance for the maintenance requirements. There is an overarching guidance as well, which you have in the last bullet point, again, and hyperlinked again, for you to access directly if you need to. But as is with the trend lately with sort of Home Office policy guidance, it doesn't necessarily add much more to the rules in terms of interpretation and how to apply those. Doesn't give you much nuggets in terms of discretionary stuff, but it is an easier way to sort of navigate the rules in a way in terms of reading it in plain English in one document and so forth. So often it's a good a document to use for client kind of care purposes. As you can see in the slide, as I mentioned, none of these routes lead to settlement now. So it would be sort of in addition to other categories that a person would qualify for settlement. So in themselves, if you're here under a senior worker, global business mobility, that doesn't qualify you for settlement. Neither does it qualify sort of towards qualifying periods. So that's the second bullet point. So you can't kind of combo different routes necessarily to then get settlement after a certain period of time. That could be the case with obviously 10 years, but that would require you know quite a lot of switching, so would very much be case specific. Whether that stays or not, I think that's something to watch in terms of whether we can predict these things. I've seen in a different context in terms of family life, they have started to kind of do concessions and bring that within the rules that you can combine periods spent under the 10-year and under the 5-year route towards settlement. So there has been some shifts there. I think as a result of litigation, perhaps as a result of recognizing younger persons' rights, and so attaching it to certain sort of profiles and certain other criteria. But I think as we move into this route and how we see how it beds into practice, how well or how less it will be used, that may be something to look out for as to whether that will change. Another couple of points just in terms of general criteria. Dependent partners and children would also qualify, so they tend to now be included within the appendix, so it seems to be self-contained in that respect. You don't have a separate part for dependents and children like we used to have under the points-based system, in terms of tier 1, tier 2, tier 5, and then dependents were under part 8, I think, or part 7, I can't quite remember now, but it's all self-contained. So what we mean, again, should be familiar with this, but if not, what we mean by dependent partners and children is usually under 18 dependent children and partners, so spouses, unmarried partners living together for 2 years, that sort of thing. Allows switching. So that is one, again, positive move, is that it does allow for a certain amount of switching into the route, which is positive. So we start the routes now in terms of looking at the different categories. Now, I think it will quickly become apparent that there will be some that are much more useful to us as practitioners in the fields that we work in and with the type of client base that we have compared to others. So I will speak more swiftly in the less useful ones. But I think, again, it's fair to say with the ones that are useful or that we think will be useful, I think we've yet to see how useful. So again, this talk is sort of to try and make you aware of the different categories if you have sort of general inquiries from clients as to what their options might be. If you want to make more use of them, I think it would require quite a lot of sort of, client acquiring kind of work, marketing drives and that sort of thing. I may be wrong, and so please do correct me in the Q&A. It'd be useful to get your experiences and your feelings about this. But my feeling is that it does seem to be quite constricted still, in line with really quite a general restriction. One, again, that is difficult to see how that could last really with the business needs and the labour needs, but we've yet to see. So starting with the first one is the senior or specialist worker. So you have just the blurb on each of these categories at the start of the slide in italics. That's taken from the guidance, taken from the appendix in the rules. So it's for overseas workers who are undertaking temporary work assignments in the UK, where the worker is a senior manager or specialist employee and is being assigned to a UK business linked to their employer overseas. So this effectively is what has succeeded the ICT route under Tier 2, which is the intra-company transfer. So under the ICT, it would be well, there was a specific group for media organizations, but then a more general for any other company / organization based overseas, and they had an office in the UK, or they wanted to establish an office in the UK, so sort of set up some structure here in the UK, send in a worker who was employed in the sort of mother company, mother office overseas to work in the UK. So it's effectively that route, but is reserved to senior managers or specialist employees, as you can see. We will go into the eligibility criteria a bit more in detail by looking at the sort of common criteria across the routes in later slides. But as you can see in the sort of middle of the slide here, with this bullet point here, must be awarded 60 points for sponsorship, job skill level, and salary. Okay, so we'll look at that in a bit more detail in terms of what salary is required in the later slide, job skill level the same, and then sponsorship is effectively that you've got this COS that ticks all the boxes. This is effectively mirrored, this sort of whole point system is mirrored across the different routes. There are 2 routes from memory that require a lesser number of points, but effectively you'll see that mirrored all the others in all the other categories as well. It's all mandatory, so there's sort of little discretion, so we stick with the sort of same rationale that we've had for a while now under the points-based system. You either tick the box or you don't in terms of salary, in terms of job level, job skill level, and so forth. And then obviously there's common criteria again, which we are not going to go to, like the TB testing, available funds, appendix finance that I referred you to earlier. But here, maximum length of assignments under GMB routes, again, I'll take you through that in more detail later. Again, this is also, I will explain this in a later slide. In this category, you have an overseas work requirement. I'll tell you that I'll tell you what that involves in a moment. And there's no English language requirements. So a lot of these routes, again, one step away from the sort of direction that we had been in for a while, is that there is no English language requirement. So it is sort of perhaps an acknowledgement that there may be a need to sort of provide a route with less hurdles in order to meet the business and labour shortages that we do have. But nonetheless, you know, that's sort of a small kind of token or a small acknowledgement, I think, in the grand scale of things, compared to the fact that, for example, there's no settlement, the fact that it's quite specific salary requirements, quite specific periods of time that a person can work under. The last bullet point here I'm just going to flag is that there are still some transitional arrangements in place. Now, I'm finding it quite tricky to gauge how much this would affect actually our clients, but it's worth mentioning. It's in the guidance still, it's in the rules, I think, still. So for me, that means there must be some applicants that are affected, because usually the Home Office, I think, do have quite a good sense of those things. But if you recall, the ICT route was sort of changed a bit in terms of what salary bands applied and what the length of stay that you could qualify for under ICT and the maximum length of stay. And so that is continued through. So if you've got an ICT sort of switching into this category, that may be relevant. But that's all I'll say really about that now, because I think, again, it's quite client specific. So just giving you, again, just the nature of each route. This at first, I think, looks quite attractive in terms of a route, you know, a bit like the graduate route. You know, it has the word graduate in it. You kind of think of it as a feeder route from being a student or, you know, kind of PBS, post-study work, PSW, sorry, post-study work. But again, I think less so when you look into it, really into the nitty-gritty. So it's graduate trainee, and again, it's what it says on the can: overseas workers who are undertaking temporary work assignments in the UK, where the worker is on a graduate training course leading to senior management or a specialist position, and who's required to do a placement in the UK. Again, from memory, you need to have sort of your graduate training program approved effectively as part of your sponsorship. So it's going to really, I think, only be relevant for the sort of the bigger you know, city employers, you know, huge firms, huge companies, huge contracting kind of worlds, and less so perhaps for our needs and our client base. The third category is UK expansion worker. The term, again, is sort of what I've just said in relation to the graduate trainee route. Again, at first blush seems really useful. And I say that because effectively, again, the sort of the predecessor of this route, a bit like the specialist and senior worker route having a predecessor as the ICT, the predecessor to this one is sole representative. For those who attend the conferences on a regular basis, I gave a talk on sole representatives maybe about a year ago. I can't quite remember. It was either February last year or maybe October 21. I can't quite remember. And it was basically the route. I gave that talk shortly before they abolished the route, I think. So it was fairly short-lived in terms of application, but it had been a route that had been with us for years, for decades, and very useful, and at that time still quite underused. And it became more used when Tier 1 entrepreneur got binned as well in terms of new applicants. And then there was worries, concerns at the Home Office that the sole representative route was being abused, a bit sort of the same reasons carrying forward from Tier 1 entrepreneur. Whether that's right or wrong, I think remains to be seen. But this now is what has succeeded it, so UK expansion worker. And effectively, this is the only route, I think, in the GBM routes where you don't, the employer, if you like, the person who is sending the expansion workers, the company who is sending the expansion workers, doesn't have a trading office in the UK. So it is to, again, what it says on the can, to expand the company's trading area, trading operations and so on, and to set up an office in the UK to expand that company. So, you know, sounds all very good, but the difficulties are really in terms of evidential and really how much how onerous it might be for companies to sort of go through this route, which is, you know, fine in relation to bigger companies, but in sort of smaller family-owned businesses, I think remains to be seen again whether it's worth it. There may be no choice, and so that's why we're covering this, because we may be ones that have to sort of either encourage or, you know, talk companies through setting up what is needed in order to make use of this route. But effectively, it's the same criteria, so as I mentioned to you, in relation to the first, in relation to the first slide, in terms of specialist senior worker, same with the appendix, but here 60 points in terms of the same criteria. So the criteria was sponsorship, job skill level, and salary. What is different from sole rep is that, and what is positive difference, positive change in the right direction, is that you can send a whole team of expansion workers. So again, if you had a real drive as a company to, you know, to set this business up in the UK, then you can really just go for it in that sense, and kind of, you know, rather than a sort of drip approach by just sending one worker, which you would be doing under the sole rep category. It is up to 5, so a whole team, a team of 5, but compared to the Tier 1 entrepreneur route, a team under that route was a team of 2. So again, positive direction there. What I mentioned earlier, so prospective sponsors must not yet be trading in the UK. So that's the whole logic that you're expanding. I'm so sorry, my mouse is trigger happy today. But and this is what's just more complex, I think, perhaps, than it needs to be. They need to have established a footprint. Okay, what we mean by footprint is by registering the UK branch or subsidiary, so with Companies House and so forth, or by purchasing, leasing premises. So paperwork to do, basically. Paperwork to be done, procedures to be completed before you can really even kind of embark in this process. So that's a difference with the sole rep, so it is more onerous. Perhaps to counter the concerns in terms of the abuse of that route that the government held, but again, for the sort of smaller firms, for smaller companies, family owned, that can really turn, I think, a lot off. You may think, okay, well, purchasing, leasing premises, that may be less kind of paperwork, less onerous, but obviously there's a cost implication, front loading that. You don't know if you're then going to get your expansion workers in and so forth. So there's still quite a lot of risk, which may be worth taking, but may not be within the reach of you know, our clients. Sorry. Overseas company also needs to have been trading for at least 3 years, less for Japan. I'll stop using the highlighter and then we won't get into these problems. Less for Japan, so it's less time, I forget how much, but you just need to know less for Japan if that's relevant to your practice, and then look it up. And that's, again, I would have thought, to counter sort of abuses in terms of startups, or, you know, trigger happy businesses that look to expand and it doesn't work, and then, you know, they've got a foothold in the UK and so forth. Less for Japan, because there's I think a trade agreement with Japan that included some of these features, and I think that's why. So still, as I said, quite onerous. And then you need to also provide, so in the penultimate bullet point, you also need to provide evidence relating to your planned expansion in the UK, including business plans, marketing, market research, capacity to fund the expansion. So that's not dissimilar to, again, tier one entrepreneur, in terms of your business plan, what you were going to do, what you know, how you were going to do it. And there's no you know, minimum sort of investment like there was in the tier one. So it's sort of taking bits and pieces from old routes, and, you know, there's some good there and there's some bad there. So again, I think it will remain to be seen as to how this is kind of interpreted and applied in practice by the Home Office. But again, if we're going by old routes, you can anticipate quite a high level, perhaps, of skepticism, quite a high level of you know, doubt and concern expressed on the part of the Home Office in terms of you know, whether your expansion plans are realistic, whether you can afford them, whether, you know, you're going to have a sort of market to tap into, and that sort of thing, all perhaps with not very much knowledge of that particular industry. So again, if you're talking through potential clients in this route, you want to be, you know, you need to be present, you need to be you know, it will be quite intense in terms of the support, in terms of how much you've got to think about and impart onto your client for them to understand, you know, how useful it will be to follow your advice, because you want to preempt these points. You need to be able to show that good business plan, you know, that you've thought about these points, how you're going to counter them, in order to satisfy you know, the decision maker of those plans and so forth. And then the expectation that you will have established your trading presence. So that is effectively, once you've got your UK expansion workers in and they've come to the UK and they've started work on behalf of your company, the expectation within the sort of the route is that you've established your trading presence within 2 years. So that, again, that you'll see later, that carries forward into how long the expansion worker would get in terms of leave. It is sort of quite short term in terms of its focus. So, you know, is that going to be useful? Yes, to a certain extent, but you know, I think, again, for family-run businesses, it just may not be as attractive as perhaps initially thought. So that's enough in terms of expansion workers until we come back to the more common criteria. And I'm going to talk about the next two, fairly swiftly, because they are incredibly specific in terms of sectors, in terms of how you can qualify for them. So service supplier. So this is overseas. So this is the fourth category, overseas worker undertaking temporary work assignments. So again, you can see the temporary nature of this being reiterated over and over again, where the worker is either a contractual service supplier employed by an overseas service provider or a self-employed independent professional based overseas, and they need to undertake an assignment in the UK to provide services covered by one of the UK's international trade agreements that is currently in force or is being provisionally applied. Okay, so quite specific. One example of this that was actually given on free movement when it was looking at the route as it was then in place, so not under GBM, but it had its own, it was under the temporary work, I think, was, for example, if you've got wind turbines and they are in the UK, they might be owned by a company here in the UK, but the maintenance contract for those wind turbines is with a German company. And because of Brexit now, and you know, no freedom of labour in terms of, as far as the UK is concerned, then the contractors in Germany would send over workers to come and service the wind turbines. So that's one example of sort of that in practice. Again, as far as I've got no personal experience, professional experience of this route, but that's how it was useful for me to sort of conceptualize it by that example. Another example is in terms of the international trade agreement. So if there is a particular agreement for a service, so there may have been back in the day something, for example, with the Eurotunnel, which was, both governments, France and the UK, had shares in the Eurotunnel as a company. It may have been something within that could have played out in today's world post-Brexit. So that's the sort of thing, quite specialized contractual services, usually kind of engineering based, maybe financial services, that sort of thing, that cross borders, and that now within the European context require a visa going forward. So that's all I'll say about that. Sorry, the other thing I was going to say about that is that there is a specific nationality requirement to this route. It's quite detailed in terms of who and who isn't covered by it. So I didn't copy or paraphrase that for your slides, but look at page 21 of the guidance, and that guidance is the first guidance that I highlighted to you in terms of the GBM routes policy guidance. So the last category in the GBM routes is secondment worker. And again, sounds really good. Okay, a company could second a worker to another company and effectively establish links that way, establish a route for a particular worker to the UK or to gain experience in the UK. But it's very limited, I think, in scope in terms of really how much use we're going to make of it. So you just have that in the blurb at the top for overseas workers who are undertaking temporary work assignments, where the worker is being seconded to the UK as part of a high value contract or investment by their employer overseas. Okay, high value contract or investment, and we're meaning high value. Okay, so it's not just small kind of run-of-the-mill contracts. We're talking kind of millions of pounds type contracts. So this is for, again, sort of city high-end clients in terms of companies, and so I think we'll have limited application in our practices. The other thing I just wanted to mention very quickly, just again to sort of reinforce those points, is that the sponsor must have a contract with the overseas service provider or business. So effectively, the overseas service, the overseas employer, I think, is sending in the worker who's being seconded. But because they're overseas and they're not based in the UK, it's sort of the receiving, if you think of it as the receiving business, so who the person is being seconded to, it's them that apply for the, it's them that have to be the sponsor license holder and who allocate the certificate of sponsorship, okay? The contract between the two entities also needs to be registered with the Home Office, okay? So again, it's very specific, and so I think for now can be, I dare I say it, safely ignored for a while. And again, I'd happily be corrected on that front in the Q&A. So those are the 5 routes. And as you'll recall, I set out ones that needed overseas work requirements or not. And so that's what we're going to focus on in this slide. But effectively, it's because this route groups really movement of workers for whatever reason, whether it's you're kind of transferring a worker within your company structure, ICT kind of way, or whether you're expanding your business, so you're overseas, you're then establishing a trading presence for the first time and you're sending expansion workers. Whichever way, there's a movement of worker, either within a company structure, as I said, that's established, or, for example, between a sending business who's seconding a worker in a receiving business. So there's usually 2 entities, one that's either formed already or is about to be formed. So because of that, you effectively have this, what's become known, what is now known as an overseas work requirement. And because that spans effectively all of the categories, it's what I've termed as a common criteria. Okay, so you have the term business linked to the sending business, for example, because it might not be the same business, but it might be a business that is linked. So as you can see here, so a requirement establishes that the applicant is currently working for the sponsor or a business linked to the sponsor, and that they have a required amount of experience working for that business outside the UK. Okay, so they've either working for the business overseas, and it's that business overseas that is sponsoring, or it's the business linked that is sponsoring. So that's why you have sort of sponsor, business linked as terms that might mean different things. This is a subject, and I should have perhaps detailed it here as a note. So if you want to make a note against this slide, there's an exception to this, and that's if you are coming as a high earner in the senior and specialist worker route and in the expansion worker, I think. So if you're a high earner, which is I think 73 and a bit K in terms of your salary, then you don't need to have worked for the business before. But if you're not within those higher salaries, then you need to have worked for the business already and be currently working. Okay, and so that's again just this table here, which I took from the Home Office guidance, just summarizes that quite nicely for you. So really, I mean, I think this is probably the one that you would be looking at, and this one potentially as one where there may be more room to apply within our client base. And so the person needs to have worked in the business or organization linked to the sponsor by a common ownership or control. So it's again, you have a parent company, and then you know, they've got perhaps a UK office, and so under the senior specialist worker, they're transferring from one worker or several, whatever, from the parent to the subsidiary office. Or a business or organization that has a joint venture with the sponsor on which the applicant is sponsored to work. So again, you might have two companies coming together there. And under expansion worker, then again, it's, as we heard, a companies overseas that would be setting a footprint here in the UK, but effectively it's under the same company structure, same common ownership or control. Okay, so that's your overseas worker requirement. And in terms of the length, it's 12 months. Okay, so at least 12 months by the time of the application. And as I mentioned, sorry, I had included it, the exceptions to this is graduate trainee. Logic is obviously if you're within a graduate training program, you're kind of in a fast track training program to reach more senior management, and so you may not have been with the company for that long. You are exiting you know, your graduate program in your graduate degree into that program. But the other exception that might be relevant is a higher earner. Japanese national goes back to the trade agreement, as I understand it, and secondment worker has the ability to extend their stay. So again, that may not be in line with the 12 months. Okay, but effectively the most common exception for us probably will be higher sorry. In terms of evidence of the overseas work requirement, I've just listed that in the last 3 bullet points. It's just, it varies how you evidence it. So in those categories in the 3rd bullet point, so senior specialist worker, graduate trainee and expansion workers, you can effectively confirm that in the sponsorship of certificate of sponsorship, but otherwise it's a declaration in the form, and then the guidance says really that should be enough, but if you've got a concern you can request further evidence. So effectively, when we're talking about evidence of overseas requirement, it's more of a procedural sort of declaration done in different ways depending on what categories you're applying under, but it's all subject to, if they want further information they can ask for it. And then the two other sort of common criteria in terms of establishing points. So we've looked at the sponsorship aspect of that, which links to the overseas requirement. And the two others are job skill level and salary. Okay, so this slide looks at that. And so they need to be sponsored in an occupation code listed in appendix skilled occupation, okay, unless we're applying a service supplier, but that's probably quite unlikely. So we are still needing to be friends with appendix skilled occupations. So again, the sort of trawl through those codes, trying to make, not trying to make, but trying to match job specs, job descriptions, job titles with what's on that list can be quite a kind of craft in itself, and that I'm afraid is still with us. So one advantage if you're used to working in sort of tier 2 skilled worker route work, you're carrying that forward, and again, if you're looking to establish work in this area, that's one selling point for sure. Service supplier I'll leave, but as I said, there's their own specific criteria to establish in terms of job skill level. Okay, and salary, effectively, other than high earners, it's £42,400 for senior and specialist worker and UK expansion workers. So these two categories really go hand in hand. They're sort of virtually the same criteria all the way through, and it's only lower for graduate trainees. Okay, so you're looking at really 42.5k, just under, and if it's different attached to the skilled occupation, you're looking at the going rate. Okay, so by that, just to conceptualize that and just to put that as an example, if you're applying under the senior and specialist worker category, and I don't know, or sticking with my wind turbine analogy, you're a wind turbine company, and now that we're not allowed to, or there's very big regulations to build them in the English countryside, you need to be super specialist, and it's very technical. So the going rate for that might be 56k or 80k, whatever there may be. So it wouldn't be the salary that applies wouldn't be 42,400, but actually the going rate as set out in the appendix. Okay, so you've got to just be careful in terms of when you're advising in often sort of hypothetical and principle cases, when you're being asked for general advice as to what salary levels you're looking at. And again, you have 70% of the going rate for the graduate trainees. Okay, again, a couple of points just to run through very quickly. Just make sure that the salary also abides by these two criteria, which is just basically basic gross pay and some guaranteed allowances, and any packages that include accommodation, they can't fall foul of what's set out there, which I've paraphrased for you. And lastly, length of assignment. So we saw that was another common criteria. It's just set out there as a list for you. So you'll see it's quite disappointing in terms of the maximum periods of time. So the highest is 5 years is in any 6-year period, but effectively that is it can be through a combination, but 5 years in any 6-year period. And that doesn't mean it leads to settlement, as I mentioned. You know, the 5-year period we would have known as quite golden in terms of settlement rights. High earners in senior specialist worker route have a longer period, as you see, maximum of 9 years. That's reflecting the ICT route. When you were a higher earner within that, you could extend up to 9 years, just short of the 10-year period, again, to not allow those to qualify, even if it didn't lead to settlement, for settlement under the 10-year rule. But then you've got sort of maximum periods within different routes. So the 5-year period would be a combination. There's no 5-year period attached to one route, if that makes sense. So graduate, trainee, max 12 months, UK expansion workers, max 24 months, service suppliers, max 6 or 12 months, depending on the trade agreements. Secondment worker is 24 months. Okay, so again, you can just see that focus on the short term. So as anticipated, I'm going to be running out of time in terms of looking at sponsorship licenses in any great detail, but I'm just going to talk you through the slides in terms of what you can get from them going from now. Just sticking, last slide, I think, with GBM is the sponsorship requirements that are specific to that route. So as I mentioned, that's why I thought to add sponsorship licenses, because effectively, now that we have these different routes and so many different routes in terms of applying to different work categories, it sort of widened the sponsorship license scheme by, you know, quite some measure. We used to have a sponsorship license really just to employ foreign workers, overseas workers. So you either had it or you didn't. And if you had it, you were either A-rated or B-rated, and that was it. And the only distinction between sponsorship licenses before were education providers that had a sponsorship license for education provided purposes, or working purposes, as I mentioned. Now you have to hold a license according to the route that you want to sponsor in. So in the GBM route, you've got 5 routes. If you want to sponsor an expansion worker, you need to hold a sponsorship license in the expansion worker route. But if you also want to sponsor under the senior specialist worker route, the old ICT, you need to hold a license on that. So effectively, a big employer or an employer who has a sort of quite a varied, you know, a company that has quite a varied company structure, for example, that might sort of multi, you know, business operations going, you need to hold different licenses. And so that is, you know, quite something really to grapple with, particularly in tandem or caused by the effects of Brexit. So that was really to highlight that, and then you just have some other guidance, and the role must be genuine, and those sorts of principles carry forward from older routes as well. So this is where I've included a few slides now on sponsorship licenses, so I'm going to talk you through them now. But we won't be able to spend as much detail on them as I had hoped to, and I'm sorry for that. But effectively, you know, these are checklists for you. First, perhaps to assess whether you want to undertake this work if you don't already, as a refresher if you do, but also in terms of looking for that work with companies, with businesses who are not licensed already. And so I think this will be useful as sort of that starting point. Check if a business is eligible, check what the vacancies are, because often it's tied together. An employer is going to make inquiries about licenses when they want to look to employ a foreign worker. They either have someone in mind or they anticipate very soon to need, you know, a high injection of sort of labour. So those are a few points in terms of how to register as a sponsor, but more in terms of, you know, what you need to think about if you're kind of looking to embark on that. In terms of the guidance on the right hand side of the slide, I've just set out some points there. In terms of the authorizing officer, we'll look at that in the next slide. Sending documents, correct formatting, correct fees, timelines, which are more or less, I think, being stuck to because of the needs at the moment in the business world. And then certificate of sponsorship, the terms have changed since, you know, the license scheme has been sort of overhauled a bit, and we're now looking at defined and undefined as opposed to restricted and unrestricted. Okay, so defined is when you're applying for a sponsorship license in order to employ one person in particular, for example, and then once an employer is licensed, they might then be applying for a number of certificate of sponsorships in order to allocate them as they need to. So that would again depend on the company. Managing the sponsorship management system, so SMS, just highlighting the different roles within that, both within the UKVI and in the company themselves. And then on the right hand side, just highlighting really where those persons need to be, but also where you might come in as the immigration lawyer. You can't be the authorizing officer within the company, but you know, you can be talking them through all of this and making them aware of what will be needed. And the last point I've just put here is think of mock audits as due diligence. So in a way, it's just sort of sowing the seed early with clients that if they're thinking of applying for a license, they need to understand really the sort of the sponsoring duties and obligations, the HR implications and all of that. And if you are helping them all the way through that, you need to be confident really that they understand those and that they, you know, that they're sort of going to take your advice on board as you go along. And we all know that, you know, however much a client says yes sort of at the start, you know, you might encounter difficulties as you go along. So one way in the sponsorship license world to do this is to undertake mock audits at the start. So if you're familiar with the process, conducting a mock audit as if you were the Home Office in inspecting them, and then you then point out all the things, you know, that they would actually fail on or that would be a cause for concern. And again, I think that's quite a useful way to get the client to understand, you know, what this sort of process would involve. And then a summary here of the reporting duties, record keeping, what expectations there are on sponsorship license holders to cooperate with the Home Office and so forth. So it's really just all there as a summary. So by no means every aspect of it, but hopefully something there as a starting point. And again, what the compliance visits entail, why they're useful, when they would happen, and a summary there for you. Useful resources at the end, all hyperlinked for you to go to as well. So that's all I can cover for sponsorship licenses. High potential, I just thought to include because there are two categories together with the youth mobility that are, youth mobility is not new, but it may be new in the sense that India has just been added, so there may be added inquiries from Indian nationals. High potential is new and concerns effectively graduates from top overseas institutions. So it's there. I covered it, I think, last time round, but I've just included the slides again in case that's helpful. But it's not to be confused, as I set out here, with the graduate route. Okay, so high potential is for graduates at non-UK institutions that are part of this global universities list, and they can come to the UK. It's not sponsored, so that's the other advantage. You don't need a sponsor. They can come to the UK and work, and it's sort of like the graduate route, but for those who were not UK based. And then youth mobility I added because India has been added to the list of nationals. So you have all the list of nationals there, and there's, I think, 2.5K, I think, places, I can't quite remember now, announced for India. So that may lead to inquiries, but it's a ballot system if I recall correctly. So yeah, that may or may not affect the nature of the inquiries that you get. So I'm sorry that it's such a whistle-stop tour, but I hope it was useful for you to gain an understanding into the GBM routes, and then what that entails sponsorship-wise. And I'll leave it there, if I may, and return over to Richard. And then if there's, I think there are some Q&As from this session, we'll be able to answer them when we get to the Q&A panel. So I'll look at those in the intervening period.
Well, thank you very much indeed, Sarah. You did indeed have an awful lot of information to convey, and you did so very well. And of course, we've got your slides that we can look at again at our leisure. So thank you very much indeed. And now we've got Sonia Ferguson, who was about the first person here, and she's remained with us throughout. And now at last, it's her turn to give her talk. So Sonia will be talking to us about Article 8 and proportionality, something which should be familiar to just about everybody, but we'll be looking forward to getting some updates on it, Sonia. So I'll go over to you, but just to remind everybody, after Sonia's talk, we'll be having a tea break and then a panel discussion. And how long the tea break is, well, let's see what time it is when Sonia finishes. So over to you, Sonia. Thanks.
Thank you, Richard. Yes, I hope I can be brief and not cause us to overrun. But I'm not also going to share my screen with you. Hopefully you can see the notes as part of the general pamphlet. And I've also included a decision that's forming the sort of basis of the talk, which is a reported decision of a presidential panel from last year that I was involved in. And I think the reason this was reported is because it provides an overview of the proportionality assessment and the origins of that. And then I'll finish up perhaps by expanding into different areas. I won't go into too much detail about Chikwamba, because I know that's something that Richard is going to be talking on immediately following. But yes, essentially this was a case that was it was actually an asylum case, and the appellant was a young Albanian man who had been well, it was accepted that he had been a victim of modern slavery in his home area. He came to the UK as a minor, and his case was undecided for a long time. He was not given unaccompanied leave as an unaccompanied asylum-seeking child, nor was he given any leave on the basis of his accepted trafficking claim, which, as we heard earlier, nowadays would mean some sort of leave following KTT should result from that. So we challenged this decision on two grounds. The first was that since it was accepted that the appellant had been a victim of modern slavery in his home area, it was incumbent on the tribunal to assess to what extent the non-state actors would be motivated to pursue him in the event that he was to internally relocate elsewhere in Albania. And this is particularly relevant for Albanian cases because it is such a small country geographically and in terms of population. And as you probably know, the country guidance does rather suggest that it is possible to find a person anywhere in Albania if the non-state actors are sufficiently motivated to do so. So as regards the asylum claim, it succeeded on that quite narrow basis, but the decision in respect of that was otherwise not disapproved of by the panel, but they most decidedly did not approve of the judge's approach to the Article 8 assessment, which, as you can see from the title, was characterized as a points-based assessment, which, as we might see in other cases, for example, Sarah's talk, that is very much applied in certain routes, but has been roundly disapproved in the general proportionality assessment. And I think I'm going to take you through the decision, if you don't mind. And I don't know if you want to refer to it as well, or whether I can just take you to the sort of salient points of the, certainly turning to the proportionality. I think I will skip over the bits relating to the asylum claim, because I've already just covered that in précis. But starting at paragraph 45 of this decision, which begins with the Article 8 assessment, our objection was that in order to be fully Article 8 compliant, the proportionality assessment outside the rules has to be flexible enough to take into account anything that might tell in favour of a particular appellant. And insofar as the judge had awarded points to any particular factor, that was criticised on two grounds. The first is that it's a bit arbitrary as to quite how one decides what points to attribute to any particular factor, and that in doing so, perhaps a notional limit is set on that, which is anathema to what the Article 8 assessment is supposed to be. So you'll see there it is at paragraph 45, that it's arbitrary but also insufficiently flexible to amount to the sort of outside the rules catch-all assessment that Article 8 needs to be fully compliant. So starting with the evolution of the balance sheet approach, it's set out that Lord Thomas was concerned that a structured approach had not always been applied to the balancing of factors under Article 8 by district judges hearing cases under the Extradition Act 2003. So this is the origins of judges needing to balance factors under Article 8 in favour of the state's interests, if you like, and the individual interests. So he starts by saying it's important in our view that judges hearing cases clearly set out the analysis of facts as found, and set out in succinct and clear terms adequate reasoning for the conclusion arrived at by balancing the necessary considerations. And then it goes on to consider Hesham Ali. And it's perhaps important to note there, this is at paragraph 48, that at that point in time, the court was not concerned with Part 5A of the 2002 Act, which, as we know, has again subsequently changed perhaps the nature of the proportionality assessment to some extent, or reduced the scope, the discretion, if you like, on the tribunal insofar as it sets out that regard must be had to all of the features at section 117B. And again, this bleeds into the Yunus and Chikwamba arguments about the scope of proportionality and to what extent the tribunal is constrained by the various factors that case law tells us they must have regard to, and what that means in any particular case. So, for example, we were talking earlier about Chelik and how, as it currently stands, although the position has now changed in that the Court of Appeal have given permission on this point, that it was previously said that people in the position of Mr. Chelik could not rely on proportionality because on the face of it, they didn't come within the withdrawal agreement at all. It would be very interesting to see what precisely the arguments are that are being run, but it seems to me that in terms of whether or not an appellant who is a durable partner can come within could come within this rather turns on the wording duly attested, and whether that must mean the issue already of a residence card, i.e. they have been recognised, their relationship is attested by the Secretary of State, or whether or not the tribunal itself has some role in assessing that. And it seems to me that that's a way that they could be brought within the withdrawal agreement, even though they are not technically family members. They could come within that if it was accepted that their relationship was durable at the relevant time. But we'll have to wait to see what the Court of Appeal finds in relation to that round about Easter. So anyway, back to proportionality and the assessment of it. In this particular case, the court, in passing, note that Hesham Ali, it was not concerned with either Section 117B or in the relation, in the context of deportation, Section 117C. And this is a good example of how rapidly the law has evolved really in less than 10 years in terms of proportionality and the different factors that all need to be brought into consideration, and the sorts of factors that are or are not capable of having weight legitimately attached to them as part of any proportionality assessment. So the point is also made that it's certainly useful for appellate courts to understand the reasoning of the judge, and this is partly why Lord Thomas's comments approve of the balance sheet approach in the first place. And of course, the point is made in this decision that the balance sheet approach may have sort of sent the judge down the wrong course, in that it implies some bookkeeping or numerical value being ascribed to any particular factors, or perhaps put a numeric value on each factor, whereas there's nothing at all in the evolution of the proportionality assessment and the balance sheet approach that suggests that it does need to be done that way. In fact, it's quite the contrary. All that the panel would say in this case is that the balance sheet approach merely means speaking of factors that will and will not count in an appellant's favour, and there's absolutely nothing in the evolution of that does suggest that actual points were supposed to be awarded in relation to those features, because as we've said, this is obviously very different from an application, a points-based application, other parts of the rules which would make it very much easier to award points for salary, points for a degree. When it comes to Article 8 rules, it's far too nebulous to say this should make that point ultimately results in a decision that isn't or an approach that's not compliant with Article 8. So as is said here, the summary of all of this is that the Article 8 proportionality assessment outside the rules needs to be a broad assessment, because it's clear that from Hesham Ali onwards that Article 8 is supposed to be incorporated within the rules, and that is the most sort of commonly occurring instances where it would be a breach of Article 8 in terms of private or family life, and the exceptions to deportations within the rules, for example, are an example of it being codified in the rules, but there still needs to be the scope for exceptions to that, and that's what the outside the rules proportionality assessment is supposed to be. And the panel in this case said that the most obvious reasons that the points-based approach would not yield an Article 8 compliant assessment is the idea that I mentioned before. This is at paragraph 63, that imposing a self-imposed limit on the amount of weight that can be given to each discrete factor is will risk producing an unlawful result, because it must be notionally open to the judge to give any factor the amount that he thinks it requires on those particular facts, it being a very always fact sensitive assessment. So he can't limit in that way, and then it also risks arbitrariness by not allowing for the possibility that individual factors interact together to create the sum of its parts. And that's an idea that you see when we talk about the sliding scale or something similar to that in asylum claims or interpretation. We must always be alive to play between the factors rather than just thinking of them as completely discrete factors. It's clearly the case that people with more vulnerability, more risk factors, there needs to be less of them for a breach to be met, and that is what the sliding scale suggests. And I think that is what was said here, which is that the judge mustn't limit the way in which the factors can interact with each other. And there's also the question of this double counting, which I'll come to in a minute, but I thought we might touch on delay, because this is one of the factors the tribunal got quite exercised about, which is to say that I don't think they liked the judge's initial approach to delay, which was to say that he would deduct a point for every year of delay, because in the first place, as we've said, there isn't obviously delay needs to be quite significant. It needs to be explained and unreasonable before it factor in itself to which weight can be given. So the fact that in the first 1, 2, 3, 4 years a claim hadn't been decided, that may well not be in the unreasonable category. And so the idea that points should be sort of deducted against the Secretary of State's interest in immigration control or the maintenance of a fair immigration system is prejudicial to the Secretary of State until such time as it gets to being excessive. So it was clearly wrong from the outset, from the tribunal's point of view, in that respect. And at paragraph 66, what Lord Bingham says in E.B. Kosovo is set out, which says essentially three ways in which delay might be something to which weight could be given in the proportionality assessment. So the starting position is there is no specified period within which or at which time an immigration decision must be made. The facts and with them government policy may change over a period, as they did here, and the duty of the decision maker is to have regard to the facts and any policy in force when the decision is made. So that is the starting point. But it does not follow that delay in the decision-making process is necessarily irrelevant to the decision. It may, depending on the facts, be relevant in any one of three ways. First, the appellant may, during the period of any delay, develop closer personal and social ties and establish deeper roots in the community than he could have shown earlier. The longer the period of delay, the likelier this is to be true. To the extent that it is true, the applicant's claim under Article 8 will necessarily be strengthened. It's unnecessary to elaborate this point since the respondent accepts it. Delay may be relevant in a second, less obvious way. It gives examples of people who enter into relationships knowing that the one party's position is precarious. A relationship so entered into may well be imbued with a sense of impermanence, but if months pass without a decision to remove being made and months become years and year succeeds year, it is to be expected that this sense of impermanence will fade and the expectation will grow that if the authorities had intended to remove the applicant, they would have taken steps to do so. This result depends on no legal doctrine, but on an understanding of how in some cases minds may work, and it may affect the proportionality of removal. And then finally, delay may be relevant thirdly in reducing the weight otherwise to be accorded to the requirements of firm and fair immigration control if the delay is shown to be the result of a dysfunctional system which yields unpredictable, inconsistent and unfair outcomes. And as I said before, this needs to be moving into to be in this sort of dysfunctional category. It would be a delay of many, many years. And even, for example, I've cited it at paragraph 9, delay without more is unlikely to amount to much. And this is from the Hisaj Deprivation of Citizenship, the UK UT 2020. Essentially, that is for a class of appellants who the Secretary of State did not for a long time tell them that their citizenship was they were going to be deprived of their citizenship, because the position she initially took was that in fact they were never actually citizens. And so initially the Secretary of State was pursuing the nullity argument, and it took quite some time for that to be resolved, and only then did she start to bring deprivation proceedings against those people for whom deception was said to have been used in their grant of citizenship. And so the fact that the Secretary of State was pursuing legal advice and deciding what the state of the law was in relation to these people did not mean that the delay in dealing with their cases was unreasonable or irrational or moved into the sort of dysfunctional category at all, because the Secretary of State was clearly entitled to clarify those points before deciding what in legal terms was the correct way to deal with them. So as I say, delay isn't usually a very strong footing for an applicant, but there may be circumstances where it is, as most famously said by Lord Bingham in E.B. Kosovo in these three ways that I've just referred to. And we said that this was relevant for our particular applicant or appellant, because he, as I said before, he did not ever get leave as an unaccompanied asylum-seeking child. And even though he was found ultimately to have been a victim of modern slavery, I think the policy at that time was to wait for the resolution of that before the asylum claim was concluded. And this is why it took 4 years for his case to be decided. But we said, because he was a minor, because he was an accepted victim of trafficking, because it would seem that the policy was actually prejudicial to him, and as I've said, it has now subsequently been confirmed that people in his situation should be granted leave pending the consideration of their asylum claim, while, when it is accepted that they were victims of trafficking. So for all of these reasons, we said in his particular circumstances, the delay, in the most general terms, that would also be the application of policy, or the fact that he was treated less favourably than people who ostensibly were in a less strong position than him, were reasons why greater weight should have been given to his private life during that time. And obviously, it's not always the case that there are sufficiently strong Article 8 grounds to be raised in an asylum case necessarily anyway, but in my view, this is, and it is an example of a time where Article 8 does come into play, and the tribunal did accept that much fuller Article 8 consideration should have been implemented in this case, instead of which the judge basically looked at it in terms of whether or not there are very significant obstacles, having found that the asylum claim didn't succeed, nor were there likely to be very significant obstacles. And he then didn't really look at Article 8 outside the rules at all, or in terms of, this is at paragraph 69, he says he might have had regard to the delay in deciding the asylum claim, but he'd already given that weight in reducing the public interest in immigration control. So that sort of suggests the difficulties of trying to separate out and not do a holistic assessment of all of the factors. As a consequence, it meant that all of the time the appellant spent here as a minor, quite legitimately, given that he did have an accepted trafficking claim, we say that his private life in that time, particularly attending school and so on, were factors that were capable of having more weight attached to them. In fact, it was right that more weight should have been attached to them, and the tribunal accepted this. So finally, what they've said about the judge's approach in this case, that it's impossible, at paragraph 67, it's impossible to reconcile the judgment of Lord Bingham with the first-tier tribunal's mechanistic approach of deducting 1 point for every year of delay in the decision-making. And this is not just because simply 1 year or 2 year taking to decide an asylum claim no longer seems remarkable in any way, and upper tribunal is not going to want to say that that is moving into sort of dysfunctional territory, nor clearly can it be seen to. But so for policy reasons, I can see why nobody would want to suggest that 1 year can be deducted for every year of delay. But it's also significant in terms of actually looking at what has happened in that time and what the private or family life of the person concerned, how that would change. And merely deducting a point for every year fails to address the sorts of factors that the judge would need to be looking at in terms of the private life, particularly private life formed during that time. And in conclusion, for the avoidance of doubt, nothing we have said should be construed as casting any doubt on what we have called the classic balance sheet approach. On the contrary, that approach has been specifically encouraged in the immigration context by 2 Lord Chief Justices, as well as a former senior president of tribunals. Its use enables the reader, including, importantly, any appellate court, to see readily the factors that the judge has considered and how these have been assessed. So now that concludes my discussion about that, but of course I'm very happy to answer questions. I then moved on briefly to part 5A and proportionality, which I know that Richard is going to talk about, so I'm not going to tread on his toes too much, but simply as Eunice instigated and has now been approved in the Court of Appeal, it really isn't, it doesn't fly anymore to say that this application would succeed from abroad. Therefore, there is no requirement for the appellant to make the application from abroad. Certainly since part 5A and the requirement to have regard to all of the factors set out there, it's very much more difficult to argue that maintenance of effective immigration control can effectively be overlooked because this would succeed from abroad. And as the point is made in Alam, Chikwamba was a very strong case, and the policy in force at the time was far too rigid and inflexible. It was also the case that Chikwamba predates Part 5A. It actually also predates the sort of codification of Article 8, both inside and outside the rules. As is said at paragraph 106 of Alam, that when Chikwamba was decided, there was no provision in the rules which dealt with Article 8 claims within or outside the rules. By contrast, by the time of the decisions which are the subject of these appeals, Appendix FM dealt with such claims, and paragraph EX1 of Appendix FM provides an exception to the requirements in Article 8 cases if the applicant had a relationship with a qualifying partner and their insurmountable obstacles to family life abroad. So that quite clearly shows the development of the case law since Chikwamba, and unfortunately that feature is just a factor amongst many now to be included in the proportionality assessment, and it certainly doesn't give any kind of steer that the appeal should be allowed, notwithstanding the public interest in the maintenance of effective immigration control. And then, as I alluded to at the beginning, what scope there is for proportionality in EU appeals is uncertain. Normally, it's the case that, as Kezia said earlier, that normally one would not rely one cannot rely on human rights in EEA appeals generally, unless there's been either a Section 120 notice, or perhaps it's possible to expand that by talking about grounds of appeal, or certainly it needs to have been flagged up at a much earlier stage that these were going to be relied upon. I think the argument can be made that normally this is because what is an issue is whether or not someone's entitled to documentation or a residence card, rather than there being any prospect of removal necessarily. And certainly Chalik did not allow for any possibility, not only of human rights or the concept of proportionality, but as I say, that is actually being appealed in the Court of Appeal, and so how the upper tribunal will be dealing with these sorts of cases in the meantime, I'm not sure. I think a stay would probably be the best way to go, given that Chalik certainly won't help, and we don't want to rely on that as a sort of definitive statement of the law for now. It does seem to me arguable that certainly for durable partners who have good claim to say that they can show that they were durable partners before the 31st of December 2020, may still be able to bring themselves within the scope of that, because there needs to be a role for the tribunal to examine the lawfulness of all these decisions, and that may extend to whether or not this person was in fact a durable partner at the relevant date, and that it's a problem if the Secretary of State in granting or not granting a residence card has sort of definitively answered the question of whether or not that person is entitled to any protection at all under the withdrawal agreement. So we have to wait to see what happens there. But I don't know how where that takes me to in time, Richard. I know we were overrunning, and I'm sort of happy to finish up there, unless, as I say, people want to ask questions now, or...
Well, maybe we could save the questions for the panel discussion. I see there's been quite a few questions put in the Q&A box, but maybe we could also use the opportunity for people to put questions to you on what you've just been talking about. Otherwise, I mean, we could, if you'd like to just answer the questions now. I don't think there's anything specifically for you in the Q&A box at the moment.
Well, I don't know how long I've been talking for, and I know that we started at a different time. I'm very much in your hands if you would like to, for me to pause now and us to go to the panel discussion shortly.
Oh, okay. Well, as we are running considerably over the scheduled time, why don't we take a break now? It's getting on for 25 to 4. And if we come back at a quarter to 4, we can have, say, 20 minutes or even up to half an hour for the panel discussion, depending how it goes, if we have enough interest. And then I can finish off with my talk. Okay, so shall we do that, folks? Come back at a quarter to 4 and refreshed, and we'll have that panel discussion. Okay, see you then. Thank you. Well, hello again, everybody. Very punctually, we're back at a quarter to 4, and the panel is assembling. We've got Sarah and
You have
Samina,
me.
hello. And Sonia. And, oh, I think that's about it, actually. I wonder, should we maybe start by just going through the Q&A box and just answer each question in turn? So better start at the beginning then. And we've got quite a few questions now. So I'll just shoot up to the top. Oh, have I got there? I think I have. Yes, okay. So we have a question from Muazzam Chugtai. Can, yes, ECO and Ahmed be argued in cases where applicants selected the incorrect category on an application form, but their cover letter stated the correct category and the basis of application? Well, actually, that question was answered, I think, yeah, during the course of the talk. So, so Samina, you would like to answer?
I think, did you say Kezia had answered that through the talk? So
Oh, yeah, she had, yeah. Oh, I just saw Samina would like to answer this question live.
Oh, no, I just thought I'd answer live because I'd put it so that everyone could see it. I don't know if everyone can see the questions if we're answering it.
Okay.
So I just thought I'd transfer it in the live box. No.
Oh, I see. Yeah. Thank you. Yes. Well, that was answered by Kezia, and the answer is yes. You can try that. Okay, that was simple. Now, excellent presentation, Kezia, from Tajamad, but I hope she gets that. So, quick question: can a non-EEA national who recently married his Irish partner in the UK, relationship started after the 30th, I think you mean the 31st of December 2020, still apply for pre-settled status under Appendix EU? There is a shaking of heads. No. Would it be safer to apply as a partner, leave to remain under the immigration rules in the light of Chelik? Yes, at the moment anyway. But besides, I mean, even if Chelik was reversed by the Court of Appeal, it would still be too late because the relationship didn't exist before the end of 2020. By the way, the Irish partner in the UK would have indefinite leave to remain. Irish citizens get that when they come to the United Kingdom. So she's settled here already. So she could sponsor him under Appendix FM as a settled sponsor. Okay.
And I just was going to say in relation to that, it is the case that an EA national with pre-settled status can sponsor a partner under the immigration rules.
Yeah, that's true. It's an Appendix FM now, isn't it?
Yes. So that's a sort of obvious route for people that are not able to, the relationship wasn't formed before the relevant date, December 2020. So in this case, it doesn't seem that he can possibly rely on that because the relationship only came into existence after that. So I think it would have to be on Appendix FM.
Yes. Certainly the fact that a pre-settled status, well, somebody with pre-settled status can sponsor a spouse or partner, that's an exception to the general rule that you have to be settled before you can be a sponsor. So that's very useful to be aware of. There's another question. If applied under Appendix EU, would anything change in case of, I think the Irish partner didn't complete 5 years residence? Well, that's not necessary for an Irish partner to be settled and doesn't earn, well, 18,600, an application under the rules would require that. And we're talking about an application under the rules here. It's not possible to do it under Appendix EU. So that's it, really. It has to be an application for leave to remain under the current regime. Okay. So let's move on to the next one. And this is from Muhammad Enamul Haq. can an applicant make a family permit application from overseas still now as dependent parents? Oh, that's right. Yes, because the relationship existed before the end of 2020. So dependent parents can be joining family members.
The only thing I would say is that they would have to show dependency, whereas before it was assumed. So that if you look at the table in the guidance, it will tell you exactly what dates, from what dates you would have to have shown the dependency rather than just assuming it. And I think, I can't remember, is it the June date? It's from June, isn't it? 2021.
Yeah, 1st of July. So up to 30th June,
yes.
you're okay. And then the next day.
Yes, from the 1st of July, you have to show dependency. That's right. And they want continuous dependency, but I think that just means, well, it has to start before the end of June 2021, doesn't it? Or does it have to actually start before the end of 2020?
What, the relationship?
Oh, well, the
application.
dependency. Does that have to be shown before the end of 2020?
The date of application, I think, yeah.
Yeah, I think date of application. I think there's a debate. So people are asking, like, at what point? But with the relationship existing before, I mean, it's safer to show from before. So
for the parent, it would.
Yeah,
but maybe the dependency, as long as it's before the end of June, rather than the end of December 2020.
Yeah.
Yes.
And obviously just show as much dependency as possible, just to be on the safe side.
Yeah, to be on the safe side. Fine. Okay. Oh, now here's an easy question. I think Samina would be able to answer this one. How much does a judicial review application cost?
I want to say 154, but I could be wrong. That could be really old.
Yeah, I think that's still right, though, isn't it?
Yeah, I think so.
For the initial application. Yeah.
And then 300 and something to renew, something like that.
To renew.
Yeah, and yes. And
Google it.
Then if it's
There's a quick guide somewhere.
If there's an oral hearing, it's 700 odd pounds, isn't it?
Yeah.
Yes.
Yeah, you're right. Yeah.
Okay. What is the certificate of service form called?
Google it.
TT 485, something like that.
Yeah.
I think that's a TT 485.
Yeah, I can't remember.
I
Google
think I wrote
upper tribunal.
I think I have put it in the slide somewhere. But yeah, and
it's on the slide. I think it's T485.
Yeah,
the name of the form.
It's to do with Rule 30, I think, if my memory is serving correctly. So yeah.
Now here's another one about JR, again from Mr. Chugtai. Have you seen any recent successful JR on delay in appeal implementation? Or JR either had a permission refused on the basis that respondent was actively working to implement decision based on their statement in the acknowledgement of service, or we were successful to agree a consent order pre-permission decision. I'm not quite sure. There seem to be two different things here.
Yeah. So I think, I mean, in implementation, JRs, I've had two different successes. One is I've had consent order. So I've had agreement pre-lodging, so just after the pre-action protocol, so same as this one. And then we've had another decision pre-permission consent order, but then the consent order was breached, which led us to nearly issuing a JR against the breach of the consent order. So I think it just depends really. They may well, you could be chasing them constantly and they constantly change the goalpost through the response to your pre-action. And they will change the goalpost even post-service of grounds. And you may give them time, but yeah, it sometimes is the case where even once they've agreed to undertake action within a certain period of time, they don't, and then you're left with the taking further action in the form of a fresh judicial review.
Yes, yes. Oh. Well, delays of one kind or another beset us all the time.
Yeah.
Okay, let's see what comes next. Oh, and here's another one from Mr. Chugtai. A late question for Jamila. Oh, well, it'll have to be Sarah or Samina. Oh, my cursor's moved. Here we are. One of our clients has been served with a public order disqualification notice under Section 63 of the Nationality and Borders Act. So that's, oh, in fact, I've got the name of the section here. Yep. Identified potential victims, etc. Disqualification from protection. So this person has been disqualified from being from taking advantage of the Modern Slavery Act because he's got a signed deportation order and he had 14 months imprisonment. How best to respond to this notice? Any useful suggestions?
I can take that one if you want.
Please.
Look at the starting point would be look at the guidance. So the statutory guidance that was included in the slides. I think it was in one of the slides that Samina spoke to at the start, or the useful resources. I can't quite remember one, either the slide in the middle or at the start. And there's a whole annex part. I think it's the annex to that guidance on the public disorder exclusions. And I think there's two kind of points, I suppose, to look at this procedural sort of guidance in terms of what evidence, what inquiries they should make, what evidence they should, gather or base their decision on. In this case, it would very much depend on what they have, what they've come forward with in terms of the basis for the exclusion. And then the guidance also covers in terms of what factors should be taken into consideration when they're balancing the public disorder issue. So you need to be a threat to the public versus the protection that you should be having as a victim. Usually the guidance also says that obviously the threat to the public it'll take a lot to outweigh the threat to the public, but it's not impossible. So it depends on in this case perhaps what the conviction was. There's then a sort of a table setting out factors that would be considered as low threat. One of those would be if the offence was committed during the exploitation, for example. So if it was a criminal offence in terms of cannabis farm or other sort of criminal conduct like that, if that was part of the exploitation, then that would be deemed as a low threat, but not necessarily on its own. So there's quite prescriptive guidance. And I would start with that, comparing what the notice sets out with that guidance. Is it enough? And then submit all the evidence that they can collate to argue why it shouldn't be counted against them and why they should nonetheless benefit from the protections. So I think that's all that we could say at this stage. Look at the guidance, see how it can apply to your client's case.
Oh, thanks very much, Sarah. Oh, now here's an interesting one for Mr. Munira. My question is very important for a lot of members of the fraternity. A lot of members of the fraternity are talking about self-sponsoring as a worker in a company. They can be directors and have sponsor license. Can you please clarify if anyone can start a company, get the sponsor license by appointing a British national in company, and self-sponsor and get the sponsor worker visa in the company they are directors? This looks like the expansion worker route, but somewhat garbled.
Yeah, sort of, yeah. That's right, in the sense that on the face of it, it's more like the expansion, because there isn't really a base already operating as a company here in the UK to fit that example. So it seems, it seemed that the sort of self-sponsored concept in terms of visa is doing the rounds, I think, in terms of advice and blog posts on the internet and so on. But it is within the, as far as I can tell, I've got no own professional experience, my own experience, I haven't dealt with cases like that. But it seems to be effectively sort of operating a bit of a loophole or a way round the difficulties that are attached with the GBM routes, for example, or skilled worker routes, and kind of operating around that. But it is within the skilled worker route, as far as I understand the example, where basically you'd start a company here in the UK, you'd get a sponsorship license awarded to that company, and then you would effectively sponsor yourself through that company, through your own company in a way. As I said, I've had no experience of it. I think my prediction would be that it's probably going to work for a bit, but then it might get sort of looked at by the Home Office, because it would seem to go round the policy objectives that the Home Office is trying to sort of regulate.
I was thinking, first of all, the Home Office took a dim view of the entrepreneur route, because people were using it in order to settle in the UK, but by means of, not realistic business plans, and they didn't really, start a proper business, but they were hoping to get settlement in the UK. And then when that route was abolished, there was greater interest in the representative of an overseas business. And that, so the Home Office thought, was also being used by people who wanted to settle in the UK. And there was an attempt made by the owner of a business to make his spouse the owner, and then he could come over as the representative, while there was like a proxy owner back home. And they got wise to that and stopped that. And well, I think that's one reason why the sponsorship, why the representative of an overseas business category was also stopped. And now we've got expansion worker with the possibility of the owner of a business appointing himself the authorizing officer, as well as the key contact and the level 1 user, and issuing a COS for himself, coming over to the UK and starting up the business. And then he can move on, he can reassign these other roles like authorizing officer to somebody else, and he can become a skilled worker recruited by the business and gain settlement that way as a skilled worker.
So it'll be interesting. I mean, I think it's just a consequence of on one hand routes restricting, on the other hand sponsorship license applications increasing. So I think let's see.
Yes. Now let's move on. There are a few more questions, I think. Now, Mr. O'Connell, an applicant was granted pre-settled status as an adult dependent family member. Subsequent application after 5 years was refused because he now works and is no longer a dependent on his mother. What is the prospect of a successful appeal? Now, is it the case that if you are granted pre-settled status as a dependent, you have to remain dependent until the time comes to, well, still apply for rather than automatically acquire settled status? I thought all you needed was residence in the UK for 5 years, and there was no longer any question about having to work or continue exercising treaty rights if you're a European citizen. You qualify on the basis of residence. Is that right?
Is this remnant of our asking Samina, our colleague Charlotte's case. You're on mute. You're on mute.
Well, it seems, well,
Yeah.
the person has got pre-settled status as an adult dependent, so presumably a parent, an adult dependent family member.
Yeah.
And can that?
Well, it could be a child who's over 20. Could be an adult child, couldn't it?
Oh, it could be, yes, who's now over 21 and has to be dependent. Oh, well, it says was granted pre-settled status as an adult dependent. So that suggests that the person was already over 21 if it was a child, but could prove dependency.
So it's tricky. I mean, I think it depends on the category that that they qualified under previously. But we just mentioned, so our colleague Charlotte Bayati has a judicial review pending for children. It's effectively the broad category of children over 21. I can't quite remember the details, Samina might, but I think this client had a residence card as a child under 21.
She came under 21 and then was over 21, married, then became dependent back again on her parents. And so then was applying, but they said you were no longer dependent, or you were unable to show your dependency, or you'd have to show your dependency throughout. So I think that's pending because she didn't have to show the dependency before she was under 21. So why now, when she's completed the 5-year residence? So it's on the basis of the residence, as you were saying. But I think there's also the point here that under the regulations, they used to, I think there was a spate of cases, and I can't remember what it's called, but I think it did go up to the European courts, where you had an adult dependent relative. They then come here, and because the circumstances have changed, they are able to get employment. They weren't in their home country and they were employed, but it didn't take away, or they shouldn't have to demonstrate dependency through the 5 years. They for that particular category. So I don't know I can't remember what the name of that case is, but I wonder whether those kind of arguments could be used under the EUS Appendix EU.
Yes. There was an old case, I think it was Hugo's story, Dauhu, that says that you have to be either dependent or a member of the household before you come to the UK.
Yeah.
And after you come to the UK, you must continue to be either dependent or a member of the household, but you could pick and mix between those two different categories. But what would happen then if, having then got your residence card in the UK as a dependent family member or extended family member, you came up to the 5-year point of residence in the UK, would you still have to be dependent then? Or could you have in the meantime become independent by getting a job or moving out of the house with your sponsor, from your sponsor?
Well, I think that we'll probably see that, we'll see those cases come up. I mean, I think there's two, if it's extended family members, it is more onerous in terms of showing the continuity of dependency and so on. But for children, whether over or under 21, for parents, direct family members is arguably not those same requirements in terms of continuity and stuff. So, but I think both categories, will be litigated, I would have thought.
Oh, so it's not so different from the 2016 regulations in terms of continuing dependency. Okay. I was thinking, well, I suppose with the no longer for the actual European citizens, EU citizens, when applying for pre-settled status, they didn't have to show that they were exercising treaty rights. They just had to show residence in the UK.
Yeah.
But the non-European family members still have to show dependency on their sponsor.
Yeah, I think it's only in certain categories, and I think again going back to that Home Office guidance would be really helpful to kind of wean out exactly which one and what circumstances and what you would need to demonstrate with reference to dependency.
Oh, well, interesting. So litigation looming. Okay. Well, now we have a question from Mr. Butt, and he says, "Hi, Sarah Pinder, an excellent presentation, as always." Yes, indeed. I wonder if you can comment on the following quick bits. Youth mobility visa holder. Is it possible for the youth mobility holder to switch in country to the skilled worker category anytime before the expiry of his existing youth mobility visa? I think that's an easy one.
I think you can, right?
Mm-hmm.
Yeah, so
Yes.
so Mr. Butt's been very courteous in introducing his 3 questions, so I think that'll be the rationale for his compliment to me. But no, I think that's right. And thank you for the question, because it did cause me to look at the slides. I think there's a typo in my slide about switching, so if I can alert everyone to that, because all the categories that I listed, visitors, outside the rules, parent of a child, it's as long as you haven't held or last been granted that status, right? It reads the other way currently. And so I just quickly checked that, and yeah, youth mobility is not in there. So because I think it used to be a category where you couldn't switch into anything else.
I think generally the temporary work categories, T5, you couldn't switch at the end of your 1 or 2 years. You had to go back and apply for entry clearance. But now you can switch. I think that's
changed, through the relaxations post-Brexit and so on, that's changed. So absolutely, I think you can switch,
Well, there are 2 more questions. Re the sponsor management system and the role of a lawyer. What's the best role lawyers should undertake? Key contact, level 1 user, to introduce themselves to the UKVI, and at what stage of the sponsor license application should they come in?
So check the guidance. It's quite prescriptive again in terms of what a legal rep can and can't do. Our reading, or certainly my reading, I think, is that it's best to avoid any role and just to be there as the legal rep, to be there as the advisor. So you can introduce yourself to UKVA as such. You can submit, you can submit covering letters in support of an application, whatever the case may be. But it's forbidden for you to be an authorizing officer. I can't remember if it's forbidden for the other roles, but it's certainly not advisable. And I have to say, I think it's easier to keep a very clear line in your roles and just say no, not even to share logins, nothing. And because there's so much responsibility needs to be taken by the employer in terms of the online stuff, the compliance stuff, that you blur those lines if you start to assign yourself a specific role, even if you're allowed to do one in particular. So it's best not to do any of them.
Right. No, I think the sponsor license application has actually to be lodged by the authorizing officer rather than a legal representative. So if the rep starts, opens up the account and starts doing the application form himself, and he submits it, that wouldn't be a valid application. It has to be the actual authorizing officer who submits it. Yes.
Yeah.
So yes, so a rather more restricted role for the legal representative. Now there's a third question. Any comments about self-sponsor work visa? Oh, this is similar to the previous query.
I think we covered it in the previous query.
Yes.
No experience myself of it, and I would just be a bit wary at this stage. It seems possible.
Yes. Mr. Butt says a few immigration law colleagues have been marketing this. Yes. So it's a bit dubious. Yes. Okay. Let me just try and get down a bit further if I can. Here we are. We have, this is Mr. Chugtai again. We have a Chelik related appeal where the first tier tribunal allowed the appeal, but the Home Office was granted permission to appeal under the Chelik case. I understand that the Court of Appeal has granted permission. Should we apply for adjournment? Oh, well, we've already been told about that, haven't we? That we should apply for adjournment. And it sounds like the upper tribunal are responding favorably to these requests. So it's worth asking. If you don't ask, you don't get.
Yeah, and I think they're also just adjourning off their own accord from what we've heard. Oh,
well, there you go. So it's very likely your case will be adjourned. Yeah, fair enough. And now there's a question from Mr. Adewoye. I received a decision on an EUSS application that my client put in. My client put in a settled status application after 5 years of Zambrano leave, and it was refused because she could succeed in an application for sole carer of a British child under Appendix FM. Thereby, she does not meet the provisions of Appendix EU because her absence will not require the child to leave the United Kingdom, because she could remain under another category of leave. I find the decision strange. Please, can you comment on this?
Isn't this the Supreme Court's decision in Akinsanya, which says you don't have to, it doesn't matter that you've had leave in another category or Appendix 7. You don't have to have had it in a different category. I think it's worth looking at that case, and I can the facts of that case.
Yes. Yeah. Well, when it started in the High Court, it was very cut and dried that applicants for Zambrano leave didn't require to apply for Appendix FM at all, or if they had it already, it didn't. They didn't have to have applied and been refused in order to be eligible for Zambrano leave. And then when it went up to the Court of Appeal, that seemed to muddy the water and came to a different view.
Yeah, I think they overturned some of the declarations. I can't quite remember because it was quite complex. But what it resulted in was a window. The Home Office, I think, opened a window for Zambrano carers to make an application under EUSS. I think they amended the rules.
Oh, yes.
Sort of
yes.
Opened
that's
a
a category,
by
isn't
which
it?
you had to apply.
Mm-hmm.
But it does all stem from the derivative right stems from it being a sort of last resort status. So if you the logic being if you qualify in other ways, then you shouldn't get the derivative rights. But yeah, it's we could do a whole talk on that.
Yes.
And still get confused in my head anyway.
Yes.
So
Yes. Now, Mr. Adewoye might be puzzled at the fact that his client got pre-settled status as a Zambrano carer, but then after 5 years, she's told, oh, you ought to apply for leave to remain under Appendix FM now, rather than being granted settled status.
I think there's a lot of challenges to those who were granted pre-settled and then not granted settled for various reasons. But I think he should really continue in that category. It sounds almost like an unlawful decision not to follow through with the same set of rules. They haven't said. I mean, I think they're still waiting to redraft those rules as well, or the guidance in relation to Zambrano following Akinsanya.
Yeah, we've really got a long way to go before all the EU settlement scheme problems get ironed out. Now, we've got another question from Mr. Butt, and he says, for all the excellent panelists, please forgive me for asking out of topic questions. Oh, I'm sure we can forgive you. Is it possible to submit a British registration application, form T, is it TI or TJ? TI, for a minor?
T with bracket.
Oh, form T, you're right, yes, form T, for a minor
No, I'm
based
struggling.
on completing 10 continuous years, having been born in the UK 28 days before completing 10 years? Or does it have to be made after the whole of the 10 years have been completed? I think when you're applying for indefinite leave, you can apply before you've resided here for 10 years or the whole 5 years or whatever, provided by the time the application is decided, you've clocked up the full amount.
You can for immigration, yeah. I can't remember for nationality. Naturalization, whether you can apply 28 days before, I don't know.
Yes.
The guidance will say.
Yes, indeed. Yeah, if in doubt, go to the guidance. Okay. Well, yeah, there we are. We can't say for sure, but it seems unlikely that your application would be rejected as invalid or something before, because when it's received, the full 10 years haven't been completed. But we don't know for sure. So now Tier 2 dependent visa extension. What's earlier? A Tier 2 points-based system dependent partner can apply for Tier 2 visa extension prior to the expiry of his existing Tier 2 visa. Is that at any time, or must it be within 28 days of the visa expiry? UK VI guidance doesn't help much. So he's here with leave as a dependent under Tier 2, and he wants to extend his leave before that existing leave expires. And can he do that any time, or must he wait until 28 days of his current visa expiring?
Just thinking through logically, I think people can apply anytime during the leave if they wanted to switch or anything, as long as they've got extant leave.
Yes.
But I think it has consequences for the 3C issues and things like that. So that's why it's always the 28 days.
Yeah, I think that's right. Because of course, if you apply well before your leave expires and the application is refused, your existing leave is not extended by Section 3C because you still had leave when the decision was refused. So your leave hasn't been extended. So it means you have much less time of lawful residence. Yeah. So basically the advice is wait until it's the 28 days before the visa expires. Okay, now brief background. I missed this out, sorry. The applicant's Tier 2 sponsor had been settled, but he couldn't, the applicant couldn't, due to not meeting minimum UK residence requirements. His current dependence visa is expiring in July this year, but he wishes to apply for Tier 2 dependent extension now. He has valid reasons to do so. Is he eligible to apply for an extension now, around 5 months earlier than the same visa expiry? We've maybe covered that already.
Yeah, I mean, I think it depends on the circumstances. I mean, I don't think there's anything to say that you can't be granted an extension when you've got X amount of leave left, which might be over 28 days. I mean, it used to be that you wouldn't get a right of appeal either. So if you had extant leave by the time they decided and they refused, you wouldn't get a right of appeal, but you've got no right of appeals in these cases anyway.
Anyway.
So it's kind of become less of an issue, and I don't think they could refuse because he's got extant leave. I suppose the only other consideration would be about the tier 2 main applicants. So you know, if it was so far in advance of the tier 2 main applicants leave being renewed, then they would get out in line. So it's hard to advise I think in the ether, sort of in theory. Yes. But would, you know, if they've got a case as to why they need to apply early and it's doable in relation to the main applicant, then I mean, what do they risk? They risk making an application with a fee and potentially losing some of that fee. But if they weren't granted, they'd have some of the fee refunded, I think, wouldn't they? So it'd be a question of whether they want to try or not.
Yes. And well, it would be an application for a sponsor worker leave, sorry, a skilled worker leave as a skilled workers dependent rather than a tier 2 dependent.
Just wonder, I wonder if we're out of time now.
Oh,
I have to check for time.
Oh yes, it's nearly 4:30. Yeah, maybe we ought to just stop now. I think the next question is a bit complicated.
Well, then let's stop now.
yes, I think we better had. We've given it a good go. Right.
And Mr. Manura has asked a question already. Sorry, Mr. Manura. One only.
Okay. Well, thank you very much to the panel members for giving up a lot more of their time for answering these questions. And thank you all three, Sarah, Samina, and Sonia. Gosh, 3 ladies whose names all start with S.
Oh,
so,
yeah.
a strange coincidence.
Yeah.
But thank you very much for your talks today and your contributions to this question and answer session. And now I think there will be a mass exit from this webinar, because we've only got one more talk to go, and that's from me. So I shall be very surprised if more than a handful are still here at the end of the webinar. But for those of you who hang on, well, I hope it's worth it. And thank you again, Sarah, Samina, and Sonia.
Thank you,
Thank
Richard.
you, Richard, for sharing.
Bye.
Thank you.
Thank you.
Oh, and we've got thanks from AstenJ to everyone, to all our speakers. So thank you, Lasanta. Okay. Well, a few brave souls are hanging on, so I'll just lodge straight into the final case, and I'll try and romp through it at a good rate. Now, it's mostly about nationality, and there are a couple of quirky cases. So the first one is definitely quirky, Murugeson, and it involves a bit of history, because it starts at a time when Penang, an island off the coast of Malaya, was a British colony. And so people born there were initially British subjects, but with the passage of the, with the coming into force of the British Nationality Act on the 1st of January 1949, the British subjects became citizens of the United Kingdom and Colonies, or CUKES, as we call them for short. Now, the applicant's father became a CUKE, and actually, when the applicant himself was born, well, actually, he was born on the very last day of 1948, and he also became a CUKE on the 1st of January 1949, because his father was a CUKE, and he was also born in the British colony. So in 1957, Malaya became independent. In fact, it was expanded as Malaysia. Penang was part of that, but for some reason, the CUKES of Penang retained their CUKE status and didn't just become citizens of Malaysia. But there was a big change in the status of CUKES with the passage of the Immigration Act 1971, because that created a distinction between patrial cukes and non-patrial cukes. So the patrial cukes were the ones who had been born, adopted, naturalized, or registered in the United Kingdom. And the cukes who hadn't been, didn't have that connection with the UK, did not achieve patrial status. Now, this mattered when the nationality sections of the 1971 Act were amended after the passage of the British Nationality Act 1981, and that created for the first time the status of a British citizen. So the cukes who were patrial became British citizens. The ones who were not became British overseas citizens or British dependent territories citizens, but not full British citizens with a right of abode. Because the right of abode, that was created by the 1971 Act, and it continues to the present day. Most people who have it are British citizens, but there remains a cohort of Commonwealth citizens from other countries who nevertheless have a right of abode in the United Kingdom. Now, at issue in this judicial review case at the High Court, Murugeson, the applicant had the benefit of Zayn Malik KC as his representative, and it turned on the interpretation of Section 2 of the 1971 Act as originally enacted. And that read, a person is under this Act to have the right of abode in the United Kingdom if he is a citizen of the United Kingdom and colonies, born to or legally adopted by a parent who had that citizenship at the time of the birth or adoption, and the parent either then had that citizenship by his birth, comma, adoption, comma, naturalization, or, without a comma, registration in the United Kingdom. Okay, so the applicant's father, did he have the right of abode because he had citizenship of the United Kingdom and colonies by virtue of being born, adopted, naturalized, query, or registered in the United Kingdom or in any of the islands? And what Zayn Malik argued was that it was only those who had been registered in the United Kingdom. It was only in respect of registration that your parent had to have been registered in the United Kingdom in order for you, the child, to be a British citizen. So if you hived off registration in the United Kingdom as a separate category, which didn't affect people who had citizenship from their parent by virtue of birth, adoption, or naturalization, then the applicant could be a British citizen because he was born to a father who was a citizen of the UK and colonies. And basically, the decision turned on the absence of a comma between naturalization or registration, because the sentence runs, the person then had that citizenship by his birth, adoption, naturalization, or registration in the United Kingdom. So in the United Kingdom would qualify all of those different categories. And the judge held that it would only be otherwise if there had been a comma between naturalization or registration, meaning that or registration in the United Kingdom could be interpreted as a separate cohort from those who were citizens by birth, adoption, or naturalization. So a rare instance of the Oxford comma or lack of it being crucial to the interpretation of a statute. It's very quirky, and there's been some controversy in the newspapers about Oxford commas. Jacob Rees-Mogg has banned them or from civil servants in his department. He's no longer the head of a department, but he banned the Oxford comma, which is what you place before and in a series. You shouldn't really put a comma if you have a series like John, Paul, Mary, Richard, and Tom. You shouldn't put a comma between Richard and Tom. You should just leave it just and connecting the last two words. If you put a comma there, that's an Oxford comma, which is frowned on. So there you are. You were hoping to learn something about naturalization. You haven't learned much, I'm afraid. What about the next case, Muslia, which is about deprivation of citizenship and about whether it's necessary for the tribunal, when determining an appeal against deprivation of British citizenship, whether it's necessary for them to essentially make a prediction about the consequences of the deprivation, because deprivation isn't necessarily followed by removal or deportation. There's a two-stage process. So to take a typical example, if somebody has gained British citizenship through naturalization, having made a bogus asylum claim, been recognized as a refugee, acquired indefinite leave, and in due course citizenship, and then it comes to light that this person was pretending to have a different nationality than his real nationality. The commonest instance is Albanians who pretended to be from Kosovo. And of course, speaking the same language, it was quite easy for them to do that. So under the guise of being Kosovan refugees, they got asylum and eventually citizenship. Then after a while, they got married to an Albanian woman. It's happened a few times. And she applied for entry clearance. And when filling in the application form, she or her representative put down that her husband was born in Tirana or somewhere else in Albania. And thus it came to light that the husband was never a citizen of Kosovo in the first place. So the Home Office then takes steps to deprive the husband of his British citizenship. Well, when the first tier tribunal, and then if there's an appeal, the upper tribunal, come to decide whether that person should be deprived of his citizenship or whether they disagree with the Secretary of State and allow his appeal, to what extent should they consider what's likely to happen if in fact his citizenship is removed? Because there then is the possibility either of being allowed to stay, given some other form of leave to remain, or indeed being removed. And so the consequences to the rest of the family of his removal or deportation, or even the consequences of a limbo period in between the final decision to deprive him of citizenship and the subsequent decision whether or not to let him stay or to actually remove him. Now, during the limbo period, he wouldn't be allowed to work or claim benefits, so there could be obvious economic problems for him and his family. And then if he actually is going to be removed, there's the prospect of family breakup. Now, to what extent does the tribunal have to take that into account? Well, I won't trawl through the whole of this because it's a bit complicated, but we finish off with a decision by Mr. Justice Lane, President of the Upper Tribunal, in a case called Tsitseri. It's in bold, the year 2021. Tsitseri. And it says, the tribunal must determine the reasonably foreseeable consequences of deprivation, but it will not be necessary or appropriate for the tribunal, at least in the usual case, to conduct a proleptic assessment of the likelihood of the appellant being lawfully removed from the United Kingdom. Now, one of the contributors to the Free Movement blog wrote a review of this case and admitted he'd never heard of proleptic before. And in fact, you would have to be as old as me probably to have been taught about it. It's one of the figures of speech that children used to be taught back in the 1960s. And prolepsis was one of them. And it means imagining or talking about something that has already, as if it has already happened, when in fact it hasn't happened yet, but you expect it will happen. And the advice given by Lord Justice Sales, who's now Lord Sales in the Supreme Court, set out two propositions, saying, on the one hand, the reasonably foreseeable consequences of deprivation are relevant to an assessment of the proportionality of the decision. And then he says, on the other hand, judges should usually avoid proleptic analyses of the reasonably foreseeable consequences. An overly anticipatory analysis will be founded on speculation. So you have two rather contradictory pieces of guidance there from the Court of Appeal. Anyway, I'll move on to another nationality case, which is another judicial review claim on the application of Alayan and al-Jumaili, or Jumaili. And this concentrates on the good character requirement. Now, people are often refused on good character grounds, for example, because when filling out their application form for British citizenship, they have answered no to the question, have you ever been convicted of a criminal offence, brackets, including a motoring offence? And it may then turn out, when the Home Office check the, national computer, police national computer, that the applicant did get fined in the magistrate's court for a motoring offence. But he thought it was such a minor offence, he didn't go to prison, it was just a fine, that he answers no to that question in the application form. And back comes the refusal letter saying, we have checked, we found that you answered you gave a false answer to this question. You failed the good character test. You've practiced deception. Don't bother applying again for another 10 years. And by the way, we'll keep your application fee. So not a good idea to give an incorrect answer to a question like that in the application form. But you can also be considered not to be of good character because of something that you did before you ever came to the United Kingdom and before you achieved indefinite leave to remain, which of course you have to have done before you apply for citizenship. So here we had a married couple from Iraq who had come to the UK as refugees, having previously been members of the Ba'ath Party in Iraq and having risen through the ranks of the Ba'ath Party, but then having fled the country and come to the UK. Now, they got refugee status and indefinite leave to remain. So they thought, once they'd lived here for long enough, 1 year after having got the indefinite leave, they would be pretty safe applying for citizenship, but they weren't because of their previous involvement with the Ba'ath Party. Now, you might have thought that the fact that they were recognized as refugees and granted indefinite leave would have satisfied the good character test, but it didn't. So it's possible for you to get that far on the road to citizenship only to fall at the last hurdle, because membership of the Ba'ath Party and support for Saddam Hussein's brutal regime would be sufficient to actually disbar you. And there's a case called Tambi, which says it may be sufficient that the applicant has, by his support for the organization and with an appreciation of its willingness to use barbaric methods, gone so far as to show that he is prepared to ally himself with it in a way which reveals a marked lack of commitment to the values underpinning British society. So even if you have never participated in any acts contrary to the principles of the United Nations, you haven't, killed or tortured anybody, but if you've actually supported an organization which does these things, or you have supported such an organization rather in the past, you could fail the good character test. And then finally, on nationality, I come to a case which Kezia Tobin talked about earlier on this morning, called Rurig. And this is the case about the children of European citizens who were living and exercising treaty rights in the UK before October 2000, when the first of the EEA regulations came in. And at that time, the Home Office were regarding European citizens who were exercising treaty rights in the UK as being settled in the UK, so that children born to them would be British citizens by birth, being born to somebody with what we now call settled status, indefinite leave to remain, because they were not restricted in the time that they could stay in the UK, and they were ordinarily resident. So the definition of settled in the 1971 Act is that you are ordinarily resident in the United Kingdom without any time limit on your stay. Okay, so that is settled, the definition of settled. But subsequently, in fact, a lot subsequently, another tribunal case called Caparelli, presided over by Mr. Justice McCluskey, the president at that time, held that European citizens who were exercising treaty rights were not completely free of any time limit, because their right to be in the UK depended upon their continuing to exercise treaty rights. And if they stopped exercising treaty rights, they would lose their entitlement to be in the UK. So it wasn't completely free of any time restrictions. And well, I think Kezia was making out that thousands of people who were born in the UK at a time when it was thought they were British by birth could now find themselves being deprived of British citizenship. I don't think that's going to happen. I think the Home Office will just do nothing, and it's a storm in a teacup, because if the Home Office did start depriving thousands of perfectly well-behaved citizens because of something that happened 30 or 40 years ago when they were born, it would cause a huge outcry, and the Home Office aren't going to do that. But it's a curiosity, isn't it? What I am going to finish with, though, is something which is probably a bit more useful. So if you'll bear with me, I'll spend a bit more time on the Chikwamba principle, which is the final few pages of my talk on the brochure, if you've got that in front of you. Now, Sonia has already said quite a bit about Chikwamba, so I won't say too much about the Alam case, which has cast a shadow over the ability of representatives to rely upon Chikwamba, because certainly until very recently, colleagues of mine have been happily citing Chikwamba for the principle that people shouldn't be expected to go back to their own country and apply for entry clearance if they're going to be granted entry clearance anyway when they go there. Why put them to all that trouble and expense? And Lady Justice Elizabeth Lang in Alam and Rahman rather poo-pooed that, saying that Chikwamba itself was a special case and it really didn't enunciate a general principle in the way that people have been treating it. Because in the circumstances of Chikwamba, there was a lady who was from Zimbabwe. Her husband was recognized as a refugee in this country, also from Zimbabwe, and he had indefinite leave as a refugee. And the daughter that he had with the appellant was British, and she was faced with a choice. She'd been refused leave to remain as a spouse. She was faced with a choice of going back to Zimbabwe with her daughter, because really the daughter was too young to be looked after by the father. So she was faced with the choice of going back to Zimbabwe with her daughter to apply for entry clearance, or else leaving the daughter behind in the UK. And the daughter was really too young to be deprived of her mother at that stage. So anyway, Lord Brown of Eton under Haywood said that it really was disproportionate to expect the mother to make that difficult choice, when in fact she would qualify under the rules to come back with a spouse visa. There was no question about the genuineness of the relationship or of the maintenance and accommodation and all that stuff. I mean, this was well before Appendix FM and the maintenance requirement of £18,600 and all the rest of it. It would have been much easier to get a visa to come back as a spouse. So why put her up to all that trouble and distress, and indeed her infant daughter? So anyway, Lady Justice Lang points out that Chikwamba really was rather a special and unusual case and doesn't found a more general principle. She also looks at three leading cases in the Supreme Court, Hesham Ali, Ajarko, and Rupiah. And it's just interesting to see in those cases the origins of some of the phrases that we're very familiar with from Appendix FM. So it was Lord Reid in Ajarko who reminded us that insurmountable obstacles is a phrase taken from the Strasbourg jurisprudence, and he himself put the gloss upon it about insurmountable obstacles meaning very serious difficulties which could not be overcome or which would entail very serious hardship. And that's the gloss in EX.2 of Appendix FM. And then he also goes on to talk about exceptional circumstances which would produce unjustifiably harsh results which would make removal disproportionate. And that's the origin of Gen. 3.2 of Appendix FM, which talks about exceptional circumstances and the unjustifiably harsh consequences to the applicant and the members of his family, where you're looking at what used to be called Article 8 outside the rules. Well, here we have, among the various cases surveyed by Lady Justice Elizabeth Lang, we have an upper tribunal case presided over by Mr. Justice Lane in 2020 called Eunice, and it was singled out for praise at the Court of Appeal, and it might be useful to just have a closer look at that particular case, although it's an upper tribunal case, no higher than that, but it's a presidential panel, and I think it's quite useful. So here we had a case where there was a mother who had come in on a visit visa and overstayed. She had a British daughter, and it was conceded by the Home Office that there would be insurmountable obstacles to family life with her partner continuing outside the United Kingdom. So her own representative thought that they were home and dry, and because of this concession, she satisfied the requirements of EX.1b. And it was pointed out, a case which people like to quote, TZ Pakistan and PG India, where the senior president of tribunals said that where a person satisfies the rules, this will be positively determinative of that person's Article 8 appeal. However, they had not counted in the fact that the appellant had come from Pakistan on a visit visa. She made an in-time application for further leave, and so her existing leave was extended by Section 3C, and that extension goes on until your appeal is finally determined. And it's the leave which you already had. It's not a different form of leave. So if you have existing leave to enter as a visitor and you make an in-time application for further leave and that's refused, your leave continues until such time as any appeal rights have been exhausted. Now, you can make a you can appeal, but you can't switch. You can't switch from anything else to be, if you've got leave as a visitor, you can't switch about anything else. So it wasn't possible for her to get leave to remain as a partner under the immigration rules at all. And so she didn't satisfy the rules, despite the fact that it would be unreasonable to expect the child to leave the UK. She couldn't succeed under the rules, having had leave to enter as a visitor, and that leave continuing when she made her when she made her application for further leave. So that meant that they had to look at the partner route instead. And there was some argument about whether she could go back to Pakistan because she had had leave, or she had had permission to reside in the United Arab Emirates. She was of Pakistani nationality, but she'd never lived there. And she was saying that, well, she couldn't go back to Pakistan because in fact she'd never been to Pakistan or not lived there, and she couldn't integrate. But that argument wasn't accepted, because although she'd never lived permanently in Pakistan, she spoke the language, she was of the same religion, and she knew the customs of the country. So she failed under the rules. So what about proportionality under Article 8? And here, the upper tribunal, very much in the same vein as Lady Justice Elizabeth Lang, they say that Chikwamba was a special case. Ajarko doesn't lend much support either to it being a general proposition that you shouldn't be expected to go back and apply for entry clearance. And she cites then with the tribunal cite with approval a remark by Lord Justice Holroyd in a case called Core. The Chikwamba principle will require a fact-specific assessment in each case, will only apply in a very clear case, and even then will not necessarily result in a grant of leave to remain. So the tribunal went on to observe that Chikwamba predates not only Appendix FM, but Part 5 of the 2002 Act, which now requires, I think since 2016, which now requires judges to take into account the public interest. That's in section 117B, subsection 1. The maintenance of effective immigration control is in the public interest, and the judges must always address the public interest when answering the public interest question posed at section 117A, subsection 2. And so judges must go through that checklist in section 117B. And let's just look at what they did here. First of all, was Article 8.1 engaged? It was. The daughter was going to be separated from her father for several months if she went with her mother to apply for entry clearance in Pakistan. Will entry clearance be granted? Well, we were looking at that earlier on, weren't we? Making a proleptic assessment of the chances of getting entry clearance. Well, here, the tribunal reckoned that she probably would get entry clearance. So the answer to that was yes. But was there a public interest in requiring her to apply for entry clearance if she was pretty sure of getting it? And here, the panel found that the appellant's conduct counted against her because basically she lied when she applied for a visit visa. She was all the time intending to stay permanently. She had no real intention of leaving the UK after her visit, so that counted against her. And then finally, was the interference with Article 8 proportionate? There would be an interference under Article 8.1, but was it proportionate under Article 8.2? So the panel then looked at the various requirements of section 117B. So first of all, the maintenance of effective immigration control weighs heavily in favor of removal in a case like this. The appellant's ability to speak English and her financial independence were neutral factors that didn't assist her really following Rupia. Section 117B4 tells us that a private life, or indeed family life, established in the UK while the applicant is here unlawfully doesn't carry much weight. But here, the appellant hadn't been in the UK unlawfully. So that subsection wasn't relevant. What about subsection 5? This says that little weight is to be accorded to a private life established when a person's immigration status is precarious. So if you're in the UK with limited leave, your status is precarious. However, it didn't apply to the appellant's family life. That wasn't precarious because it had been established well before she came to the UK. So she'd been married long before that. So it was only her private life that was precarious. And finally, if it would not be reasonable to expect a child to leave the UK, then there will not be a public interest in removing a parent. So that's usually the strongest card in the parent's suit. If the parent has a child and that child's removal, or it wouldn't be, or rather it wouldn't be reasonable to expect the child to leave the UK when the parent is removed, that means that the parent can stay. However, in this case, the panel found that the child's leaving the UK would be reasonable. Aha, no, why is that? And here we have recourse to the balance sheet approach, which Lord Thomas set out in Hesham. Now, Sonia Ferguson talked about the balance sheet approach in Hesham and how it shouldn't lead to a sort of mechanistic, mechanical approach of awarding points for and against. Although Lord Thomas did talk about weighing up the pros against the cons, but it shouldn't be a purely mechanical exercise. So looking at the real world, the panel found that the absence of mother and daughter from the UK would be no more than 9 months for an application to be made and granted for entry clearance to return, and that in the circumstances of this little girl, it wouldn't be unreasonable. She'd be looked after by her mother. Her mother was steeped in the culture of Pakistan, wouldn't have any problem adapting to life there. The child was too young to have started school, so her education wouldn't be disrupted. All in all, it would not be unreasonable. So, just finishing off, it struck me that it's curious that in recent years, the Home Office have not brought up, when refusing an Article 8 family life claim, that the applicant could go back to his own country and apply for a spouse visa. And if it's a genuine and subsisting marriage and all the rest, that person could come back on a 5-year route to settlement rather than staying in the UK, appealing, and if successful, going on a 10-year route to settlement. Although, of course, there is the possibility that if you do decide to go back to your own country and apply for entry clearance, you could be refused on what used to be paragraph 280(11) of the immigration rules, part 9 of the immigration rules, for contriving to frustrate the intentions of the immigration rules by previously overstaying or breaching conditions, etc. And the equivalent of that is now in 9.8.2 of part 9, which I didn't get to talk about this morning, but it's in the brochure. So there is that risk. But even so, the Home Office are content to rely just on EX.1 A and B and say no insurmountable obstacles to family life between the husband and wife continuing in another country. and they will rely on that instead of saying, well, what's to stop the appellant from going back and applying for entry clearance? I speculated that after this case of UNAS, the Home Office might start relying more on the possibility of applying for entry clearance. And indeed, initially, when the Human Rights Act came into force in the year 2000, the early appeals on family life and human rights focused on this very possibility. In fact, the first Court of Appeal case dealing with Article 8 family life was called Amjad Mahmood, reported in 2001. And in that, the judges in the Court of Appeal, including Lord Justice Laws, very much were of the view that people who were in the UK unlawfully shouldn't be allowed to jump the queue and get leave to remain as a spouse. Rather, they should go back to their own country, join the entry clearance queue, take their turn, and apply for a visa. So that was the view then, but it's faded away since that time. And the effect of UNAS has not been that hoppos routinely ask the immigration judge to dismiss the appeal because the appellant could go back to his own country and apply for entry clearance. They say, no, there are no insurmountable obstacles. The couple can go back, or they can go to the appellant's country and it'll be hunky-dory. So there it is, ladies and gentlemen. You've been very patient sitting through so many talks, and it's well after 5 o'clock. And our original schedule had us finishing at 20 past 4. So, well, I guess if you've stuck it out this long, you must have got your money's worth. Now, I see there are 2 questions in the chat box, so let me just see what they are. Oh, many thanks for our speakers for excellent presentations. Oh, this is from Wasanta, who runs AstenJ. And here's one from Sarah. Thank you for having us. I have to leave now to pick up the kids. Well, I don't, but I'm going to leave and you'll be relieved about that. So I won't keep you any longer, ladies and gentlemen. Thank you very much for sticking it out this long. And I hope that you'll come to a future webinar. And oh, a direct message to me. Thank you. Oh, well, thank you very much. So goodbye to you. Oh, fortunately, I haven't started coughing until now. I've got a cold, but fortunately it didn't affect me too much. So thank you all and all the best. Bye-bye.